Court officer, madam. Hello, court officer, madam.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಸಾಹೇಬ್ರು ಎಷ್ಟೊತ್ತಿಗೆ ಬರ್ತಾರೆ ಅಂತ ಐಡಿಯಾ ಇದೆಯಾ ಮ್ಯಾಮ್?
ಬರ್ತಾರೆ ಸರ್ ಇನ್ನೊಂದು 2 minutes.
ಅಲ್ಲ ನಿನ್ನೆ ಸ್ವಲ್ಪ ಬೇಗ ಬಂದಿದ್ರು, ಅದಕ್ಕೆ ಇವತ್ತೇನಾದ್ರು ಡಿಲೇ ಏನಾದ್ರು ಇದೆಯಾ ಅಂತ ಗೊತ್ತಾಗಬೇಕಿತ್ತು ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು.
ನಿನ್ನೆ 10 AM ಅಂತ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ ಸರ್, ಸಿಟ್ಟಿಂಗ್ ಆನ್ 10 AM ಅಂತ ಹೇಳಿ.
ಎಸ್ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
My lord, one matter for 230, my lord. One matter for general memos ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
Direct check to be the amount of payment. It should be for account 3 to 5. They are the custodian of the amount and also project is with them. So number 1 and 2 are not.
ಆಯ್ತು ನೋಡೋಣ ಕೊಡಿ.
One matter
ನಾಳೆ give all the memos, my lord.
Your lordships, kindly, my lord.
Direction only to respond over 3 to 5, my lord, not 1 and 2, because 3 to 5 are handling the project. Please, 3 to 5. One matter for tomorrow.
My lord, 230 matter, my lord. Suspension order under challenge, my lord. Very all other memos you give, except 230 ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lord, this is a Bengaluru bench matter, my lord. My lord, I'm the absolute owner of the land and third party rights are being created.
Why parted ಆಗಿದೆಯಾ?
My lord?
Is it parted before me?
Yes, my lord. My lord, if it may be listed tomorrow, we have come all the way from Bengaluru. It was supposed to be.
All the way from Bengaluru.
Yes, oh. There's urgency, my lord.
Okay, give it.
One no confidence.
My lord, on
No confidence matter, my lord, for tomorrow. I appear for response.
tomorrow ಅದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Notice ಕೊಟ್ಟಿಲ್ಲ. I have no objections to allow the writ petition.
ಅದು ಕೊಡಿ. ನಾಳೆಗೆ ಏನೇನಿದೆ ಎಲ್ಲ ಕೊಡಿ.
My lord, Bangalore matter, my lord. VC ನಲ್ಲಿ ನಂದು
ಆಯ್ತಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
ಅಲ್ಲ VC ನಲ್ಲಿ ಡಿಸ್ಕನೆಕ್ಟ್. ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್, ನನಗೆ ಅವತ್ತು ಸಂಜೆ 8 ಗಂಟೆಗೆ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಗೊತ್ತಾಯ್ತು. ನನಗೆ ಟ್ರೈನ್ ಟಿಕೆಟ್ ಸಿಕ್ಲಿಲ್ಲ. ಮತ್ತೆ ನನಗೆ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ನನಗೆ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು. ಇವತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಒಂದು ಪಾರ್ಟ್ಲಿ ಹರ್ಡ್ ಅದನ್ನ ಒಂಚೂರು ನಾನು ಹಿಯರ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ. ನಾನು ಪೆಟಿಷನ್
ಯಾವತ್ತು ಬೇಕು ನಿಮ್ಗೆ?
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟರು ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ. ಪೋಸ್ಟೆಡ್ ಫಾರ್
ನಾಳೆ ಹಾಕೋಣ ಬಿಡಿ. ಗೊತ್ತು,
ದಯವಿಟ್ಟು ಸ್ವಾಮಿ
ನಾಳೆ ಹಾಕಿ.
ನಾಳೆ
ಆಯ್ತು, ಏನ್ ಬೇಜಾರೇನಿಲ್ಲ, ನೀವು ಮಾಡಿ ಎಷ್ಟು ಬೇಕು. ಆಯ್ತು,
ರೆಡಿ ಇದೀನಿ ಸರ್,
ತೊಂದ್ರೆ ಇಲ್ಲ.
230
ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ.
From serial number 57 onwards, notes KB general matters are listed. It's a similar matter. It can be heard along with that at 230 matter. So
ಕೊಡಿ. 230 ಯಾಕೆ 230 ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Please, your lordship.
ನಿಜವಾಗ್ಲೂ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ
Your lordship, matter is your lordship.
I will not ask what are the facts.
There is urgency.
If this real urgency, give it. If there is no urgency, it will be adjourned by 8 weeks. Give it.
So the lordships, kindly not mentioning for 230.
One moment. We see 1 minute, sir.
Please, please.
Give all the 230 memos. ಅದು ನಾಳೆ ನೋಡಿದ್ದು ಯಾವಾಗ ಬರುತ್ತೆ ಕೊಡಿ. Otherwise, all 230 memos you give.
serial number 117
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Election matter, connected matter ಅದ್ರ ಜೊತೆ 230.
ಆಯ್ತು ನೋಡೋಣ.
Kindly not mentioning.
ನಾಳೆಗೆ
ಅಲ್ಲಿ ಆನ್ ದಿ VC ಪ್ಲೀಸ್ ಸ್ವಿಚ್ ಆಫ್ ಯುವರ್ ಮೊಬೈಲ್ಸ್, ಅದರ್ವೈಸ್ ಇಟ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಟು, ಏನು ಕೇಳಿಸೋದೇ ಇಲ್ಲ ಇಲ್ಲಿ. ಎಸ್ ಟೆಲ್
Your
ಮಿ.
lordships, kindly not mentioning for 230.
ವಿಚ್ ಒನ್?
Not the urgency is not my Jaggery unit has been ordered to be closed down today, my lord, at 11 AM.
ವಿಟ್ ಸರ್. ಯಾರು ಯಾಕೆ ಅವ್ರ ಕೈಲಿ ಹೇಳಿಸ್ತೀರಾ? ಇಲ್ಲಿ ಇಲ್ವಾ ನೀವು? ಕುಡಿ. ಎಸ್.
One matter, I think 230, my lord's memo is already given. I
ಕುಡಿ ಸರ್, whatever 230, who is here to give a memo?
Sir,
My lord, Ganapati Bhatt. 230.
Don't make a mention, yes.
to order of attachment, my lord. To order of attachment. Wife filed a petition, my lord.
Your
because-
husband?
Yes, my lord, already.
You are not attached?
Yes, 30% amount have been, your lordship deposited. Adru ಮತ್ತೆ in view of Tahsildar, your lordship is going to attest the property, my lord. For that aspect, 230, my lord.
ನಾಳೆ.
Notice issue ಮಾಡಿದಾನೆ.
ನಾಳೆ.
ಆಯ್ತು.
ಹಸ್ಬೆಂಡ್ ಅಲ್ವಾ ನಾಳೆ?
ಹೌದು.
Thank you, sir. Whatever. Yes, call the case.
Serial number 1, 14% Ravichandra Gowda.
There is one mistake, court's order. No, there is one mistake about the amount in the end. 8 weeks ಅಲ್ಲಿ refund ಮಾಡಬೇಕು, ಟೈಮ್ ಬಿಟ್ಟೋಗಿದೆ, ಅದನ್ನ ಹಾಕ್ತೀನಿ ಅಷ್ಟೇ.
Yes, yes.
For that purpose I have posted it.
My lords, cost was imposed of 25,000, that is also missing.
No, cost was imposed,
Yes,
no?
if they not comply with the directions of refund within.
If it is not complied, that I will
That
add.
aspect is missing.
Tell Archana Magdum, madam.
Yes, I will inform.
Yes. The subject petition was disposed by an order dated 3/11/2025. Out of inadvertence, a typographical omission has been crept in with regard to the compliance. With regard to compliance, and in the event it would not be complied, the adu helidna adanna.
Yes, madam.
Cost of rupees 25,000 would be imposed in the event it would not be refunded within 3 weeks from the date of receipt of the copy of the order. The said omission is to be included in the order. The certified copy of the order, a fresh certified copy of the order be issued to the petitioner. Yes.
Number 2, Sriharshi Nilopan, dear Lord Khan.
ಇದ್ಯಾಕೆ?
My lord, only writ of mandamus was issued, my lord. Due to
ಏನ್
the-
ಬೇಕು ನಿಮ್ಗೆ?
ಅಲ್ಲ, ಕ್ವಾಶನ್ ಕೇಳಿದ್ದಾರೆ, 54 ಎಂಕ್ವೈರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿದಾವೆ.
ಒಂದ್ ನಿಮಿಷ.
My lord, in the land tribunal order, land tribunal has granted.
You are the one who said it is covered by coordinate bench judgment. All
My
right?
lord, there are 2 covered decision, page number 90.
Which you said it is covered ಅಷ್ಟೇ.
My lord, annexure has to be cost, my lord.
Delete the name of the
Writ-
Sonekar. ಇದು ಕ್ವಾಶ್ ಆಗ್ಬೇಕು.
ಅಲ್ಲ, ಕ್ವಾಶ್ ಆಗಿದ್ದು
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲೌಡ್ ಅಂದ್ರೆ ಕ್ವಾಶ್ ಆಗ್ಬೇಕು. ನಥಿಂಗ್.
ಅಲ್ಲ ಒಂದು ಸಬ್ಮಿಷನ್
ಏನು?
ಅಲ್ಲ,
ನಂಬರ್ 11 ಅಲ್ಲಿ ವರ್ಕ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ
ಅದು ನಮ್ ಗ್ರೀವೆನ್ಸ್ ಇಲ್ಲ. ಅಲ್ಲ, ನನ್ ಗ್ರೀವೆನ್ಸ್ ಇಲ್ಲ.
ಮತ್ತೆ
ಅಲ್ಲ, ವಾಟ್ ದೇ ಆರ್ ನೌ ಸೀಕಿಂಗ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದ ಎಂಕ್ವೈರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ 54 ಕ್ವಾಶ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
ಅದನ್ನು
ಇಲ್ಲ, ಅದಕ್ಕೆ
Annexure has to be.
ಅನೆಕ್ಷರಿ ಏನು ಸರ್?
Annexure A, my
What
lord.
is that, sir?
The form number
First
52
notice has been issued.
under section 52 of
One minute,
work property that they.
1 minute, sir. Which is the judgment you said it is covered?
Page number 90, my lord.
90.
Please, man.
ಫಾಲೋ ಮಾಡಿರೋದು ಯಾವುದು?
My lord.
ಫಾಲೋ ಮಾಡಿರೋದು ಯಾವ್ದು ಅದರಲ್ಲಿ?
Annex, sir, K, my lord.
Sir.
98, 98.
ನಾನು ಇಲ್ಲಿ ಕೋಟ್ ಮಾಡಿರೋದು ಯಾವ ಆರ್ಡರ್?
98, my lord. To remove the name of work property in column number 11 of the property record of.
ಅಲ್ಲ, ರೆಫರ್ ಆಗಿದ್ದು ಪೇಜ್ ನಂಬರ್ 101 ಮೈ ಲಾರ್ಡ್, 101 ಪೇಜ್ ನಂಬರ್ 101 ಡೈರೆಕ್ಟೆಡ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್,
yes,
ಅದು
sir.
ಕವರ್ ಆಗಿದೆ. ಇದ್ರ ಬಗ್ಗೆ ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಗ್ರೀವೆನ್ಸ್ ಆಸ್ ಫಾರ್ ದಿಸ್
I will write, sir. 50 you can't get over everything. initiating proceedings under
no, my lord.
54, no.
No, my submission before your lordship would be.
Yes, sir, we will rehear the matter, not a problem.
Please,
Yes.
please, my lord.
The petition was disposed following the order passed by the coordinate bench. The learned counsel for the petitioner has moved a memo on the score that the order that had to be passed following the judgment was in writ petition 103231 and not the other one. The learned counsel Lad Khan would now submit that he would make submissions with regard to the inquiry under 54. It is noticed that the coordinate bench has clearly held that the Waqf board cannot invoke proceedings under section 52 to get over the order of the land tribunal. Therefore, the matter would require further hearing. List the matter tomorrow in the
Please.
fresh matters list.
Please.
I am going to follow that only.
No, my lord.
You cannot get over the orders by
Alala.
invoking 52, sir.
My submission the other
No
day.
problem. Yes, yes.
The other day, if my brother had informed me well in advance, I would have submitted the same thing on that day.
Tomorrow you do it.
No, I will do it, my lord.
Yes.
I'll.
Yes, yes. Next.
Obliged, my lord.
MB Reddy, MB Kanvi.
Anagjar,
Is
my
there a line
lord.
being spoken to yake?
ಅದು instead of job, my lord, the lump sum amount of 5 lakh can get ಅಂತ.
ಅಲ್ಲ ಅದು ಇಟ್ ಇಸ್ ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್ ಪ್ರಾಜೆಕ್ಟ್ ಮೇಲಾಡು ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಕೊಡಬೇಕು
ಏನ್
ಅಂತ
dispose ಮಾಡ್ರದು ಏನಕ್ಕೆ?
ಎಸ್ ಡಿಸ್ಪೋಸ್ ಬಿಕಾಸ್ ಜಾಬ್ ಇಸ್ ನಾಟ್ ಆಫರ್ಡ್ ಇನ್ ದಿಸ್ ಸ್ಕೀಮ್
Lump sum amount, my lord. Anagjar, my lord.
How order,
Whatever
sir?
the amount they will-
Which order is that?
Anagjar, my lord.
Being spoken to ಯಾಕೆ?
ಅದು ಯಾಡ್ ಮಾಡಿದ್ದಿಲ್ಲ ಅದಪ್ಪ lump sum amount, my lord.
ನನ್ನ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? Where is order madam?
ಇದು ಕವರ್ಡ್ ಬೈ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಮೇಲಾಡು ಜಾಬ್ ಇಸ್ ನಾಟ್ ಆಫರ್ಡ್ ಅಂತ ಅದಕ್ಕೆ ನೌ ದೇ ವಾಂಟ್ ಲಂಸಮ್ ಕಂಪನಿ
Whatever division bench has granted, I
ಎಸ್
will grant.
ಎಸ್
If there is any mistake in granting, we will correct the order. All right, ಅದ್ಯಾಕ್ being spoken to ಬೇಡ, we'll do. Division bench order ಪ್ರಕಾರ
Yes, ma'am,
ಮಾಡ್ಬೇಕು.
yes.
The implemented application
ಈಗ
alone.
ಇನ್ನೂ sign ಮಾಡಿದ್ದೀನಿ, sir. We'll do it.
ಪ್ಲೀಸ್
Yes, ma'am.
Division bench ಅಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. Don't ask beyond that because I have not determined anything on merits.
Yes, ma'am.
ಪ್ಲೀಸ್
Prithvi,
Four, Prithvi case.
Third para, my lords, in third line, lords, for issue of NOC for construction, Allah, for alienation of property, third party. Third line, Allah.
respondent ಯಾರು?
Sanjay Chinna, I have informed.
Ah.
lords. Please,
ಎಲ್ಲಿದೆ third parallel?
third line, lords, third para, lords.
Seeking no objection in terms of.
For
the
construction,
rules
Allah, for alienation
to- No,
of
see for
NOC, for selling the property to third.
alienation, your permission ಬೇಕಾ ನಿಮ್ಗೆ?
Please.
Why?
Is after the auction,
After
10 years.
After 10 years.
There
lords.
the subject petition was disposed by an order dated 29th October 2025. The counsel for the petitioner has moved the matter of being spoken to on the score that there's typographical error crept in at paragraph 3. The third paragraph now reads as follows. The third paragraph should read as follows. The now after. The petitioner is seeking no objection in terms of the Bagalkot Town Development Authority rules to issue an NOC for alienation of the property. ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡಿ ಮಿಕ್ಕಿದೆಲ್ಲ ಹಂಗೆ ಇರುತ್ತೆ.
Please.
Bill number 5.
I appear for petitioners in this case, no?
Kindly pass your lordship. Yesterday matter it was listed.
ಎಲ್ಲರೂ
covered
served
with-
unrepresented. Yes, Muridhar.
Please, my lord, this is a matter pertaining to pension, my lord, and dearness allowance. The petitioners, my lord, are seeking, my lord, petitioners are seeking, my lord, a revised dearness allowance, my lord, at central rates, my lord. Lord, this is a case where these petitioners, my lord, are all retired
None
professionals.
of the respondents are represented. They are all served.
Please, my lord. It's
Na
a
division
government,
bench
my lord,
ಅಲ್ಲಿ hear
it's a decision
ಮಾಡಿಲ್ಲ.
of the government, my lord, government's decision, they will follow, university and
Who
other
has to
things.
do it, madam? ನೀವಾ?
Please, your
Government
lordship.
ನಿಮ್ದ
Now,
ರೆಡಿನಾ?
pass your lordship.
ಆಯ್ತು, ಪಾಸ್ ಓವರ್.
Please. your
Please,
lordship.
my lord.
ನೆಕ್ಸ್ಟ್.
Bill number 6. Chapuri.
Let's may I request it on Monday, Mulats. On the previous occasion, I was directed to take notice. I've informed the referring advocate, Mulats. He would send wakalat by Monday.
List the matter on 26th in fresh matters list.
Great.
Yes.
Bill number 7, Jagdish Patil. Shivraj P. Mudhwa.
Your lordship, it may be heard along with 211, your lordship. Same management, your lordship, and these are the
211.
lecturers. your lordship.
211 ಜೊತೆ ಕೇಳೋಣ.
Yes, sir.
Bill number 8, KL Patil, Sunil Desai.
The last occasion in this matter, lordships were pleased to direct the state to sanction pension. Serious orders were passed, my lords.
One ನಿಮಿಷ.
2 occasions it has come up before your lordships. 2021 I have retired.
One moment.
Lordship, please, your lordship. On the last occasion, directed that whether it was pension fixed or not, your lordship. Earlier, it was sent to the AG office, your lordship. With the objection, it was returned. Again, we have sent it to management, and the petitioner, he is not ready to rectify the objections raised by the office, your lordship.
What objections?
Lordship, earlier, they have raised
No,
some
What
objections.
objections?
He has not signed the papers.
What he has to sign?
ಅಲ್ಲಿ may make my lord, may make
ನೀವು ಯಾರು?
management my lord.
ಪೇಪರ್ಸ್ ಕಳಿಸಿಲ್ವಾ ಗವರ್ಮೆಂಟ್?
ಪೇಪರ್ ಕಳಿಸಿದೀವಿ.
ಯಾವಾಗ ಕಳಿಸಿದ್ದೀರಾ?
But,
ಗ್ರಾಂಟಿನೇಡಾ?
granting.
ಸರಿ, ಯಾವಾಗ ಕಳಿಸಿದ್ದೀರಾ ಪೇಪರ್ಸ್?
On 4/1, your lordship, it was sent, your lordship. Again, it was returned.
4/1 of which year?
4/1 of 25.
25.
Earlier, it was
make
sent
a
and it was
Did you
returned.
retire, sir?
2021.
Earlier, on 24/8/23, your lordship, it was submitted.
May make. Earlier, your lordship has passed an order.
7/8/2023 I have passed an order.
Yes.
What happened to that?
Yes, what I will tell. We have requested him to come and sign the photos and family pension papers is required to be done. He has done it and it is forwarded. Thereafter, your lordship says that, my lord, whatever the admissible is to be given to him. There is a dispute, lords, we have imposed a punishment. That order is under challenge. So your lordship says that.
Challenge ಅಲ್ಲಿ ಇದೆಯಾ?
There are 2 components which they have left out and they have sent it, which are subject
Oh,
matter.
that is.
That,
this
my lord,
matter,
your
yes.
lordship says that living up of that, my lord,
Two
the,
disputed components.
yes. So your lordship directed them. When it was sent to the office and he is supposed to go, he went to the BO office and says that unless entire amount is paid, he will not permit. He will not accept. So that is why it was again came to the court.
I'll keep
Now
my
we
party
have-
present.
Dismiss ಮಾಡಲಾ?
I'll keep my party present.
Not necessary.
ಇದು
ನಾನೇ
ನನಗೂ
ಅವ್ರಿಗೆ-
If you can't dictate your party, then it's no use.
ನಾನೇ
I was
ಅವ್ರಿಗೆ
not
ಹೇಳಿದ್ದೇನೆ
aware of
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋ ಇಲ್ರಿ ಇದನ್ನು ಸೆಟ್ ಮಾಡಿ ಹೋಗಿ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದೇನೆ.
ಇಲ್ಲ, what my party said.
ಇದ್ರಲ್ಲಿ ಈ ಪೆನ್ಷನ್ ತಗೊಳ್ಳಿ.
Yes, yes.
ಇದರಲ್ಲಿ ಪೆನಾಲ್ಟಿನೂ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Penalty is challenged.
In
Both,
this?
both punishments without enquiry.
Common merits, yes.
Yes, your lordships may kindly take annexure N, which is at page 59. This is the first order of penalty, 31/7/2017, page 59.
By the management?
Yes, management.
You're a disabled employee?
I am a disabled employee.
No, this certificate ಅಲ್ಲ
I'll
ಪಾಸ್
finish him and then.
ಅಲ್ಲ ಪಾಸ್
Why? Great. Yes, come on.
Yes, page 59, if your lordships may kindly take. This is termed as notice.
59 is your certificate, sir.
Illa, annexure N, annexure N, page 59.
Pagination problem. ಯಾವ್ದ್ರಲ್ಲೂ ಕೋಆಪರೇಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ.
I'll set things right, my lords. Tomorrow, your lordships. Annexure N.
Notice dated.
In this notice dated 31/7/2017.
That is page 61.
Sorry, page 61. In that, my lords, last para, ಅನಧಿಕೃತವಾಗಿ 33K ವಿಷಯ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿರುವ ಬಗ್ಗೆ ಸರಿಯಾದ ಮಾಹಿತಿ ಸಹ ಆಡಳಿತ ಮಂಡಳಿ ಒದಗಿಸದೇ ಇರುವ ಕಾರಣ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯಲ್ಲಿ ನಿಮಗೆ ತಿಳಿಸಿದ ಪ್ರಕರಣ ಮುಂದಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನವಾಗುವವರೆಗೆ ನಿಮ್ಮ ವೇತನವನ್ನು ತಡೆ ಹಿಡಿಯಲಾಗಿದ್ದು. For 3 months, my salary was withheld. Thereafter, if your lordships could kindly take annexure R, which is at page 81. It appears 83 in that.
Annexure R.
Yes, my lords, 31/10/2017.
ಅದು 81 ಅಲ್ಲೇ ಇದೆ.
Last para. ಕಾರಣ ಈ ಮೂಲಕ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ತಿಳಿಸಿದ್ದು ಸಹಿತ ಸದರಿಯವರು ಇಲ್ಲಿಯವರೆಗೆ ಮೂಲ ದಾಖಲಾತಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಸಲ್ಲಿಸದೇ ಇರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇವರಿಗೆ ವೇತನದಲ್ಲಿ ನೀಡುವ ಸಂಚಾರಿ ಭತ್ಯೆಯನ್ನು ಇನ್ನು ಮುಂದೆ ರದ್ದುಪಡಿಸಿ ವೇತನವನ್ನು ಬಿಡುಗಡೆ ಮಾಡಲು ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. I was getting this sanchari bhatte because I am a physically handicapped person. Your lordships may kindly take page 86. This is notification by the state government in the year 1993, which notifies me as a physically handicapped person. And this I have produced very initial at the time of service itself. And these 2 penalties without enquiry. Both the penalties.
Penalty ಅಲ್ಲಿ impose ಮಾಡಿದ್ದಾರೆ.
ಒಂದ್ರೊಳಗ they withheld 3 months of salary.
Correct.
That is not paid subsequently.
Are those 2 components what they are projecting now?
That is the only thing now.
No, that is already the withholding of my lord.
What are the 2 components that they are disputing?
No increment, my lord.
Where is the order of withholding of increment?
Lord,
There are only two.
Wait. Where is the order of withholding of increment? I will ask the government to stop your grants if you treat if you treat a teacher in this manner who is retired. I'll direct the government to stop your grants.
Before, my lord, so far as him is concerned, my lord, I can make a, he was appointed as a Kannada teacher.
Forget his appointment. He's now retired. Don't go
No,
back.
that
in
is why we
appointment.
have cooperated, my lord, with him, and we have forwarded all the documents.
Correct. What are those two components that you have left over? Which is that? That has become the bone of contention now. For 5 years, he has not got his pension.
No, this on from when he comes before this court, my lord, we have forwarded all the documents as per he is not, my lord, inclined to get all the benefits.
You forget that, sir. What is that penalty you have imposed? What are those two components?
Just
Where Indian communication is, yeah?
Sorry, my lord.
Any other communication of imposing anything?
No, these are the only two.
If these are the only two, Sunil.
Yes.
How have you imposed this? And why is the state keeping quiet on this?
Withholding is N and R ali bari withholding of Lord salary is there.
Aita, one the withholding of salary. No enquiry, resolution of the management. Straight away withholding the salary. Next. Don't think you can treat your employees as and how you want.
No, certainly.
Will direct the government to treat you as and how they want.
No, if you, Lord, there is no, Lord, that making him as.
Why did you?
No, he has made, Lord.
1 minute, sir. Why did you withhold this 3 months salary?
No, there are two, Lord, allegation against him.
What allegation?
Pardon?
What allegation?
My lord, the one is that, my lord, he was, though he was appointed as a Kannada teacher, my lord, he has manipulated the checklist, and he himself has, my lord, worked in the Urdu division where my lord, the Kannada subject was not there, and he has created a document to show that he has been teaching.
Urdu teaching anta.
Urdu dalli teaching anta heli.
That is not the allegation.
And
ಅವ್ರನ್ನೇ ನೋಡ್ಬೇಡಿ ಇಲ್ಲೇ.
And my lord, we have issued a note, my lord, a notice to him, and he has applied. He has admitted the fact that, my lord, he has done it. So the question of, my lord, since he has admitted, it is only a minor punishment which is supposed to be imposed.
Where is the admission?
My lord, reply on that, my lord. I cannot. That is why I requested, my lord, pastor. I will assist your lordship. That, my lord, there is no, my lord, the vengeance against him, my lord.
Tomorrow in fresh matters list.
Please.
ಅದು ಫಸ್ಟ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಕನ್ನಡ ಟೀಚರ್ ನಾನು when I was put to Urdu school I have evaluated third language ಕನ್ನಡ. That is their allegation.
ಆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ಸ್ ಚೆಕ್ ಲಿಸ್ಟ್ ಅನ್ನು ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದು ಕೊಡ್ತೀನಿ.
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅವರೆಲ್ಲ ಅದ್ ಮಾಡ್ಬೇಕಾರೆ?
ಅಲ್ಲ ಅವನು ಅಲ್ಲಿ ಹೋಗಿ ಅದನ್ನ ಆ ತರ ಕಳಿಸಿರೋದು ಗೊತ್ತೇ ಇಲ್ಲ. ಗೊತ್ತಾದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ಲಿ ಮಾಡಿದ್ವಿ. 19 ಆರ್ಡರ್ ಅದು ಈಗ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ವಿಥ್ಹೋಲ್ಡಿಂಗ್
ಪೆನ್ಷನ್ ಈಗ ಬಂದಿದೆಯಲ್ಲ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ ಪೆನ್ಷನ್ ಈಗ ನಮ್ದು ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ನಾವು ಕಳಿಸ್ಕೊಟ್ಟಿದ್ಬಿಟ್ಟಿದ್ವಿ.
ಆ ಟೂ ಕಾಂಪೋನೆಂಟ್ಸ್ ಸೇರಿಸ್ಕೊಟ್ಬಿಡಿ. ವಾಟ್ ಇಸ್ ದ ಡಿಸ್ಪ್ಯೂಟ್ there? What is that dispute? There is no dispute in the eye of law.
No, but he has made a mistake that he can't. Now he has retired.
Sir, if he has
only
made a
because
mistake, if he has made a mistake, hold an inquiry and punish him, not according to your whim and fancy. Now he should get pension.
No, there's certainly. I'm not.
For 5 years, 21 retirement. Like 4 years agide. ಒಂದು 6 ತಿಂಗಳ ಗ್ರಾಂಟ್ ನಿಲ್ಲಿಸಿ. Then I will impose costs and cost of litigation from them to be recovered from the management while you gave the grants. How sari hogutte? Definitely I'm going to pass this order. Tomorrow I will pass this order saying out of the grants that is received by the management, the interest and costs will be recovered. That is going to be the order. Tomorrow you convince me. Yes.
Certainly.
Number 9.
I pay for petition in this case, my lord. But all this
disposal of WP now, why sir?
But this is covered by judgment. This is a case where, my lord, this is a case, my lord, all these petitioners are the D group employees working in the aided high schools. No, they have been working in the high school since 1993, my lord. In the year 2014, my lord, Annexure A, the government has issued a notification for admitting granted aid for 918 D group employees working in various aided institutions. In the said,
madam. ನೋಡಿದ್ದೀರಾ? Why?
ಇದರಲ್ಲಿ least has been, your lordship may kindly see.
Tomorrow fresh matters. Tomorrow
Please.
fresh matters. Yes.
Please.
Bill number 10, Srinivas Vinayak.
Lord, is the yesterday matter, Lord, rejection of improper nomination is under challenge. And so far as the second matter is concerned, my lord, result is already announced. The connected matter, your lordships, in the same society is concerned. The person who approached this court for the election, which has been permitted, he has got elected. My lord, now that. Lord,
Lord, sorry.
no, interim order, there was an interim order earlier, my lord, not to announce the result. Subsequently, the writ petition was dismissed. Thereafter, results were announced. And now the application still for recalling is pending.
Recalling order.
Recalling.
ಎರಡರಲ್ಲೂ recalling ಇದೆ.
ಅಲ್ಲ ಒಂದರಲ್ಲಿ ಸೆಕೆಂಡ್ ನಲ್ಲಿ.
ಏನಕ್ಕೆ why recalling?
My lord, I request a passer, my lord. Senior will appear, my lord. Senior has appeared through VC in a principal bench, my lord.
Bill number 11, Dinesh M. Kulkarni.
Lords, State of Mandamus, my lords. My land was acquired by respondent number 2 KHB, my lords, for development of residential layout, my lords.
When?
My lords, in 2016, my lords, on.
Yes.
My lords.
Well, Ramesh.
my-
Karnataka Housing Board.
Yes, my
ಯಾರು
lords.
acquisition ಮಾಡಿರೋದು?
Respondent number 2, Karnataka Housing Board, my lords.
Who appears? ಯಾರು appear?
Rupali N.
Plus, what happened in this case, my lords?
Self-
In 2009,
Hmm.
the land was acquired in 2009, my lords. There was one PT sheet, my lords, which was subsequently set aside by the DDLR, my lords.
Hmm.
Later on, new PT sheet was filed, my lords. On that PT sheet, my lords, my petitioner's land was fallen on the northern side of the national highway, which was unutilized by the KHB, my lords. We made an application to KHB, my lords. KHB directed respondent number 3 to submit a report by making spot inspection. The respondent number 3 submitted a report, my lords, and directed respondent number 4 to hand over the land, my lords. Yes, my lords. I'm
That is not
seeking
done?
no, my lords. I'm seeking mandamus to consider that report, my lords.
The petitioner is before this court seeking the following prayer. Heard the learned counsel Vaibhav Inamdar appearing for the petitioner and the learned AG and other respondents. The second respondent, Karnataka Housing Board, hereinafter referred to as the board for short, in order to develop a residential layout at Ranebennur, notifies a scheme and consequent acquisition for the purpose of the said scheme, indicating lands indicating lands for acquisition, which included the land of the petitioner in RS 865/4 to the extent of 2 acres and 9 guntas. The final notification thereon was issued on 16/11/2010. An award comes to be passed. It transpires that certain proceedings were pending before the DDLR, and the DDLR Haveri, after conducting proceedings, has what is the report?
Well, they have submitted that the land is not utilized. Page number
See,
72.
the DDLR then on 15/6/2016 is said to have submitted a report that the land of these petitioners are not utilized and should be returned to the petitioners. Petitioners then make an application, make a representation to the second respondent for return of the land, which on the score that the land had not been utilized. The third respondent is also said to have submitted a report to the second respondent indicating that the land of the petitioners are not utilized. Notwithstanding the same, the second respondent has not passed any order with regard to the claim of these petitioners upon the representations which were submitted.
Second respondent has directed respondent number 3, my lords, to submit a report. Accordingly, respondent number 3 has submitted a report. Respondent number 4 has to consider that.
Who is
report.
R4, madam?
Land Acquisition Officer.
Housing Board, Karnataka Housing.
ಅವರೇ ತಾನೆ, yes. It transpires that a report is also in place from the hands of the third respondent to the second respondent, all of which would clearly indicate that the lands of these petitioners lands of these petitioners have not been utilized. If the lands have not been utilized, appropriate action in terms of the reports ought to have been taken by the fourth respondent. The fourth respondent having not taken any action is what has driven these petitioners to this court in the subject petition. The learned counsel for the petitioner would reiterate the grounds set out therein and claim and submit that a direction be issued to the fourth respondent to pass necessary orders on the reports that are submitted. The counsel appearing for the respondents would submit that if reasonable time is granted, the report submitted by the third respondent to the second respondent would bear consideration in accordance with law, and appropriate orders would be passed. In the light of the said circumstance, I deem it appropriate to dispose the subject petition with a direction to the fourth respondent to consider the report submitted by the third respondent to the second respondent, pass necessary orders in accordance with law, within an outer limit of 3 months from the date of receipt of the copy of the order, if not earlier.
My lords, one submission. In prayer, my lords, I have not written acquired extent, my lords. I may be permitted to. It is total extent, my lords. Out of that 2 acre 9 guntas, I have to write.
Is to extend 2 acres?
2 acre 9 guntas is acquired.
Learned counsel for the petitioner seeks leave of this court to amend the prayer, amend the typographical error in the prayer with regard to the extent of land which is narrated in the petition. The permission so sought is granted. Madbutta amele extent koneli 2 acres 9 guntas. Yes, next.
Obligement.
But 12,
Do that now.
Yes, I will.
Please. Petition, my lords, challenging the circular wherein, my lords, the tax on a royalty.
Differential
Royalty.
GST bills.
Ninne.
Differential. Ninne, my lords.
This is not covered. This is not exactly covered by the Supreme Court judgment. This is some factual aspects.
Wherein, my lords, we need to file the statement of objections.
The learned counsel Girish Shulmani seeks 2 weeks time, 3 weeks time to file statement of objections. Objections, if any, in the next 3 weeks. Any
Interim order.
Interim order subsisting will continue to the next date. Yes.
Much blessed.
13, Vijayendra Bhimak now. Raviraj C. Patil.
Lords, the petitioner is questioning the impugned denotification of section 17 of the Slum Act by the government. Lords, on the last occasion, Lordship, we are pleased
Denotification.
to denotify without there being power. Only on the ground that since before issuance of section
Who are
17
you?
Sorry,
ನೀವು ಯಾರು? ನಿಮ್ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿತ್ತಾ?
please
ಅದನ್ನ ಡಿನೋಟಿಫೈ ಮಾಡಿ.
Denotify.
ಲ್ಯಾಂಡ್ ಬೇಡವಾ ನಿಮ್ಗೆ?
ಬೇಡ ಅಂತ ಅಲ್ಲ, ಕಾಂಪನ್ಸೇಷನ್ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಅಪ್ರೂವಲ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿನೋಟಿಫೈ ಮಾಡಿದ್ರು. ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇರ್ ಆರ್ ಸಪರೇಟ್ ಫಂಡ್ಸ್ ವಿತ್ ದಿ ಸ್ಲಮ್ ಬೋರ್ಡ್. ದೇ ಶುಡ್ ಪೇ ಇಟ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಬಿಫೋರ್ ದಿ
What is the extent of land?
19 guntas.
Yes, Keshwari sir.
My lord, your lordship may come to para 3 of his own admissions in the writ petition. The slum has developed because of his own negligence. I will read that. No? It is submitted that in view of the dispute among family members of the petitioner, neither this nor his predecessors were in position to exercise their rights over the lands. But on the other hand, migrant workers, unskilled labor, domestic workers, mostly belonging to lower social strata who have come to believe.
Did you notify this for acquisition?
This is the.
Did you notify this for acquisition?
Illa, it was there. What we have done is, we wanted to improve it. Section 3 Kelgade, we have taken some improvement to this one, my lord, in the area because it was slum, my lord, unhealthy was there. Then, my lord, it was thought, my lord, to acquire.
But thought ಅಂದ್ರೆ ನೋಟಿಫೈ ಮಾಡಲೇ ಇಲ್ವಾ?
ನೋಟಿಫೈ ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ ಥಾಟ್ ಏನ್ ಬಂತು?
ಅಲ್ಲ ಅಂದ್ರೆ that was not done in due procedure and there was no requirement at all because the slum is not developed because of our mistake. It is his own responsibility to evict them. They are all encroachers. He himself has admitted.
No, it's all right. Now after notification,
yes,
final notification, ಅದ್ರಲ್ಲೇನು preliminary final ಇಲ್ವಲ್ಲ?
Land acquisition of
land acquisition ತರ ಅಲ್ಲ ಇದು, ಗೊತ್ತಾಯ್ತು?
Not applicable.
Yes, so after notification you have
17 ಕೆಳಗಡೆ once issued, my lord,
the submission is that 17 ಕೆಳಗಡೆ once issued you have no power to withdraw.
It cannot be. Under General Clauses Act, section 21, any order passed can be rescinded or withdrawn. They have withdrawn.
Power to do includes power to undo.
That has been dealt
Yes,
with.
my lord. They have withdrawn.
So we will direct power to redo.
No, he has no power to direct us. I mean, sir, my lord, he can demand us to acquire this.
Petition and another writ petitions were initially clubbed. And this honorable court lords has
On
held
that way
that
of
there
filed
is no
appeal.
power as such to invoke General Clauses Act for denotifying the land. In those writ petitions, the contention of the slum board was that the original
Which
landlords.
paragraph? Which paragraph?
Pardon?
Which paragraph in this?
Paragraph.
ಇದು ನೋಡಿಲ್ವಾ ಕೇಶವ ರೆಡ್ಡಿ ಸರ್?
They were the parties. They contested it.
I think, my lord, an
It is
appeal is
confirmed-
filed against that.
It is
order.
confirmed in
I
writ
will
appeal
check up
also.
that.
ನೀವೇ ಅಪೇರ್ ಆಗಿರೋದು.
ಅದೇ ಇದೆ. Appeal ಗೆ ನಾನು recommend ಮಾಡಿದ್ದೆ in fact because they cannot compel, my lord, because of their own mistake.
ಇದು ರೆಕಮೆಂಡ್ ಮಾಡ್ಬಿಡಿ.
My lord, because of their own mistake, that in that case, it was sold to the persons who are there.
No, whether it is mistake on the part of.
Mistake ಇರ್ಲಿ.
ಒಂದು ನಿಮಿಷ. Mistake on the part of the
In both
board
cases,
or of the petitioner, you did issue a notification for acquisition.
notification, we have, afterwards we came to know that it
You
was
can't
a
do that.
mistake on our part.
You can't do
And
that.
we have got power to withdraw, we have withdrawn.
ಎಲ್ಲಿದೆ ಪವರ್ ತೋರಿಸ್ಬಿಡಿ.
ಅದೇ
Under the
section
act
21 of the
ಜನರಲ್ ಕ್ಲಾಸ್ ಆಕ್ಟ್ ಬಿಟ್ಟು ಆಕ್ಟ್ ತೋರಿಸಿ.
Section.
No, ಜನರಲ್ ಕ್ಲಾಸ್ ಆಕ್ಟ್ ಸೈಡ್ ಗಿಡಿ. ನಿಮ್ಮ ಆಕ್ಟ್ ಅಲ್ಲಿ ಪವರ್ ತೋರಿಸಿ ಆಮೇಲೆ ವಿಲ್ ಕಂಪ್ಲೀಟ್.
ಆಕ್ಟ್ ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ,
ಏನಿಲ್ಲ
withdrawal ಬಗ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಆಮೇಲೆ.
So, my
Then
lord,
that is not panacea. No, general clause act is not panacea to all ills of the state.
my lord, ಈ particular issue ನಲ್ಲಿ the land was sold by the landlord himself to the dwellers. On that ground I have argued that, but still their lordship has directed us to acquire. We have filed an appeal against that. We have filed.
I will follow this.
ಮತ್ತೆ appeal ಹೋಗ್ತದೆ ಅಷ್ಟೇ.
ಹೋಗಿ.
ಆಯ್ತು ಸರ್.
ಅಯ್ಯೋ ಡೇಟ್ ಅಪೀಲ್ ಹೋಗ್ಬಾರ್ದು ಅನ್ನಕ್ಕಾಗತ್ತಾ?
Writ appeal is dismissed.
ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Writ appeal is
appeal ಗೆ
dismissed.
I had recommended, afterwards what has happened I don't know.
I'll get.
Where is the order?
I'll get. Writ appeal is dismissed.
ಅಷ್ಟೇ. Anything else? SLP ನೂ ಆಗಿದೆಯಾ?
SLP ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ.
ನೋಟಿಸ್ ಏನಿಲ್ಲ, ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದು ಆಫೀಸ್
ಡೈರಿ
ಅಬ್ಜೆಕ್ಷನ್ಸ್,
ನಂಬರ್
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ. That too by the slum board.
Anything else?
ಅಷ್ಟೇ ಸರ್.
Writ appeal order ಕೊಡಿ.
Court.
I think slum board people have to come forward.
Respond number 6.
It is for the slum board.
HDMC.
Slum board yaru? Who appears?
Only for government.
Respond number 6, my lord. Formal party of this.
Formal alla swami.
For Joshi
You are
appeal.
the person.
HDMC.
HDMC alla.
TMC.
Slum board.
ಹೊರಲ್ಲ
Who is
ಬಿಡಿ
appearing
ತೊಂದ್ರೆ.
for slum board?
Who appears for the
He is
slum board?
responsible for that.
ಶ್ರೀಪಾದ್ ಜೋಶಿ.
Because
ಎಲ್ಲಿದ್ದಾರೆ?
tomorrow I should not be, take an objection that you have accepted for that. They should say
I
for
will
that.
never say you have accepted.
ಅಲ್ಲ.
You are unable to convince the court ಅಂತ ಹೇಳ್ತೀನಿ.
ರವಿರಾಜ್ ಪಾಟೀಲ್ ಅಂತಿದೆ, ಅವರು ಶ್ರೀಪಾದ್ ಜೋಶಿ ಅವ್ರ ಕಲೀಗ್ ಅಪ್ಪಿದ್ದಾರೆ.
Let him come then.
Please.
Heard the learned counsel appearing for the petitioner and the learned counsel Keshav Reddy represent ನೀವು government ga? Government.
Yes, madam.
Representing the state. The issue in the list is with regard to notification of acquisition under section 17 of the Karnataka Slum Development Act, seeking to acquire the land of the petitioner. After issuance of the notification of 19 gundas of land of the petitioner, the notification is cancelled or dropped. The learned counsel for the petitioner submits that once having issued a notification under section 17(1), power to denotify or drop the said acquisition is not available under the act. The learned counsel Shri Keshav Reddy appearing for the state would submit that they have invoked section 21 of the General Clause Act to contend that the power to do is power to do inheres in it power to undo. The learned counsel of the petitioner would seek to place reliance upon the judgment rendered by the coordinate bench in writ petition 101473 of 2023, which considers this very issue of this very submission of this very counsel and declines to accept it. The learned counsel Shri Keshav Reddy submits that a writ appeal has been preferred against the said order. Counsel to the petitioner would now submit that writ appeal also has been dismissed and an SLP against the said order is pending in office objections. In the light of the said circumstance, there is no warrant to withhold this petition any longer, but there is no representation on behalf of the council appearing for the slum board Raviraj Patil. Therefore, awaiting his appearance list tomorrow. In the event the council would not be present, appropriate orders would be passed.
Please.
Yes, next. Aditomani, Itapil order. Yes.
For 14, Sachin C. Kulkarni, Anup Deshpande.
My lords, annexure F, the leave period for the year 1981 to 84 were not considered for increment of the petitioner. Petitioner was to retire in the year 1999. my lords.
One ನಿಮಿಷ.
Please.
ಯಾವಾಗ ರಿಟೈರ್ ಆದ್ರಿ ಸರ್?
He retired in the year 1999. And after that, he has been drawing pension. But the said pension is not feasible for him for the fact that his leg has been imputed for he being running tuberculosis. And that was the reason for which he remained absent from service from the year 1981 to 1984. my lords. And under annexure F, such period for medical leave were not considered as domestic leaves, and his increment was not properly allocated for that particular period.
When did that happen?
My lords, it is for the year 1981 to 1980.
No, when did that happen? Erroneous calculation ಯಾವಾಗ ಆಗಿದ್ದು? Pension ಕೊಡ್ಬೇಕಾರ?
Increment consider ಮಾಡಬೇಕಾರ pension ಒಳಗೆ.
Pension ಅಲ್ಲಿ
Yes, sir, ಒಳಗೆ.
ಮಾಡ್ಬೇಕಾರ.
Please.
ಯಾವಾಗ pension ಶುರು ಆಗಿದ್ದು?
From the year 1999. He voluntarily retired.
Voluntarily.
Yes.
23 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ ಆಮೇಲೆ?
Please, my lords. He has been, please. That is
Anything else?
nothing else.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner joins the service of the facts in brief remain are as follows. The petitioner joins the service of the respondent, the then Karnataka Electricity Board, as a temporary employee or a daily wage employee, as the case would be. The petitioner's service comes to be regularized on 16/11/1972. Between the years 1981 to 1984, the petitioner was not regular to his service owing to certain medical emergency. And therefore, his increments were postponed or not granted appropriately. The petitioner then gets back to regular service in the year 1984. After about 15 years of the said resumption of service, retires on seeking voluntary retirement in the cadre of executive engineer. The pension of the petitioner was fixed on 31/7/1999. After about 23 years of receipt of pension, the petitioner is said to have submitted representation for correction of the increment of the year 1981 to 1984, which would inure to the benefit of the petitioner for getting varied pension. Reject ಮಾಡಿದಾರಾ ಏನೇ? ಇಲ್ಲ.
He voluntarily resigned.
ಅದಲ್ಲ ಸರ್. ಇದು mandamus ಅಷ್ಟೇನಾ ಅಥವಾ?
ಇಲ್ಲ.
Quashing annexure F.
Annexure F and endorsement.
The said representation of the petitioner is met with its rejection by an endorsement dated 10th February 2022. The rejection is on the score that the petitioner had to get his increment corrected once he resumed service in the year 1984, as the increment, the alleged erroneous increment was between 1981 to 1984. The endorsement is what is called in question. If the dates link in the chain of events as narrated herein above is noticed, what would unmistakably emerge is that the petitioner has not been diligent but indolent in pursuing his rights. If the increment had been in error between the years 1981 to 1984, the petitioner ought to have agitated the same then itself. The petitioner keeps quiet for 15 years, retires on seeking voluntary retirement from service. After cessation of employment on such voluntary retirement, also keeps quiet for 23 years. Now, in the year 2022, is said to have submitted a representation seeking correction of an error of the year 1980, error that has happened between the years 1981 to 1984. Therefore, an error of 38 years is sought to be corrected in by way of a representation in the year 2022. It is trite law that the equity whatsoever is in favor of any employee or a litigant is lost due to sheer delay, as the law protects the diligent and not the indolent. But lacking in merit stands dismissed. Next.
Number 15, Mrityunjay Salikeri.
It's the compromise, my lord, without the signature of the party, and it's covered by your lordship judgment yesterday I had submitted.
Party yaru? Oh, idarda LSA.
LSA, my lords.
We have restored the proceedings there.
Yes, my lords. And that is also based on another annexure C, my lord, which is a reported judgment.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the issue in the list is akin to what is decided by this court in writ petition 102151 of 2024, disposed on October the 13th, 2025. This court has held as follows, following the law laid down by the coordinate bench, has held as follows. Quoted, same order.
My lord, so serial number 16, 121, 163, same, my lords.
Same. Yes.
And one more aspect in serial number 15 and 163, I filed an LR application that may be allowed, my lord. I will amend the cost item. Please, my lord.
Applications
In serial number 15 and 163.
15 and 163.
LR application may be allowed.
LR applications for the reasons indicated in the delay idea.
163 al delay ಇದೆ.
ಏನೇನು IAS ಇದೆ ಎಲ್ಲ allow ಮಾಡಿ.
I'm grateful.
ಹೇಳ್ಬೇಕಾ?
Number 17, Ranjita ji.
For respondents, please.
Your lordship,
17.
petitioners, please. Seeking the dearness allowances as per the rule 37 of the your lordship statutory provisions instead of 8 joint note. They have filed objection, your lordship. They have stated that your lordship there is a separate settlement as per the joint note 8. Wherein your lordship, our contention is when there is statutory provisions are clear, they cannot supplant the joint note 8.
Lord, if I may submit, Lord, I'm not substituting, Lord, the pension regulations by virtue of joint note. Lord, in fact, both pension as well as dearness allowance, Lord, the rate at which it is paid. Lord, the manner of payment is, of course, Lord, as per the pension regulations, both pension as well as
What
dearness.
would prevail?
Lord, pension
Statute
regulations
or a
will,
settlement?
Lord, even today, my lord, my submissions before your lordship is, my lord, pension regulation still prevails. My lord, pension regulations provides for a manner in which it is to be paid. My lord, that is being paid. In fact, my lord, pursuant to 1995 regulations, my lord, there have been several bipartite settlements in joint note, and both pension as well as dearness allowance has been subsequently revised. My lord, all the employees of the bank, my lord, have availed the benefit. My lord, what in some instances, my lord, pension has increased support. And my lord, the rate at which dearness allowance was being paid right from 1995 have been varying continuously, my lord. My lord, I have also produced joint notes, my lord, of 2010, 15 and 24. And my lord, to show that, my lord, the rate at which dearness allowance is paid, my lord, even though pension regulations provides that it has to be paid at a particular rate, whether flat rate should be applied, my lord, is the question before your lordship. Pension regulation says 0.35% of, my lord, basic. My lord, the pension.
They are not asking something beyond the regulations.
Lord, I'm not even submitting that, my lord. I'm saying, my lord, the rate at, my lords may kindly see the appendix to the pension regulations.
Dearness allowance, how it has to be worked out is in the regulation itself.
Please, my lord.
Right.
So is pension.
So is pension.
Yes.
Yes.
Now, my lord, both pension as well as dearness allowance is revised time and again pursuant to a settlement and the joint note, my lord, signed between the parties. Increased pension is also being paid to the petitioner. In fact,
is pursuant to the settlement.
Yes, my lord.
Yes, correct.
Increased pension and, my lord, vary in the dearness allowance is being allotted to all the employees, including petitioner. In fact, my lord, in 2022, when, my lord, petitioner retired in 2020, in 2022, pursuant to the 8th joint note, my lord, arrears of, my lord, increased pension was also paid to the petitioner because he is entitled to under the joint note.
Settlement.
Under the settlement. My lord, what petitioner is saying is, my lord, one part of the joint note is acceptable to me, that is, my lord, increase in the rate of pension, but one part of joint note which, my lord, varies the rate of dearness allowance is not acceptable to me. You know, is the contention for your
Is the variance now contrary to this statute?
No, my lord, it is not contrary. In fact, that is what I'm trying to submit. My lord, pension regulations provides the manner in which it has to be paid. My lord, in the year 1995, when the pension regulations came into force, my lord, the sixth bipartite settlement was there. My lord, pursuant to sixth bipartite settlement in the year 1993, pension regulations were implemented based on that, my lord. Thereafter, my lord, time and again, the rate at which pension as well as dearness allowance is paid is changed, my lord, as and when bipartite settlements and joint notes are in. And my lords are aware, my lord, of course, my lord, the wires and, my lord, the law, insofar as, my lord, joint notes and bipartite settlements are concerned, has been time and again upheld, my lord. Your lordships are aware, my lord, your lordships have been part of those decisions. In fact, my lord, there was one decision, my lord, in Suresh Prabhu versus Corporation Bank. In fact, your lordships are aware about that case. Even though the matter related to, my lord, second option pension, my lord, the crux of the matter was that, my lord, variation, my lord, in the manner of payment based on the joint note and settlements. My lord, that also, my lord, pursuant to, my lord, UCO Bank, Sanvarmal, as well as Shil Kumar Jain, they have upheld the validity of these settlements and joint notes. My only submission before your lordship is, my lord, if the petitioner, my lord, now says that, my lord, you pay me pension in accordance with revised rate under the joint note, but don't pay me dearness allowance in accordance with joint note, pay it to me under 1995 regulations. My lord, that in my respectful submission would not be correct. In fact, my lord, identical issue had also come up before the Honorable Supreme Court. Just place that on record, please, my lord. Lord, before that, Lord, petitioner has placed on record one decision of the Honorable Supreme Court in G. Palani's case. Lord,
29.5.
Yes, my lord. G. Palani's case was with regard to, my lord, retrospective implementation of, my lord, amendment of regulations. My lord, here is not that case. We are not trying to retrospectively make any change. In fact, insofar as pension is concerned, we are paying arrears. Dearness allowance, revised, reduced rate, we are not affecting to the change of payment. That we are not affecting. Therefore, my lord, this judgment will not apply at all. However, my lord, on an identical case, I'll invite your lordship attention to, my lord, in fact, my lord, discussions were held with regard to changes that were made in dearness allowance subsequent to every bipartite settlement and joint notes. My lord, I'll trouble your lordship reading a couple of paragraphs,
Yes,
my lord,
yes,
if your
Lord.
lordship permits, my lord. Para 25 onwards, my lord, page 563. I'll come to what the Honorable Supreme Court has held later, my
At
lord.
the
I would
outset.
want to read out a few facts.
At the outset.
At the outset, please. At the outset, it must be stated that Appendix 2 to the pension regulations had characterized employees in three different segments. And the dearness relief payable on basic pension in respect of employees in these three categories was on the basis of tapering formula, which differed in each of the categories. In respect of those who were in the first category, that is, who had retired earliest, the dearness relief was at 0.61% on the first slab, namely up to 1250 of basic pension. The rate then tapered and finally was 0.17 of basic pension in excess of 2130. At the same time, in respect of retirees in the second category, the rate of dearness allowance was 0.35%. In respect of first slab, namely to 2400. Here also dearness relief was on tapering formula and finally 0.09 of basic pension in excess of 4100. The third category, which was in respect of employees who retired after 1/4/1998, the rate was 0.25% for the first slab up to 3380. Going by the tapering formula, the rate of 0.06% of the basic pension in excess of 5770. If clause 7(2) of the 9th bipartite settlement dated 27/4/2010 is compared with the latest category of Appendix 2 of the pension regulations, there is hardly any change in respect of retirees during the period 1/4/98 to 31/10/2002. Thus, whatever benefit was conferred and was enjoyable by employees who retired before November 2002 was not taken away. If both categories dealt with by 9th bipartite settlement dated 27/4/2010 are further compared.
Para 30, sir.
I was coming to that, my lord. Before that, may I read para 27, my lord? This is the issue, my lord, before your lordship. The parity was sought in the position was not so much regarding applicability of same rate of 0.18%, but was in respect of flat rate idea. The illustrations given in para 30 of the writ petition that we have quoted herein above bring home the point. My lord, then I will come your lordship to, my lord, para 29 and 30. My lord, para 29, they refer to P.N. Menon's case.
Yes, yes.
Para 30, my
is
lord,
what is the
yes,
crux there.
therefore, my lord, insofar as dearness allowance is concerned, my lord, the judgments referred to by my learned friend will not apply because I'm not trying to retrospectively.
What is relied on is 29.5.
29.5. Lord, I'm not on that at all. Lord, I'm only saying.
No, 29.5 to drive home the point that statute will prevail over settlement.
Absolutely, my lord. Statute will definitely prevail over the settlement. And I am not even trying to take away the right conferred under 1995 regulation because that is under which, my lord, the dearness allowance as well as pension is paid to them.
Correct.
Lord, I am not tapering with that either. I am only saying that, my lord, the provisions of pension regulations has undergone changes right from 1995 till, my lord, today.
I'm aware.
Several times. Not once, my lord, several times. Every time.
Has to, it can't be stagnant.
Yes, my lord. Therefore, my lord, the petitioner now cannot say, my lord, pay me dearness allowance at 30.3. In fact, my lord, 2024 joint note, the rate has been increased. And that change has also been given to the petitioner. I have produced a copy of the pension slip.
The dearness allowance.
Yes, my lord. Dearness allowance has been increased and that change has also been effected. My lord, my lords will see annexure. If I may compare, my lord, your lordship will see R7, R8 and R9. 3 different periods I've produced.
Now come to page 92.
92, my lord, of my statement of objections.
No, petition.
Please.
Now,
Please.
this is the latest settlement.
Yes.
As,
No, no,
no. As on
for
the date
petitioner.
the petitioner retired,
Please.
this was the settlement that was prevailing.
Please.
So clause C thereof deals with dearness allowance.
Yes, ma'am.
Now, this is what was being paid to the petitioner.
My lord, prior to this, my lord, the rate of joint note of the year 2015 was being paid.
That was higher than, that was
Higher than this.
Higher than this.
Yes, my lord. Now, my lord, in 2024, this has increased up to 1%.
Now it has increased more than this.
More than this.
Now you are paying that to him.
Higher pay. That also I have produced. R7, R8, R9, my lord, 3 documents, your lordship will have a comparative idea.
Yes.
Lord, R7, your lordship will find, my lord, at page
137.
137.
Please.
137.
All this? Yeah.
Page 137 is the pension slip for the year September 2020, prior to, my lord, change affected pursuant to this settlement. Here, my lord, he was getting dearness relief at 23,580 and the pension was 34,25.
Now it's increased.
My lord, R8, 139, your lordship sees, pension is increased to 47. Pursuant to joint note, and the dearness allowance was reduced to 15,650. In fact, my lord, this also happened because a portion of dearness allowance was also merged with basic pay.
Correct, merged with.
Yes, my lord. Then, my lord, R9,
DA
page
merging
140.
with basic pay has.
Yes, my lord, R9, page 140. Pension is increased to 47 and DA is increased to 25, more than what, my lord, the petitioner was earning into.
Now this is the latest position.
This is the latest position, my lord. This is as of October 2025. 2024 was the settlement, my lord, joint note, and that change has also been affected and arrears have also been paid to the petitioner.
All right. What do you have to say?
My lord, prepared.
Huh? ಕೊಡಿ ಆಯ್ತು ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಬ್ಯಾಂಕ್ಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
My lord, first thing is, they have not, while raising objection, they are silent on the letter what they have sent to, which we have submitted, copy of which we have submitted. They are silent in respect of objection. That means.
What objection?
I mean, they have not stated anything on the letter.
You forget that in
Okay,
law what is
my
there
first
ಹೇಳಿ ಅವ್ರು
submission.
ಹೇಳಿದಾರೋ ಬಿಟ್ಟಿದಾರೋ.
That was my first submission. They say that you've admitted payment of dearness allowance as per regulation 37. I say, my lord, even today I pay as per 37. Only the rate I change.
My lord, they are referring to Palni's case. When we.
So who is referring to Palni's case?
Petitioner.
Both are, I mean, he said he denied, but as per the petitioner, Palni's case, he is relating to 29.5. But when those who are denied the benefit under 29.5, bank itself says that this pertains to 1616, 1684. They are taking contradictory position as far as decision in Palni is concerned. Now, I am submitting joint note. I'll come to judgments later. Joint note, it is there. It is signed on the same date, 27/4/2010. In para 8, clause 8, the banks and the unions themselves have said that all other provisions which are not dealt with in this joint note
statute will
as per pension regulation. That means they themselves have admitted pension regulation prevails over settlement.
All right.
Then on 25/5/2015, they have signed a record note of discussion where both on behalf of Indian Banks Association and also on behalf of unions and associations, they have clearly said retirement benefits are as per rules prevailing on the date of retirement.
All right.
Then Honorable Finance Minister on the floor of Rajya Sabha, she has
is-
also said
that
it is in
settled
terms of
position that
regulation
ret-
37. Next,
Pension,
coming
pension
to,
would be determined as on the date of
yes, sir.
retirement.
Yes, my lord.
But now with the news, then you don't want any other settlement that comes about later?
Settlements cannot take away.
ಹೌದು ಸರ್, ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಹೊಸ ಸೆಟಲ್ಮೆಂಟ್ ಪ್ರಕಾರ ನಿಮಗೆ ಜಾಸ್ತಿ ಬರ್ತಾ ಇದೆಯೋ ಇಲ್ವೋ? Then we will
Settlement,
ಅಲ್ಲ ಈಗ
my
now,
lord,
are you not getting 26,000 dearness allowance today?
I am getting reduced dearness allowance
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಬರ್ಬೇಕು?
as per whatever that is there as per pension regulation. my lord.
ಅಲ್ಲಿ ಎಷ್ಟು ಬರ್ಬೇಕು ಅದ್ರ
It
ಪ್ರಕಾರ?
is your lordship. 1,05,000 your lordship, nearly to 1
Dearness
lakh.
allowance
Please,
every month,
please.
Every month.
1 lakh?
20, near to 1,05,000 your lordship. As on today, they are getting.
1,05,000. If the DA is merged with basic pay, where is the question of our basic pension? Where is the question of you getting 1,05,000?
As per their calculation, your lordship, on the slab, they are calculating it is 0.07. According to that calculation, your lordship, we are getting
26,000. Yes.
26,000. If it is as per the statutory provision, your lordship, 0.35, it is 1 lakh.
0.35% of this, of the basic pension.
I have made the raw calculation, your
Nobody?
lordship, approximately, it is. Please. Basic 10.
But that calculation may not be correct because.
1933 slab you are entitled to?
Please, your lordship, that is that is clear in the annexure A itself, your lordship, the person whoever retired on or before 2000, after 2017, they are entitled for 0.35% on a basic, your lordship. I've made it raw calculation, your lordship. If I am wrong, I'll take one more suggestion from the any seniors to calculate it one more time.
Why?
Because
Why do you want?
because at
ನೀವು ಮಾಡಕ್ ಬರಲ್ವಾ?
I'll calculate.
Then
Look, that rate is now revised to 1% of pay. my lord.
no, now 0.35% if the regulations would say.
Yes.
And your, and the settlement reduced it to 0.7, which is far less than the 0.35 in the regulations. What would prevail? You accept that the
Have to
regulation
see-
would prevail?
My lord, I'll have to see the.
No,
my lord,
pension
calculation.
regulations will prevail there can be no
But
doubt
insofar
about.
as the right, my
There,
lord,
no, there
regulation-
can be no qualm about the pension regulations prevailing over the statute, settlements or whatever it is.
I'm not saying that, my lord. I'm not saying that. I'm saying, my lord, the rights, my lord, of the petitioner is under the pension regulations, of course. But that rate cannot be applied at this point in time because it has undergone several changes. In fact, my lord, those employees who have retired prior to the petitioners, my lord, will also be affected. My lord, they'll all start coming before this honorable
it has
court
a-
claiming rights.
There's a far-reaching consequence.
Lord, not just, my lord, and not just this bank, my lord, it will be far-reaching consequences for
All the bank
for all the
employees.
bank employees who have retired from, my lord, 1995 till today. And because, my lord, all of them have been paid pursuant to joint notes. And, my lord, my one more submission before your lordship is, my lord, one of the prayers sought for in the writ petition is to strike down, my lord, 9C. My lord, 9C, my lord, is, my lord, under a joint note between IBA and all banks. My lord, I'm only, here only, my lord, SBI is a party. My lord, the rights under, my lord, all those banks
All
will
that
also
we'll
get affected.
consider.
And, my lord, my most important submission is, my lord, this will have a huge consequence on each and every, my lord, employee retired prior to, my lord, or if I must say after 1995, my lord, because all of them have been
No,
paid
we'll
at,
have-
my lord, joint notes.
Pass a cautious
If I'm not wrong, your lordship, indirectly they are coming to Palni judgment, wherein it says that your lordship retrospectively they cannot amend the provisions. In this case also, they cannot amend the provisions, your lordship, because it is repealed.
There is no amendment here of the provision. It is only tweaking by way of settlement. Regulation is in place. No problem, but regulation is varied insofar as pension and other benefits are concerned.
That is what.
Through settlements. That
That is
has
what.
been
In
practiced
Palni
in the
also,
banking
that,
industry.
in Palni judgment also that is considered, saying that, your lordship, they cannot make bipartite settlements when there is a regulation is clear.
My lord, I would like to draw your kind attention to
Palani's judgment.
2019 amendment by State Bank of India. Annexure H, pages 114 and 115. There they have clearly stated that those who have opted for pension of amalgamated bank, pension needs to be paid as per pension regulations as existing on the date of amalgamation. It is their own amendment. That is what we are also seeking.
That is not a problem, because 1/4/2017, when the notification came of amalgamation, this was one of the clauses. Otherly the doubt illa.
Okay. Then he was talking about that United Bank of India judgment. Entire judgment is not based on the regulation, my lord.
No.
It is in entirety. It is in entirety.
Judgment he relied on for one purpose, saying you can't pick one part of the settlement to say you want it and say the other part of the settlement is not correct. That's also there. We'll see.
But this is settled in Suhasini case.
Can't blow hot and cold in the same way.
And the bank cannot say that huge amount of money because of acquiescence.
All that is fine. We'll see. We'll pass.
Lord, I'm also on the point of, my lord, validity of these joint note and settlement. It has been time and again upheld to say that, my lord, these are binding, my lord, on all the employees. Insofar as bipartite settlement is concerned, unionized sectors and, my lord, the management, and joint notes insofar as officers and management is concerned. Lord, it is a bind because all of these employees are members of those union and consciously they have signed it. Lord, on that point also, my lord, I'm
yes, heard reserved.
Grateful.
If your lordship permits, your lordship, by afternoon I'll file some judgments, your lordship. I have prepared the compilation. So I'll file.
This has far-reaching consequences.
1995 onwards.
No, that's why.
I am also requesting my lord to extend the benefit of this judgment to all members of my association, who include even members of other associate banks.
Even though they're leading banks, they'll go bankrupt if that happens.
Sir, 68,000 crores is the net profit, sir. We are not asking even fraction of it, sir. Small fraction of it.
68,000 crores is the profit.
Profit.
It'll all go in DA, my lord, from 1995.
It will not. And that cannot be the reason to deny also, my lord.
Grateful for question.
Thank you.
Yes, Ranjita, Kodi, judgment.
Please, I'll please.
Heard reserved.
Number 18, Ranganath is doing.
Petitioner, madam. Petitioner is working as a daily wage employee, madam. He is working more than 40 years, madam. Petitioner is not regularized. He requested for your lordship powered by decision.
1990, your lordship, he was terminated. There is a gap, your lordship.
Labor court. 1990 in the
98 in the lordship.
I have labor court, but labor court is allowed and allowed ID number so and so, and full without back wages continuity of service, my lord. And they approached the Honorable High Court. High Court is also confirmed by the labor court order, madam. Petitioner is reported for duty on 6/12/99, madam.
Continuity of service ಕೊಟ್ಟಿದ್ದಾರಾ?
Yes, my lord. Yes. Page annexure A, my lord. Annexure A is the labor court order. Page number 17, my lord. Reference ID is allowed. Directed to take back the claimant in service without back wage, but with continuity of service.
Retire ಆಗಿದ್ದು ಯಾವಾಗ? ಇನ್ನು still in service?
Yes, my lord.
Representation.
My lord, I have made a representation. Annexure D, my lord. D, E, F, G.
ಯಾವ್ದು ನಂದೇ ಇದೆ ಅಲ್ಲಿ.
Annexure D is the issued by the AW, my lord. In the last ನಮೂನೆ ಅಂತಿದೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಕೆಳಗಡೆ ಲೈನ್ ಅಲ್ಲಿ ಪ್ರಮಾಣ ಪತ್ರ ಮೇಲಿನ ನಮೂನೆ ತೋರಿರುವ ಸಿಬ್ಬಂದಿ ಸೇವಾ ವಿವರವನ್ನು ಮೂಲ ಹಾಜರಾತಿ ಮತ್ತು ಎಂಆರ್ಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸರಿ ಇರುತ್ತದೆ. ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಸದರಿಯವರ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸಿ.
ಎಕೋ ಆಗುತ್ತೆ.
Yes, ma'am.
Stop.
Is your lordship, my submission is there is no continuation in the work.
ಹೌದಾ? ಆಮೇಲೆ
Appear for respondent number 3 to 6, my lords, KNL. He has terminated in the year 1984, my lords.
94 ಅಲ್ಲ?
1984, my lords.
84?
Please, my lords.
84 ಇಂದ ವಾಪಸ್ ಕರ್ಕೊಂಡ್ರಲ್ಲ ಆಮೇಲೆ?
He has challenged that in the year.
All right, ವಾಪಸ್ ಕರ್ಕೊಂಡ್ರಲ್ವಾ?
Please, my lords.
Then he retired as what? He is retired or serving still?
Service, my
No,
lords.
he is in service, madam.
58 years. The petitioner is before this court.
My lord, one more submission, madam. Annexure M and N, same employee, same Nigama, my lord. They have not approached the tribunal or any court of law, my lord. They have to be regularized, my lord. Annexure M and N.
Sir, you have approached the court. They have approached someone else.
Yes, ma'am.
ಮತ್ತೆ ಯಾವ್ದು ಎಮ್ ಅಂಡ್ ಎನ್?
Yes, my lord. Page number 72 and 76.
Before this court, seeking a direction to the respondents to consider his case for regularization of his services on the date on which he completed 10 years with all consequential benefits. Heard, so and so. Facts in brief, germane, are as follows. The petitioner joins the service of the fifth respondent as heavy mazdoor -watchman, a Group D employee on daily wages. With effect from 19/9/1979. The petitioner, ನೀವು terminate ಆಗಿದ್ದು ಯಾವಾಗ?
1984, my lords.
My lord, terminated in 1984, my lord.
To skip that.
84, April 84, my lord.
The petitioner is said to have worked continuously up to 1984 and is said to have been orally terminated without assigning any reasons or holding any inquiry. This is called in question by the petitioner before the labor court, before the labor court in
REF number 46 for
one
19.
ನಿಮಿಷ. In reference 46 of 1997. ಅಷ್ಟು ಲೇಟ್ ಆಗಿ ಮಾಡಿದ್ರ?
Please,
84 ಟರ್ಮಿನೇಟ್ ಆಗಿದ್ದು.
for 14 years delay in, my lords.
Why, sir, premium should be given to you?
My lord.
14 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನಕ್ಕೆ ಚಾಲೆಂಜ್ ರೆಫರೆನ್ಸ್ ಅದು ಏನು?
Reference, my lord, reference. 97 ಅಲ್ಲಿ.
Stop doing all this. Yes.
Without any notice ಅಂತ allow ಮಾಡಿದ್ದಾರೆ.
The petition ಮಾಡಿ madam. The government, the appropriate government referred the matter to the labor court for adjudication of the dispute, which according to the government did subsist as on the date of the reference. The reference was then numbered as reference number 46 of 1997. The labor court then, in terms of its in terms of its award dated 12th August 1998, directs while allowing the reference, directs reinstatement of the petitioner, but without back wages, but granting continuity of service. This is called in question before this court in writ petition 13169 of 1999, which comes to be dismissed by an order dated 31st May 1999. The petitioner then was reinstated into service in terms of what the labor court had directed. After his reinstatement, the petitioner continues to work then and even today. Representations are submitted by the petitioner to the respondents seeking regularization of his services. The representation did meet some favorable consideration, but not for regularization, but for bringing in the petitioner within the ambit of the Daily Wage Welfare Act 2012, The petitioner then, continues to represent that he has to be regularized and not bought under the ambit of the Daily Wage Welfare Act. The learned counsel appearing for the petitioner submits that the petitioner is entitled to be regularized from the date on which he completed 10 years of service, as the labor court had awarded continuity of service and the said award has become final. And the respondents have implemented the said order. The learned counsel would quote two illustrations where employees similarly situated have been regularized and the petitioner is meted out for discriminatory treatment. He would seek parity with all others who have been regularized in their services. The learned counsel, the learned HCGP would vehemently refute the submissions of the petitioner, contending that the petitioner was out of employment from 1984 to 1999. Those 15 years cannot be taken note of for the purpose of calculation of a period of 10 years, as he was terminated in the year 1984, which was only 5 years after the date of joining. The learned counsel would submit that the petitioner has been bought under the Daily Wage Welfare Act, and that is beneficial to him, and regularization cannot be sought as a matter of right in the light of the judgment of the Apex Court in the case of State of Karnataka versus Umadevi, 2006, 4 SCC, page 1. The learned counsel appearing for the respondents 3 to 6 would toe the lines of the learned HCGP in seeking dismissal of the petition, again reiterating the submission that the petitioner was out of employment between 1984 to 1999, and therefore the petition should be dismissed. I have given my anxious consideration. The afore narrated facts are not in dispute. The petitioner joining the service as a daily wage employee in the year 1979, on 1979 is a matter of record. So is the termination of the petitioner in the year 1984. This dispute is referred by the state after about 13 years of the termination. The reference is answered in favor of the petitioner. The award passed by the labor court is as follows. Page 15 to 17 is as follows. The labor court allows the reference, directs that the petitioner should be reinstated into service without back wages but with continuity of service. The said order is tossed by the state before this court in writ petition 13169 of 1999, which comes to be dismissed by the following order, page 22-23. Thus, the continuity of service that was granted to the petitioner became final. The petitioner is then reinstated after the order passed by this court without any further challenge. Therefore, the observation of continuity of service would inure to the benefit of the petitioner. Thus, the petitioner would be in service continuously from the year 1979. The petitioner then stakes his claim to be regularized in services. The claim is not accepted too, despite the representations being given. The benefit that the petitioner would get is his name being drawn in the list of employees who come within the ambit of Daily Wage Welfare Act. Notwithstanding the same, the petitioner again represents. The representation is not met favorably, therefore the petitioner is at the doors of this court. The learned counsel for the petitioner places reliance upon two illustrations where the regularization has happened in identical circumstances of two of the employees of respondents 3 to 6. The orders passed in favor of other two employees are as follows. Page 74 to 75 one, 76 one. The regularization of the aforesaid employees is not in dispute, as the respondents is not in dispute. This court, in identical circumstances, has, considering the case of the petitioner therein, passed the following order of an employee of ನೀರಾವರಿ ನಿಗಮ್ ಇದ್ಯಾವುದು?
Parappa Gowda ಮೇಲೆ.
Of
Your
the
Lordship,
very same employer, of the very same employer. This has become final?
Yeah, no, my lord, it is a file writ appeal, my lord. Writ appeal is pending.
Stay ಇದೆಯಾ?
Yes, ma'am.
Stay ಇದೆಯಾ?
Stay ಏನಿಲ್ಲ sir.
This court, considering the entire spectrum of the facts therein, has had held as follows. Page 62 to 66. In the light of the aforesaid circumstances, the petitioner does become entitled to regularization in services, regularization of his services from the date on which he completes 10 years of service. The issue with regard to the learned counsel for the learned HCGP projects the judgment of the apex court in the case of Uma Devi to deny the petitioner's regularization on the score that it is neither a sanctioned post nor a vacant post at the time when they were appointed, and the petitioner has been out of employment for 15 years. Therefore, the direction to regularization would put a premium on the absence of the petitioner for 15 years. The said submission would become unacceptable for the reason that the apex court in the aftermath, AFTERMATH, aftermath of the judgment of the judgment in the case of Uma Devi has in plethora of judgments considered the right of those employees who have rendered service in this state for more than 20 years, 25 years, or 30 years, as the case would be, and has directed regularization. The apex court has held as follows. Nandan judgment.
My lord, apex court judgment, my lord, in Jago case and Dharam Singh.
In the light of the judgment of the apex court rendered in the aftermath of Uma Devi, as quoted herein above, the petition deserves to succeed. It deserves to succeed with a direction to the respondent to consider the case of the petitioner for regularization of his services from the date on which he completed 10 years of service. You will not get arrears of salary, sir.
My lord.
Regularization of services, ಇದಲ್ಲದೆ ಇನ್ನೊಂದಿದೆ. The petitioner shall become entitled to all consequential benefits except the salary of a regular employee, but the period of regularization from the date on which he completed 10 years of service till his retirement will be taken as service for all other benefits.
Excluding that period, your lordship, where he was not work.
ಅದು ಕಂಟಿನ್ಯೂಟಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್.
Please.
If you are challenged continuity of service illa andidre, what you say?
Your lordship, high court order.
Yes, next.
Much obliged.
Prithviraj P. Hekkalmani.
This is with respect to cancellation of GST, my lords. Covered matter.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the issue in the list is with regard to cancellation of GST without issuance of notice to the petitioner.
Without fixing the time and date of hearing, my lords.
Without fixing the time and date of hearing pursuant to issuance of the show cause notice. The learned counsel for the petitioner submits that the issue in the list stands completely answered by what is rendered by the coordinate bench, which is not disputed by the learned AGA. The coordinate bench is held as follows. In the light of the said issue being answered by the coordinate bench, which I deem it appropriate to follow, the petition deserves to succeed with this on the same lines ordered accordingly. Allowed.
20 SM Kalwad.
Pertains to damage award. Damage award.
Damage award. ಇವತ್ತಿದೆಯಲ್ಲ ಅದು?
ಇವತ್ತಿದೆ 4 o'clock.
213
ಮಧ್ಯಾಹ್ನ
4 PM.
21 Sabil Ahmed.
Lords, I pay for the petitioner in this matter, my lords.
Yes, my lord.
ಮಧ್ಯದಲ್ಲೆಲ್ಲ ಸೇರ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ.
Earlier, it
For
was
responding
disposed of
to
my
complainant.
I pay for the petitioner in this matter, my lords.
Yes.
Petitioners are the accused number 1, 2, 3 in the CC 747 of 2020. My lord, the complaint is arising out of a private complaint filed by the de facto complainant second respondent, covering the very same allegations as that of the civil court. A civil suit which is filed by them. Civil suit is filed on 25/7/2019, my lords, with verbatim allegations. Except for changing plaintiff and defendant as complainant and accused, they have filed the present private complaint, my lords. I have three grounds, my lords. Remedy under section 154(1) and 154(3) was not exhausted before invoking section 200 CRPC. Secondly, all the allegations were covered in the suit which were being agitated before a civil suit are again reiterated before in a private complaint, my lords. Thirdly, my lords, the private complaint is being filed only to ensure that I am being evicted without due process of law to avoid adjudication in a civil suit, my lords. If my lords peruses the plaint, my lords, more particularly the schedule, which they say that I am in occupation. The property of the plaintiff is described as A schedule, which is given as CTS number 7/2G. The portion which they say I am in encroachment is bounded west of 7/2G. I am not in possession of their property, my lords. I am an encroacher in the road. They want to evict me without following the due process of law, and this is also again reiterated in the complaint also. At paragraph number 7 of the complaint, they say that they tried to offer money to the accused to go out. When they refused, they started all this litigation.
Ashana?
Please, my lords, in this regard, two judgments of one judgment of my lords themselves, my lords, and another judgment of the Honorable Supreme Court, which covers the case of the petitioner.
ನಂದೇ ಕೊಡ್ತಾ ಇದ್ದೀರಿ.
Yes, my lords. And another judgment of the Honorable Supreme Court, wherein at paragraph number 33, the Honorable Apex Court has considered with regard to when paragraph 33, my lords, having heard the senior counsels for the parties and after going through the material on record, the issue which emerges is as to whether a criminal case against the appellant could proceed. This has to be examined from two angles. Firstly, as to whether any criminal offense in the background of factual position is made out to justify the criminal proceedings against the appellant. Secondly, whether the same cause of action has been based on the afore narrated facts, both in civil and criminal proceedings can simultaneously go on. And considering all these aspects, the Honorable Apex Court has upheld the quashing, which was upheld the order.
You're talking of Vijay Lakshmi.
Indeed, my lords, Vijay Lakshmi's case. And thirdly, my lords, with regard to the documents which they have relied, at page number 192, it is the chief allegation that I have got the sketch out of their property, subdivided sketch out of their property. This sketch is obtained in their 2019. Their sketch is as it is intact. And allegation against accused number 3 is that he has got form number 3, which is the extract of the municipal tax demand register extract. In that form number 3, nowhere TS number 7/2G is mentioned, my lords. And in the written statement before the civil court, I have taken a contention that I am on a government land where my occupation has been regularized by virtue of section 94C of Karnataka Land Revenue Act, my lords. My humble submission before this honorable court is, when they are agitating before the civil court on the very same allegations, they cannot invoke criminal process.
Where is the plaint?
Plaint is at annexure G, my lords, page 77.
Page 77.
Plaint is filed on 25th July 2019, my lords. Page 83 may be relevant, my lords.
93.
83.
83.
Page 83.
Why?
Page 6 of the plaint. It is for this reason, my lords. Shri Nandi, son of Ravindra Babu, after executing the said power of attorney, the power of attorney has negotiated with the illegal occupants and convinced them and made them to vacate on their own. The power of attorney holder has dealt and vacated the families on humanitarian grounds. He has given financial assistance to have their alternative accommodation. Defendants' families have not vacated from their respective properties. And my lords may kindly take the schedule. A schedule is at page 88, my lords. A schedule, they describe the entire property of TS number as the property of the plaintiffs and complainants as TS number 72G. B schedule, which is in the occupation of the defendants. And C schedule, my lords.
Where is the private complaint?
Private complaint is at page number 16, my lords. Even in the private complaint, page 22, my lords. Sorry. Page 5, my lords, para 7. It is pertinent to submit that after the execution of the agreement and power of attorney, the power of attorney holder of the complainant has persuaded the trespasser.
Verbatim similar.
Verbatim similar. The only object is, my lord, civil suit will take a longer course. That's what they have resorted.
That's what they have said.
No, that's what they have resorted to by filing a criminal case.
They have said so?
Indeed, my lords. I have not vacated. That's why we have.
Right.
Please, they have not.
One moment.
Yes, sir. My lord, may I take your lordships to the charge sheet runs to 568 pages, wherein the petitioner accused.
568 pages.
Howdu. Or hake illa. Last time I had placed before adu spiral binding iro file. May I take your lordships to page 8.
Sir, documents collected during charge sheet run to 568.
I want to demonstrate your purpose. Fraudulently, the petitioners forged and created false documents with false signature and false seals to grab my property. That has come in the charge sheet papers. May I take your lordships to page for a minute 105. It's a comprehensive map of my property, wherein, my lord, my property consists of a lodging, a commercial complex. During the time of construction, certain worker sheds were constructed. They occupied the worker sheds. And, my lord, when I tried to evict them, they manipulate the government records. For a minute, I want to take your lordships to.
There is a manipulation of government records.
I'll directly take your lordships to page 191. It is the endorsement issued by the Assistant Director of Land Records.
What is that?
ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದಂತೆ ಬಳ್ಳಾರಿ ನಗರದ ವಾರ್ಡ್ ನಂಬರ್ 15 ಬ್ಲಾಕ್ ನಂಬರ್ 1 TS ನಂಬರ್ 7 ಜಿಲ್ಲೆ ದಾಖಲೆಯನ್ನು ಕೋರಬೇಕು ಉತ್ತರಿಸಿದೆ. TS ನಂಬರ್ 72G ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹುಸೇನ್ ಸಾಬ್ ತಂದೆ ದಾದಾ ಸಾಹೇಬ್ ಖೈರೋಜ್ ಬೇಗಂ ಸೋ ಅಂಡ್ ಸೋ ಈ ಮೇಲ್ಕಂಡ ಹೆಸರಿಗೆ ಸದರಿ TS ನಂಬರ್ ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಾಗಿ ಖಾತೆ ನಮೂದಾಗಿಲ್ಲ ಹಾಗೂ ಈ ಕಚೇರಿಯಿಂದ ನಕಲುಗಳು ವಿತರಣೆಯಾಗಿರುವುದಿಲ್ಲ. So the original map is in the next page, my lord.
Manipulation.
My lord, I will take your lordship. The original map in respect to 72 is at page 192. Now I took your lordships to page 193 consists of the municipal records in the complainant's name. Now, my lord,
ಅವರು ಮ್ಯಾನಿಪುಲೇಟ್ ಮಾಡಿ ಅವರ ಹೆಸರು ಹಾಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದೆ.
ಅವ್ರು ಹೇಳ್ತೀನಿ, my lord. I take your lordships to page 218.
I'm there.
Yes, this is the fake creation in the name of D. Muhammad Javed. Seal, everything. This is a map created by the petitioners accused. E map base itkondu municipal records ಅಲ್ಲಿ ತಮ್ಮ ಹೆಸರು ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂತಾರೆ.
ಎಲ್ಲಿದೆ ಎಂಟ್ರಿ ಮಾಡಿ?
My lord, next page, my lord. Page 219. D. Muhammad Javed and D. Hussain Saab.
ಆಮೇಲೆ
Now, the very important document, I take your lordship, page 396.
ಇದಾಗೋಯ್ತಾ?
ಹೌದು.
ಆಮೇಲೆ
396.
I am there.
396, my lord. in respect of 7-2Z. ಸದರಿ TS ಮತ್ತು ನಕ್ಷೆ ಮತ್ತು PLR LR ದಾಖಲೆ ತಾವು ಕಡತ TS 7-2Z
ಕೇಳಿರೋ ಕಡತ ಇಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ರೆ ಅದೇ ಕಡತ ಅದು.
ಈ ದಾಖಲೆ ಈ ಕಚೇರಿಯಿಂದ ವಿತರಣೆ ಆಗಿರುವುದಿಲ್ಲ because the page 192, my lord, is a fake name that has not been issued by this office. It's a sheer creation. And my lord, when they wanted to grab my property, the matter is covered by the latest judgment of the Honorable Appeals Court.
First books the facts, ಆಮೇಲೆ ಲಾಗ್ ಹೋಗೋಣ.
Yes. So here, my lord, these documents are created. And in his statement, the accused statement recorded, my lord, page 502. This is in response to the IO.
502.
ಹೌದು. Relevant page 502. ತಾವು ಕೋರಿದ TS ನಂಬರ್ 72Z2 ವಿಸ್ತೀರ್ಣ 8 ಅಡಿಗಳು ಇರುವ ಆಸ್ತಿಗೆ ಸಂಬಂಧ ಬಳ್ಳಾರಿ ಭೂ ದಾಖಲೆ ಸಹಾಯಕ ನಿರ್ದೇಶಕ ಕಚೇರಿಯಿಂದ ಪಡೆದುಕೊಂಡ ಮೂಲ ಸರ್ವೆ ನಕಾಸೆ ಈ ದಾಖಲೆ ನನ್ನ ಕಡೆ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. It is very clear that they created the fake document with fake seals. The Assistant Director of Land Records clearly certifies at P96 that there is no survey sketch conducted and his office has not issued such survey sketch. When his office is not issued, by the fake creation, they get the name as entered into property records. And now they claim that it's a government property.
ಅವ್ರ ಹೆಸರು ಎಂಟ್ರಿ ಮಾಡಿದ್ಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೆಂಗೆ
ಅವ್ರಿಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದೇ ಹೇಳಿದ್ರು, ಸರ್ಕಾರಿ ಆಸ್ತಿನಲ್ಲಿ ನಾವು ಕಬ್ಜನಲ್ಲಿ ಇದೀವಿ ಅಂತ. For this site of, once again take your lordships to page 105, the comprehensive map wherein 7-2Z is clearly demonstrated. ಅಂದ್ರೆ ಒಂದೇ compound, it runs to around 78,000 square feet total extent. And hence, my lord, they, because who else can create the documents to gain the property illegally? It is not none but the petitioners accused. And the charge sheet material, the statements of the certificate issued by the survey officers clearly reveal that the government office has not issued. Even the municipal corporation has also, my lord, issued a show cause notice to them as to why the municipal entries cannot be cancelled because the documents are fake in view of the endorsement issued by the DDLR. And my lord, this honorable courts, my lord, the Honorable Appeals Court, in the latest judgment, my lord, last time put it in judgment.
ಕಾತ್ಯಾನಿ ಆಮೇಲೆ.
Yes. So the case law has been clearly discussed.
Case law has been dismissed.
Discussed.
All right.
Yes. For a minute, my lord, I want to take your lordship para 19. We now come to the issue of bar against prosecution during the pendency of a civil suit. We hereby hold that no such bar exists against prosecution if the offence is punishable under criminal law or made out against the parties to the civil suit. Learned senior so and so has rightly pleaded that the relevant judicial precedents to support the above submission. In the case of K. Jagdish Vijay Kumar and another, this court has reviewed its precedents which clarify the position. The relevant paragraph from the above judgment is extracted below. It is thus well settled that in certain cases, the very same set of facts may give rise to the remedies in civil as well as criminal proceedings, and even if a civil remedy is available by the party, he is not precluded from setting in motion the proceedings in criminal law. And my lord, the Pratibha Rani versus Suraj Kumar and another, that also has been discussed. So here, the entire charge sheet material clearly reveals that it is the petitioners accused and petitioner accused only illegally. They have manipulated the survey records, manipulated the municipal records based on that. And there is an inquiry, show cause notice issued by municipal corporation. And hence, my lord, in the light of the latest judgment, July 2025 of this year, my lord, pray your lordships to dismiss the petition. Let them face and demonstrate their bona fideness before the trial court.
What do you clarify with those three documents?
With regard to three documents, page number 105, my lords, may kindly peruse. There is a road running in between the properties adjacent to their property. With regard to page.
What is that manipulation you have done?
My lords, there is no manipulation. They say that because survey department has assigned a TS number as 272G/2, they say that it is their property. Page 193, page 100, page 192, my lord, their property.
Anyway, civil suit pending ideyalla.
Indeed, page 192, their property is intact till today. We are not in their property. We are outside their property. But the only problem what they are having is, if my lords peruses page 105, after their property, there is a government property which is a road. we have been regularized in front of their property. They are having a shorter access to the main road. That is their grievance. To remove us, they are alleging that we are in their property.
Yes.
They are trespassers and they have entered into our properties, and that's how.
Government regularize ಮಾಡಿದ್ಯಾ ನಿಮ್ಮ possession?
That is the defense taken by me in the written statement.
Allah. Their stands before the trial court as well, this court is most confusing one. They want to confuse. They want to put up false facts because.
ಯಾರಿಗೆ confusing?
ಅಂದ್ರೆ ಈ properties within my properties, my lord, ಈಗ disputed property.
Who is getting confused?
They are confusing. ಅದು ನಮ್ದು ಗವರ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ, ರೋಡ್ ಇದೆ, ಆಚೆ ಇದೀವಿ, ಈಚೆ ಇದೀವಿ ಅಂತ.
ಅದಕ್ಕೆ ಕನ್ಫ್ಯೂಸಿಂಗ್ ಹೂಮ್ ಅಂತ. ಕೋರ್ಟ್ ನಿಮ್ಮನ್ನ ಯಾವ್ದನ್ನ?
ಎಲ್ರು.
ಹೌದಾ? ಕೋರ್ಟ್ ನ ಹೇಳಿಬೇಡಿ ಅದಕ್ಕೆ.
ಪ್ಲೀಸ್.
ಎಸ್. Heard reserved.
Obliged.
22 Ganesh Raibagi.
Last time this honorable court was to pronounce the judgment.
Pronounce,
but at the interpretation of the other side, it was adjourned.
Lord, I appear.
Last time.
Lordship says last time directed them.
Contest of issue.
Lord, as on today, the writ petition become infructuous.
Why?
Lord, kindly see, Lord, under section 13, the body as well as the annual audit report has been accepted for the year 2024-25. Now, in pursuance of the stay order that has been continued for the year, my lord, the 25-26 general body meeting was called for, and new body has been accepted.
It is.
challenge ಮಾಡಿಲ್ವಾ?
Challenge that I has filed before this honorable court.
All the general, I have produced, my lord, the general body proceedings and the, my lord, the approval order.
Impugned orders, to stay that impugned order, I1 has been filed.
Page number 18 is the body, my lord.
So, ಈ body ಇವ್ರು ಇಲ್ಲ ಈಗ?
ಇಲ್ಲ.
Body is in existence, Your Honor. The stay is granted and the
stay
still
is for
in
the
force.
suspension.
And the respondent won by violating the stay order.
13 to 2025 have passed an order of interim order as spread for ಅಂತ ಇದೆ.
Yes.
ಯಾವತ್ new body ಯಾವಾಗ?
Kindly see, my lord, page number 34 in writ petition. For the writ petition. Your lordship's got it, my lord? 34, 2411, 24-25 ಸಾಲಿನ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯ ಸದರ ಪಟ್ಟಿ. This was approved earlier, which was, my lord, kept under suspension. That is why they, my lord, approached this honorable court. This honorable court has stayed, this body has continued. Now, for the academic year, for the year 2025-26, general body meeting was called for. I produced the, my lord, all the
This is
proceedings.
for 2024.
Yes, 24-25. Now he has filed application for a stay of this order. He has not challenged. In that, he himself has admitted that, my lord, the yearly meeting was called.
Yes.
My lord.
If you want to challenge that order.
My lord, I have filed the as IA.
IA for
challenge
what?
that order. Challenge
Stay ಆಗಲ್ಲ, first challenge ಮಾಡಿ. Challenge ಮಾಡಿ stay ಕೇಳಬೇಕು. If you want to do it. Otherwise, as I said, it is over now.
My lord, my lord.
Challenge ಮಾಡಲ್ವಾ?
That the present.
You don't want to challenge it?
Challenge ಮಾಡ್ತೀವಿ sir. The previous management which is in existence has the power to summon the general body meeting. The present person who has no concern to the Samiti is not at all in existence. The secretary, that is the local MLA, by influencing, by created in the documents and dominated the respondent and dominated the respondent and dominated the respondent and managed to get the illegal approval order against the existing committee. My lord.
ಈಗ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದು.
ಚಾಲೆಂಜ್ ಮಾಡ್ತೇವೆ, ಅದು I1 ಹಾಕಿದ್ರೆ ಸಪರೇಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತೇನೆ ಸರ್. ಮಾಡ್ತೀನಿ ಸರ್.
ಈ ಸಪರೇಟ್ ಪೆಟಿಷನ್ ಹಾಕ್ತೀರಾ?
ಪೆಟಿಷನ್ ಹಾಕ್ತೇನೆ ಸರ್.
ಹಾಕಿ.
ಎಲ್ಲ ಕೈಂಡ್ಲಿ ಪರ್ಮಿಟ್ ಟು ಅಮೆಂಡ್ ದಿ ಪೆಟಿಷನ್.
ಅಮೆಂಡ್ ಮಾಡಿ ಚಾಲೆಂಜ್ ಮಾಡಿ, ನಾಟ್ ಸೀಕಿಂಗ್ ಸ್ಟೇ. ಇಫ್ ಯು ವಾಂಟ್ ಅಮೆಂಡ್ ಇಟ್. ಬಟ್ ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಆಗಲ್ಲ ಸ್ಟೇಗೆ. ಯು ಹ್ಯಾವ್ ಟು ಚಾಲೆಂಜ್ ದಿ ಎಂಟೈರ್ ದಿ ನ್ಯೂ ಆರ್ಡರ್.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸರ್. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಸರ್, ಹಾಕಿಲ್ಲ, ಹಾಕ್ತೇನೆ ಸರ್.
ಮತ್ತೆ
Yes, remedy under section 25. Or the
Senate counsel appearing for the respondent Sunil Desai submits that the petition is rendered infructuous in the light of the subsequent development. The learned counsel of the petitioner seeks time to challenge the said subsequent action. The 2 weeks time is granted.
Humble submission, 1 week time, my lord. 1 week time, my lord.
1 week.
And my humble submission is stay the
No, no, no.
connection.
First challenge ಮಾಡಿ ಆಮೇಲೆ. Without challenge, I can't stay. Yes. Next.
Please.
Number 23, Anil Kade. Shan Ganpati.
Vacating stay.
Please. The earlier stay order has to be continued, my lord.
That will continue.
Lord, in this, my lord, I am filing a memo. Lord, giving the particulars, my lord, yesterday, my lord, I have submitted. my lord,
Substance allowance ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಅದು my lord 3,17,800 ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಕೌಂಟ್ ಅಲ್ಲಿ. Today he had been to my lord withdraw the amount. Lord, it is stated that amount is not there, and he was asked to furnish his personal account, and they told him that it will be deposited to his personal account.
ಡೆಪಾಸಿಟ್ ಆಗಿಲ್ಲ ಇನ್ನು.
ಆಗಿಲ್ಲ. ಇವತ್ತಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ. ಇವತ್ತು ಹೋದ್ರೆ 20,000 ಇದೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಆಮೇಲೆ ಬ್ರೇಕಪ್ಸ್ my lord, I have, it is not 3,17,000.
Lords, we have deposited that in his account. Now, my lords, he had come to the bank today.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಎಷ್ಟು ಬರ್ಬೇಕು? 371 ನ?
My lord, total,
we have
my lord,
paid, we have
total he is
deposited in his
entitled.
account. Adra RTGS ಮಾಡ, he has given an account, my lords, where we are RTG.
I'll take it at 4 o'clock. Get the demand draft here.
My lord,
Please.
Get the demand draft of 371 here.
Please.
Yes.
total due
I'll
is.
pass it over. Total ಎಷ್ಟಿದೆ?
Total, my lord, total due is, my lord, that is 12,02,500.
ಏನ್ substance allowance?
As my lord, I have given the details in memo.
ಯಾವತ್ತು ಸಸ್ಪೆಂಡ್ ಆಗಿದ್ದು?
My lord, he was suspended on
November
my lord,
2024.
November 2024. Prior to that 12 months, my lord, he was salary is due for, my lord, 50, my lord, it is total
ಆಮೇಲೆ we'll see.
58,500.
Subsistence suspend ಆಗಿದ್ದು ಯಾವತ್ತು ಅಂದ್ರೆ?
Suspend ಆಗಿರೋದು, my lord, that is on December 2024. November 2024, he was suspended.
ಇಲ್ಲಿವರೆಗೂ ಕೊಟ್ಟಿಲ್ಲ.
ಅದರದ amount, that amount would be, my lord, 5 lakhs.
No.
75%.
Where is that?
My lord, second salary due after suspension.
No, the calculation is that, my lords, he has taken 75% of the salary. As per, my lords, the bylaws, 50% of the salary. That we have calculated,
Bylaws I have produced.
and, my lords,
bylaw ಎಲ್ಲಿದೆ?
My lord, along
I
with the
just
memo.
pass on, my lords, relevant portion
Where
of
is the
that.
bylaw?
14.2, my lords, I am passing on, my lords, the, what we have done, my lords, first 6 months, 50%. 14.2.
50%. 6 months.
Thereafter, 75%. This is how we have calculated, and 3,71,000, my lords, has been deposited.
Along with the, my lord, memo dated 7/11/2025.
ಈಗ bylaw ಇದು ಕರೆಕ್ಟಾ?
Bylaw ಅಲ್ಲಿ 75% ಅಂತ ಇದೆ.
50% ಅಂತಿದೆ.
ಇಲ್ಲ. Bylaw, my lord, copy of the bylaw itself I have produced. Page 26, my lord, page 28, 20, 22, 23. Page 23. Internal page 26 ಅಲ್ಲಿ. Item number 5.
ನೌಕರರು 6 ತಿಂಗಳ ಮಾತ್ರ ಅಮಾನತುಗೊಳಿಸಬಹುದು. 6 ತಿಂಗಳ ನಂತರ ಅವಧಿ ನೌಕರನ ಅಮಾನತಿನ ವೇತನ ಶೇಕಡ 75. ಅದೇ after 6 months.
After 6 months, 75. That is
Now
how we
after
have
6 months
calculated.
were.
6 months ಆಯ್ತು. ಇನ್ನು not from the beginning 75% ಅಲ್ಲ. 50% for 6 months. If it is not revoked after 6 months, it is 75%. ಈಗ ಎಷ್ಟಾಗುತ್ತೆ ಅದಕ್ಕೆ?
ಈಗ now, my lord, 3,17,000.
71,000.
Now, my lord, he is due of, my lord, that 12 months salary. That is also not paid.
Salary is prior to that. We are not on that. First substance allowance ತಗೊಳ್ಳಿ.
Lords, one submission, my lords. Lords, these things are brought into this particular case, my lords, to drag on the matter. Now, my lords, by November 20th, no, we will pay, my lords.
Enquiry stay ಆಗಿದೆಯಾ?
Enquiry stay ಆಗಿಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾಯಿಲ್ಲ enquiry?
Because of, my lords, the suspension order is stayed, and we had filed, my lords, vacating application.
I will clarify that enquiry will go on.
Please,
First get the DD at 4 o'clock.
Please.
ನೀವು ಎಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಡಿ, DD ತಂದು ಇವ್ರ ಕೈಗೆ ಕೊಡಿ.
Because morning, my lords, had come to the bank, we had, my lords, made all preparations for sending it by RTGS also.
No, don't prepare anything, sir.
Please.
You prepare the DD and come here.
Please.
I'll call it at 4:30.
ಅಕೌಂಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅದರದೊಂದು ರಿಸಿಟ್ ತಂದ್ಬಿಡು. Because
ಅಕೌಂಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ.
our ಅಕೌಂಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ, we will, my lords, at 4 o'clock, my lords, I'll produce the, please.
ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ
ಇಲ್ಲ, we will, my lords,
cost impose ಮಾಡ್ತೀವಿ.
No, my lords, we will do that, my lords, that is not an issue. The problem here, my lords, by November 20th, that 1 year period of suspension will also expire. And that is what they want. My lords, for last 22 years, my lords, he is sitting there.
That's all right. I'm not on that.
I will, my
You
lords.
get the demand
Please.
draft. I will clarify the order that the inquiry will go on despite this day of suspension.
Inquiry, my lords, in fact, report is also submitted. We have issued him a second show cause notice for that
To
also.
take it to its logical conclusion, this proceeding will not come in the way of inquiry.
Please.
Salary ಎಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ. First substance allowance ತಗೊಳ್ಳಿ.
Filed application also not in that.
For what, sir?
Release of salary for 12 months.
There is a
Why
loan.
salary is not paid?
My lords, that is why the earlier body, my lords.
No, no, same body. 2023, my lord, this
20
body has.
My lords,
You
9.5 lakhs, my lords, loan he
You
has
forget
raised
about
without
it.
authority.
Body or no body, but salary, why it
Salary,
is not?
my lord, that is not an issue at all. The issue is now, my lords, purposely brought in to drag on the matter.
We'll see. Yes.
4 o'clock, my lords, I'll produce, my lords.
First substance allowance, ಆಮೇಲೆ we will
Please,
see what
please,
is to be.
please.
Next.
24, Karthik Nikari.
Petitioner, my lords. My lords, this is a matter pertains to
Yesterday-
article of charges issued 4
Yesterday
years
I
Close
prior.
ಮಾಡೋಣ. 171B.
My lords, tomorrow, my lords,
Eh?
senior.
What is all this yesterday and the today, today and the tomorrow? Why senior
Well,
wants to appear?
Senior has to appear, my lords.
We'll
since
put
it's a
senior's name, don't worry.
My lords, since it's a corporate matter, my lords, and
He's not there.
no, my lords, he's out of station. That's why I requested yesterday as well. Tomorrow, my lords, please. Tomorrow.
Tomorrow in fresh.
It has to be allowed. She also knows. But ಅವ್ರು ಬಂದಾಗ ಆಗ್ಲಿ.
Yes, my lords. tomorrow.
In fresh matters list.
Fresh matters.
Great.
ನಾಳೆ ಬರ್ತಾರಾ?
Yes, my lords.
Yes.
Number 25. Ail Patil. Then ready Gonde.
Yesterday's matter. I've given one judgment, my lords.
That is not applicable, sir.
My lord, suit is maintainable, my lords, in view of, my lords, by referring
Suit
the
is
judgment.
maintainable.
Suit is maintainable before civil court, my lords, the surface matters involved.
Here is not suit, not challenging. Suit, in suit, I am not a party. That order will not bind.
Sir, sub-register has to register it, no choice.
My lords, I'm not, my lords, the in view of, my lords, the judgment which I given, my lords, in view of, by referring this judgment, the Delhi High Court division bench has held that.
ಅಷ್ಟೇ ಸರ್ಫೇಸ್ ಪ್ರೊಸೀಡಿಂಗ್ ಯಾವ್ದು ನಡೆಯಲ್ಲ, ಎಲ್ಲ ಸೂಟ್ ಹಾಕ್ಬಿಟ್ಟು ತಗೊಂಡ್ಬಿಡ್ತೀವಿ.
My lords, my right has to be protected, my
What
lords.
right, sir?
Ultimately, my lords, my
What
father
right?
has been sold the property.
Partition suit ಯಾವಾಗ ಹಾಕಿರೋದು ಸರ್?
My lord, subsequent.
ಮತ್ತೆ
My lords, but in this judgment, my lord, the subsequent suit has been instituted by the daughter. That was the counterclaim has been filed a rejection of plaint. The rejection of plaint has been allowed by the, my lords, trial court. My lords,
This is not regarding rejection of plaint.
ಅಲ್ಲ,
You are
No,
confused. This is, I am not a party there at all. I am
ಅಲ್ಲ,
not party there at all. They have taken injunction order and then that is covered squarely by your lordship's.
I have
judgment.
already written this, sir.
Yes, squarely page 3 and page 6, my lord. Page 3, clause 4 and page 14.
my lords, ultimately, I will,
Page 14 clearly.
One, my lords, in my
Same
suit.
exactly similar point.
in my suit, my lords, my father has been contested my suit, my lords.
Page
at least-
14. Last even observation ಮಾಡಿದ್ರಿ ಮಿಸ್.
Lords.
ಇದು ಬರೀ ಫಾಲೋ ಮಾಡೋದು ಅಷ್ಟೇ.
ಅದರಲ್ಲಿ ಸೇಮ್
Division bench civil court has granted certain orders which.
ಅದು called out, my lords, take my lords.
In this also we are not party to that suit, that injunction that is there.
The Punjab Haryana High Court Division bench also,
ಮಾಡಿ.
that is confirmed to Supreme Court also.
My lords,
And in this case, same, we are not party and it is not affected.
my lords, one para ಓದ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ last
ಓದಿ
Supreme Court last.
ಓದಿ sir.
Before we close the this litigation, we deem it necessary to observe the bank should be remain every careful, indicate title clearance report, more particularly when such report obtained cheaply and times for external reasons. This concern the protection of the public money and is in the larger public interest. Therefore, it is essential for the Reserve Bank of India to other stakeholders and collaborate in developing this standardize the practical approach of the preparing title search report before sanctioning loan and also for the purpose of determining liability, including the potential criminal action on the officer who approves the loan. Additionally, there should be a standard guidelines for fees and cost associated with the title search.
ಅದಕ್ಕೂ ನಿಮಗೂ ಏನ್ ಸಂಬಂಧ?
At least they have to search, my lords, who are the LRs and who are the
ಯಾವ್ದು
share
suit
holders.
ಹಾಕಿರೋದೇ ನೀವು ಅದ ಮಾರ್ಟ್ಗೇಜ್ ಆದ್ಮೇಲೆ.
ನನಗೆ ಗೊತ್ತಾಗಿರೋದು ಯಾವಾಗ ಸ್ವಾಮಿ?
ಅದೇನ್ ಮಾಡೋದು? that is their secured asset, sir. If
lords,
this is,
if
if
I
this is
succeeded
permitted,
in-
I'll tell you, your father will raise a loan of few crores.
Please,
ಆಮೇಲೆ children will file partition suit amongst themselves and take away the secured asset.
my lords, if I
Yes,
succeeded in the
you
suit, my
can't,
lords, what,
can't do that.
my lords, if I,
What happens to the money that your father has taken? ವಾಪಸ್ ಕೊಡೋದು ಬೇಡವಾ? Are you prepared to give it back? Are you prepared to give it back? Tell me.
my lords, ನನ್ನ
ದುಡ್ಡು ಕೊಡ್ತೀರಾ ನೀವು ವಾಪಸ್ ಎಲ್ಲ ಲೋನ್?
ನನ್ನ ಸೇರಿಗೆ ಎಷ್ಟು ಬರುತ್ತೆ?
ನಿಮ್ ಶೇರ್ ಇನ್ನೂ ತೀರ್ಮಾನನೇ ಆಗಿಲ್ಲ, ದುಡ್ಡು ಕೊಡ್ತೀರಾ ವಾಪಸ್ಸು?
My lords, ನನ್ನ ಸೇರಿಗೆ ಎಷ್ಟು ಬರುತ್ತೆ? I am ready to pay.
This is what will happen. In every loan account, then there will be partition suits after the, ಈಗ ಹೆಂಗೆ ಇದಾದ್ಮೇಲೆ acquisition ಬರ್ತಾ ಇದೆಯಲ್ಲ, ಆ ತರ ಆಗತ್ತೆ ಇದನ್ನು. Acquisition ಆದ ತಕ್ಷಣ ಎಲ್ಲಿಂದನೋ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಕಮ್ ಪಾರ್ಟಿಷನ್ ಸೂಟ್.
At least, my lords,
ಅಂಡ್ ಅಕ್ವೈರ್ ಆಗ್ತಾ ಇದೆ ಅಂದ ತಕ್ಷಣ.
subject matter, my lords, outcome of the suit, at least, my lords.
I'm not, bank is not a party barely because.
No, bank
injunction orders.
party or not a party is a different thing.
And
That doesn't mean that their secured asset under the statute will be taken away by a partition suit subsequently instituted. None of the judgments are applicable to you. If ಬಿಟ್ಬಿಟ್ರೆ ಆಯ್ತು, ಬರೀ partition suits ಆಗುತ್ತೆ. One law, if you lay down like that, finish.
My lords, ultimately, my
10
lords,
ಕೋಟಿ
if I
ಲೋನ್ ತಗೊಂಡು 10
succeeded in,
ಕೋಟಿನ ವಾಪಸ್ ಕೊಡ್ಬೇಡಿ, ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕ್ಬಿಡಿ, ನನ್ ಶೇರ್ ಅಂತ ಅಲ್ಲಿ ಸ್ಟೇ ತಗೊಂಡ್ಬಿಡಿ ಅಷ್ಟೇ, ಫಿನಿಶ್. ಬ್ಯಾಂಕ್ ಹೋಯ್ತು.
at least outcome of the suit, my lords. If I succeeded in property, in suit, my lords,
there are a lot of other properties also, you will get your share, there is no problem.
Not at all. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, are you prepared to clear the loan?
please, my lords.
Are you prepared to clear the loan?
My lords, ನನ್ನ ಸೇರಿಗೆ ಎಷ್ಟು ಬರುತ್ತೆ? As per
ಶೇರೇ
instructions,
ಗೊತ್ತಿಲ್ಲ, ಇನ್ನು ನಿಮ್ ಶೇರಿಗೆ ಬರುತ್ತೆ ಅಂದ್ರೆ
my lords, if I succeeded in suit per month,
difficult.
please.
This Punjab and Haryana has clearly held what is to be done, which I have followed. There are 2 other orders we will write tomorrow. ಹಾಕಿರಿ. ನಾಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
Please, please.
Yes. ರಿಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅದು ಪೈಲಪ್ ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ ಅದಕ್ಕೆ. Yes. Next.
ನಾಗರಾಜ್ ಅಪ್ಪನ
Second, challenging the annexure C lordship. Second respondent lordship issued a notification for appointment of Anganwadi teacher lordship for reserving the SC community lordship. In that locality lordship, there is no SC community lordship.
Yes, madam.
Your lordship, we have filed a memo dated, your lordship,
What is the
28/10.
SC community
75 families are there, your lordship.
ಎಷ್ಟು ಫ್ಯಾಮಿಲಿ ಇದೆ?
76 families, your lordship. Total population 455, your lordship. Along with the.
ಮತ್ತೆ ಇದೆಯಲ್ಲ ಸಾಕಷ್ಟು.
ಕೇಂದ್ರ 1.5 ಕಿಲೋಮೀಟರ್ ಒಳಗಡೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ.
ನೀವು ಎಲ್ಲ ಊರೆಲ್ಲ
ಊರಲ್ಲಿ ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, with that
1.5
area, your
kilometers ಅಲ್ಲೇ ಅಷ್ಟು ಜನ ಇದ್ದಾರಾ?
ಹೌದು.
ಹೌದಾ?
ಬಟ್ ಸ್ಥಳೀಯತೆ ಅಂತ ಮಾಡ್ಬೇಕು, ಅದು ಮಾಡಿಲ್ಲ ಸರ್. ಲೋಕಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಮಾಡ್ಬೇಕಂತಂದು ಸರ್ಕ್ಯುಲರ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 13.
ನೀವ್ ಯಾರು?
ಲೋಕಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಲಾರ್ಡ್.
ಈಗ ಯಾರನ್ನ ಮಾಡಿದ್ದಾರೆ?
SC community law, reserving for SC community law.
No, your ground is
not SC.
there are no SC families there. Now SC families, 76 families are there. So
Instead of SC community lordship, it is reserved for backward community ಅಂತ ನಮ್ claim ಇರೋದು.
Anything else, sir?
Nothing.
The petitioner is before this court, calling in question a notification dated 23/9/2024, which seeks to call for applications for appointment to the post of Anganwadi helper.
Helper, your lordship.
Anganwadi helper in what area idu?
Anganwadi worker, your lordship.
Anganwadi worker in
Kariyamma camp.
Kariyammana camp.
ಬೊಮ್ಮಸಾಗರ ಕರಿಯಮ್ಮನ ಕ್ಯಾಂಪ್.
ಬೊಮ್ಮಸಾಗರ ಕರಿಯಮ್ಮನ camp. Please. The petitioner, you participated, is it?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಪಾರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ.
The petitioner is said to have been left out in the participation on account of the post reserved for scheduled caste or scheduled tribe community candidate. The petition is on a slender ground that there are no SC or ST families within 1.5 kilometers of Bommasagar Kariyammana camp for calling applications exclusively for them in the said exclusively for them to the post of Anganwadi helper. The learned counsel would seek to place reliance upon the circular which clearly indicates that the SC or ST community must have adequate representation within 1.5 kilometers of the Anganwadi camp. The learned HCGP on instructions, memo ಹಾಕಿದ್ದೀರಾ madam?
File, memo file.
The learned HCGP has filed a memo of inspection and on instructions would submit that that within 1.5 kilometers radius, there are 76 scheduled caste or scheduled tribe families residing in Bommasagara Kariyamana camp. And therefore, the reservation has come about in terms of the circular. There is no reason to doubt the inspection report that is placed before this court pursuant to a direction of the coordinate bench. In the light of 76 SC or ST families in existence in the within 1.5 kilometers radius of Bommasagar Kariyamana camp, the petition on this slender ground would not become entertainable and the notification to be quashed on the plea of the petitioner that it ought to have been reserved for even backward classes and not only reserved for SC or ST. The notification being in tune with the circular, there is no warrant of interference. The petition lacking in merit stands rejected. Next, please.
Number 27.
Your Lordship, in this matter,
Petitioner. On 311, my lordships had directed the state and the inquiry officer to file an affidavit as to why 8 years delay has been caused in conducting the disciplinary inquiry.
Your Lordship, from the beginning, Your Lordship, we have appointed in officers, Your Lordship, but they have not submitted any report.
Oh.
And finally, Your Lordship, again, we have changed the investigation officer. Now, again, one more officer has been appointed. With if opportunities given, Your Lordship, will complete the investigation, Your Lordship. And,
Investigation,
investigation,
inquiry.
sorry, inquiry. Inquiry.
Anil Kalevri ಯಾರಿಗೆ?
Lord, here, Lord, the annexure F, what is challenge is, Lord, initial order of Lord appointing an inquiry officer.
ಲೋಕಾಯುಕ್ತ ಕೊಟ್ಟಿದ್ದಾರಾ?
ACB, my lords.
B report ಹಾಕಿದ್ದಾರೆ against.
ನೀವು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದೀರಾ?
B report ಹಾಕಿದ್ದಾರೆ. Lord, he is the petitioner, he is the Lord person who was working on a contract basis in a corporation.
My lords.
Lord, the rate, my lord, the trap was taken place. The trap was successful on the my lord person who was a contract employee. Petitioner is the my lord SDC working in a corporation. My lord, therefore, charge sheet was not filed against him since there was no demand and acceptance by this petitioner. Only charge sheet was filed against the my lord that person Parameshi. Against him, my lord, charge sheet we could not file charge sheet.
So you have dropped him from the proceedings.
There is no case against him. There is no case against him.
ಮತ್ತೆ ಏನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್
ನಮ್ಮದು ಯಾವುದು ರಿಪೋರ್ಟ್ ಇಲ್ಲ indicating that petitioner ಇದರಲ್ಲಿ misconduct is my lord what alleged is not demand and acceptance. Misconduct is my lord that he has handed over the keys of Almera to that Parmeshi who is not a my lord employee of the corporation. On that basis inquiry is
Annexure F, my lords.
ಈಗ 6 are exonerated.
All are exonerated. I have been continued with the departmental proceedings on the pretext that I had not submitted my reply. But annexure E is my reply, my lords, which I had submitted well within time.
You are still in service, Allah?
I have attended superannuation, my lords.
When?
July 2025, and my retirement benefits are withheld.
Not paid?
Not paid, and not settled, my lords. And in the criminal case also, it is ended in acquittal. I have been settled as CW5.
Complaint witness ಮಾಡಿದ್ದಾರೆ.
Complaint witness.
he was a witness in the prosecution.
Sorry, all right.
Allah, he is the petitioner who was the witness. He is not a complainant.
No, CW charge sheet witness ಅಲ್ಲಿ ನನಗೆ charge sheet witness number 5.
Because of the COVID and mallards, because of the mallards general elections, mallards 3 mallards inquiry officers were changed by the government.
ಯಾಕೆ ಕೋವಿಡ್ ಬಂದ್ಬಿಡ್ತಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ there is an explanation by the
inquiry officers ಕೋವಿಡ್ ಬಂತಾ?
ಇಲ್ಲ, due to COVID and mallards general elections to the mallard Ballari. So mallards my submission is that mallards my instruction is that now mallards now fresh inquiry officer is mallards appointed. And mallards if the mallard inquiry
submit within if time is granted, Your Lordship.
3 months ಒಳಗಡೆ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು direction. Since mallards the 3 officers were unable to mallards perform the duty of the inquiry officer.
Why, sir?
Not submitted report, Your Lordship.
Yes, sir, proceedings were conducted. This is what my information. 2 times mallards the proceedings were conducted before the inquiry officer. Now mallards government had mallards appointed new inquiry officer. This is what mallards instruction with.
Even letters were also written to the
That
investor.
order is not in challenge.
appointing
of a fresh officer.
one middle court is my lord's inquiry officer to hold an inquiry.
Subsequently on 15/11, your
15/11
lordship
ಗೆ.
was passed, your lordship.
15/11/2025.
15/11/25, your
ನನ್ನ
lordship.
order
order.
ಆದ್ಮೇಲೆ ಹೊಸ
Because your
inquiry
lordship,
officer
earlier
appoint.
we have written a letter on the 16/11/21, 18/3/22, 23/24. Even we have written many letters to the inquiry officer, your lordship, to submit a report. But as he has not submitted
Against
report.
them. The petitioner is before this court calling in question a notification dated 5/12/2017. Then notification ಏನಿದೆ?
This is.
21. your lordship.
ಅದು already, my lord, that has been merged in some other orders.
Yeah.
This was,
That those are
ಹೌದು.
not.
ಏನಿದು?
ಇದು DE order.
ಅದು ಬೇರೆಯವ್ರಿಗೆ ವಾಶ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಇದಲ್ಲ.
ಮತ್ತೆ ಏನ್ 5/12/2017 ಏನದು?
Lord, that was the initial, my lord, entrustment of inquiry. Thereafter, my lord, there is.
Entrustment of inquiry to whom?
Lord, that was.
Inquiry
appointed-
officer.
Page ಯಾವ್ದು sir ಅದು? Which page is that?
Page 40, my lords.
Page 39 is the operative portion.
Annexure F, my lords.
Inquiry officer.
Annexure F, entrustment
Appointment,
order.
appointing my lord's inquiry officer.
5/12/2017. my
ಇದು
lords.
ಲೋಕಾಯುಕ್ತ ಕೊಟ್ಟಿದ್ದೇನಲ್ವಲ್ಲ?
ಇಲ್ಲ, my lord.
5/12 is a order my lords, by the government, wherein inquiry my lords was my lords supposed to conduct against the my lords petitioner herein. Appointment of inquiry officer.
Petitioner ಎಲ್ರು ಎಷ್ಟು ಜನದ ಮೇಲೆ?
ಒಬ್ರು ಮೇಲೆ ಅಷ್ಟೇ.
Only against the petitioner.
Which is at my lords page number 39.
ಶ್ರೀ ನೇತಾಜಿ ಅವ್ರ ಫಿರೋಜ್ ಅವರೆಲ್ಲರ ವಿರುದ್ಧ ಕೈ ಬಿಟ್ಟು ಮೊಹಮ್ಮದ್ ಬೋಸ್ ವಿರುದ್ಧ ಮಾತ್ರ.
Page 42, annexure H, subsequent order, latest order.
Page?
Page 42, annexure H. Operative portion 43.
Dated 21.
21/5/21.
Yes, ma'am.
ಇದೇನಿದು?
Is second inquiry officer.
Second inquiry
You have
officer
not
is.
challenged that?
No, my lords.
Why?
Entrustment order is at annexure F, my lords. Thereafter, they have changed 3 inquiry officers. These orders at annexure G and annexure H are with
ಇನ್ನೊಂದು
regard
ಯಾವುದು?
to changing of inquiry officers.
ಇನ್ನೊಂದು ಯಾವುದು? G ಯಾವುದು?
Annexure G is one inquiry order, my lord. Sorry, of appointment of Shri VP Jagirdar as inquiry officer. Annexure H is for appointing BV Prakash as
Page 40.
inquiry officer.
annexure G, my lord, page 40, one more, that is prior to this inquiry.
Where is the exoneration order of all others?
Exoneration order is at annexure F, page 39, my lords.
ಇದು ಯಾರ್ದು? 39
Page 39 ಅಲ್ಲಿ
exoneration entrustment
entrustment ಅನ್ನ ಅವ್ರನ್ನ ಕೈ ಬಿಟ್ಟಿಲ್ಲ.
ಮಾತ್ರ ಕೊಟ್ಟು ಮಾಡಿದ್ದ?
ನನಗೆ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. On the
ಈಗ all 5 people are left off in
left off from the inquiry.
ನಿಮ್ಮ ರಿಪ್ಲೈ ಅಲ್ಲಿ
It is at annexure E, my lords, page 35.
Now enquiry is not conducted, why? The reply ಕೊಟ್ಟಿಲ್ಲ ಅಂತನಾ?
ನಾನು ರಿಪ್ಲೈ ಕೊಟ್ಟು ಶೋಕಾದ್ ನೋಟಿಸ್ಗೆ ನಾನು ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆನ್ ದಟ್ ಗ್ರೌಂಡ್ entrustment order at annexure F is passed. 5/12/2017 order.
So, but that is contrary, you have given your reply.
Indeed, my lord. Without ignoring my reply, this order has been passed. And thereafter, 3 inquiry officers have been appointed. None of them have conducted the inquiry from past 8 years. This issue is covered by my lordship judgment.
ರಾಮಸ್ವಾಮಿ ಗೊತ್ತು.
Please.
Yes. ಯಾರು who had to conduct inquiry? Government?
Please, your lordship.
ಯಾವ್ದು first respondent?
First respondent.
Yes.
UD.
As earlier also, your lordship, we have done our work and appointed the officers to conduct an inquiry, your lordship. But as they have not submitted a report, that is the reason, your lordship.
Why have you kept quiet?
We have written a letter also, your lordship.
You should have placed those officers under suspension.
We have written a letter also.
Dereliction of duty when they don't follow the orders of the government saying that conduct an inquiry.
They are retired judges, your lordship, they have.
Retired judges ಅಲ್ಲ madam appoint ಮಾಡಿದ್ದು.
ಹೌದು.
ಹೌದಾ?
All the my lords,
District judges as inquiry officers.
Now on 15/11 my lords, one more.
ಎಲ್ಲಿದೆ retired judge ಅಂತ?
All the retired judges, my lords. VP Jagirdar is a retired district judge, my lord. And my lord, BV Prakash is also retired judge, my lords.
Then not one day of proceeding happens?
Twice, my lords,
Only
proceedings were.
in the year 2021, one sitting has happened, my lords. wherein they have issued summons to the witnesses mentioned in article of charges. Only one sitting in past 8 years.
The petitioner is before this court calling in question a notification dated 5/12/2017 by which a departmental inquiry is sought to be instituted against the petitioner. Heard, so and so. Facts in brief, germane, are as follows. In the year 2010, it transpires that a crime in crime number 201 of 2010 comes to be registered for offences punishable under section 419 and 420 on a trap that was laid against one Parameshi, who was a task force employee in the CMC. The petitioner was a daily wage employee, Alva?
Parmeshi was daily wage
Oh,
employee. I
Parmesh.
was SDC.
The petitioner was a first division assistant working in the said CMC, in which the said daily wage employee Parameshi was trapped. The issue does not relate to criminal proceedings. On 1/6/2016, the first respondent, Department of Urban Development, issues a show cause notice to the petitioner and 4 others, calling for explanation by initiation of a departmental inquiry. The petitioner submits his reply on 24/6/2016 to the said show cause notice. On 5/12/2017, after about 18 months of the submission of reply, the departmental inquiry is sought to be instituted against the petitioner alone and dropping the inquiry proceedings against others. The reason for continuing departmental inquiry against the petitioner is that he has not submitted his reply, while the other employees had submitted the reply, and against them the inquiry was closed. This happens on 5/12/2017. An inquiry officer is appointed, first in line, on 29/1/2018 to hold a departmental inquiry against the petitioners. Against the petitioner.
5/12.
5/12/2017.
First inquiry officer.
Page number 39.
5/12/2017. ಯಾರನ್ನ ಮಾಡಿದ್ದವಾಗ?
VP
VP Jahagirdar.
One VP Jagirdar, a retired district judge, was appointed to hold an inquiry against the petitioner. The said inquiry officer does not move a piece of paper. A second inquiry officer is appointed on 29/1, adena? 29/1/2018.
AM Pattar. His name is AM Pattar.
29/1/2018 to hold an inquiry against the petitioner. This time, a retired district judge, A.N. Pattar, is appointed. He also would not move a piece of paper except issuing summons to.
He did not move any paper, my lords. Even the next inquiry.
He also did not move a piece of paper towards the inquiry proceedings. Then comes the third inquiry officer on 21/5/2021. Now, one B.V. Prakash, a retired district judge. B.V. Prakash, the third inquiry officer to hold an inquiry against the petitioner, is said to have done some exercise of movement of papers or correspondences by issuing summons to the witnesses named in the articles of charge as was issued to the petitioner. The inquiry, note what happened later.
Thereafter, no proceedings.
They said summons was issued on 16/7/2021, and later there is absolute silence. 4 years pass by. The petitioner retires on attaining the age of superannuation on 31st July 2025. Terminal benefits of the petitioner is not settled on the score that the aforesaid departmental inquiry is pending against him. It is on the said premise the petitioner has approached this court in the subject petition. The learned counsel appearing for the petitioner submits that the very initiation of a departmental inquiry against the petitioner is on a wrong premise, that the petitioner has not submitted his reply. 4 other officers who were sought to be proceeded departmentally the proceedings against them are dropped considering their reply. The petitioner had submitted his reply, but the same is not taken into consideration and a departmental inquiry is sought to be instituted. The learned counsel would further submit that there are three inquiry officers who have done nothing to hold a departmental inquiry against the petitioner for the last 8 years, as the first of the appointment was on 5/12/2017. He would submit that his terminal benefits are now withheld on the score that the aforesaid departmental inquiry is pending consideration. The learned counsel would seek quashment of the very notification that he appointed the first inquiry officer or subsequent inquiry officers. The learned HCGP would submit that pursuant to the order passed by this court on 3/11/2025, the fourth inquiry officer is appointed to hold a departmental inquiry against the petitioner. Therefore, if a timeline is fixed, the state would now diligently hold the departmental inquiry and conclude the inquiry within the time frame so fixed by the court. The learned HCGP submits that the petitioner should not be let to go scot-free and terminal benefits should not be ordered, as the departmental inquiry has to conclude. The learned counsel, Gurudev Gachinmatti.
ಇಲ್ಲ, ನಾನು ಕಾರ್ಪೊರೇಷನ್, ಬಳ್ಳಾರಿ ಕಾರ್ಪೊರೇಷನ್.
The learned counsel representing the respondent corporation also toe the lines of the state. Counsel Shri Anil Kale submits that in the criminal proceedings, there is no allegation against the petitioner, but it was against the said Parameshi, whose reference is made here in above. The petitioner is now a charge sheet witness number 35 in the said proceeding.
5 minutes.
Charge sheet witness 5 in the said proceeding and not an accused at any point in time. Therefore, insofar as the criminal case is concerned, the petitioner has nothing to do. Petitioner is blame free. It is a submission of the counsel, Shri Anil Kale. I have given my sounds. Therefore, narrated facts are not in dispute. The dates and link in the chain of events, though not in dispute, would require certain iteration. The petitioner is a first division assistant working in
Ballari City Municipal Corporation.
in the fifth respondent, Ballari Municipal Corporation, which comes within the first respondent. A trap is laid against one Parameshi, who was a daily wage employee in the said corporation. The petitioner has had nothing to do with the said trap. 5 people were sought to be proceeded departmentally, and therefore the charge sheet is issued to show cause notice cum charge sheet is issued against all the 5 on 1/6/2016. The petitioner submits his reply to the said charge sheet as is submitted by the other 4. The reply submitted by the petitioner reads as follows. Page 35-36. It is the same or identical reply that was submitted by the other 4. Notwithstanding the same, an inquiry officer comes to be appointed to hold the inquiry against the petitioner solely on the ground that the petitioner has not submitted his reply to the charge sheet, which on the face of it is erroneous, as the petitioner has submitted his reply, which is quoted here in above. The order appointing the first inquiry officer is dated 5/12/2017, reads as follows. Page 38-39. The said inquiry officer against the petitioner does not move a piece of paper for close to a year. Does not move a piece of paper. Then comes the appointment of a second inquiry officer by an order dated 29/1/2018. It reads as follows. He also would not move a piece of paper. 2 years pass by. 3 years pass by. Comes the third inquiry officer on 21/5/2021. The said inquiry officer holds proceedings on one particular day, i.e. on 16/7/2021, but only issues notice to the witnesses. Nothing happens thereafter. Nothing happens thereafter except the ticking of time. The petitioner, 4 years pass by. The petitioner retires on attaining the age of superannuation on 31st July 2025. Terminal benefits of the petitioner are completely withheld on the score that the aforesaid departmental inquiry is pending pursuant to issuance of a charge sheet dated 1/6/2016 and appointment of inquiry officer. When the matter comes up on 3/11/2025, this court passes the following order. In the light of the said order, the state again wakes up from slumber and appoints the fourth inquiry officer to hold an inquiry and complete the inquiry. The learned HCGP would seek to defend this action by contending that the fourth inquiry officer must be permitted to continue the proceedings. The said submission is noted only to be rejected. The error has not happened in appointment of the fourth inquiry officer. The very first inquiry officer appointed was in error, as the reason for appointing the inquiry officer was there was no reply from the hands of the petitioner, while there was a reply. The reply of the petitioner was identical to other employees whose departmental inquiry gets dropped on accepting the reply. The petitioner is sought to be singled out and proceeded departmentally. The proceeding, it would have been altogether a different circumstance if the if the departmental inquiry instituted against the petitioner had been concluded 8 years ago. 8 years the state has taken to move piece of paper on the table of departmental inquiry. Fourth inquiry officer is now appointed to conduct an inquiry which on the face of it was illegal to have initiated even on 5/12/2017. The justification of 5/12/2017. Therefore, on the sheer score of the state having changed inquiry officer after inquiry officer who would not want to hold the inquiry, and in the teeth of the passage of time, the sword of departmental inquiry is hanging on the head of this petitioner for 8 years and still hangs on his head after his retirement. If this cannot be termed as an abuse of power on the part of the disciplinary authority, I fail to understand what else can be abuse of power by the disciplinary authority. Abuse of power of initiation of a departmental inquiry and keeping it pending or continuing against an employee. The petition thus deserves to succeed, not success simpliciter. It would be with exemplary costs of litigation on the petitioner and interest for non-payment of terminal benefits on his retirement. For the aforesaid reasons, the following order. The petition is allowed. The order dated 5/12/2017 stands quashed with costs of litigation at rupees 50,000 to be paid to the petitioner from the ಅಂತ ಮಾಡಿ ಯಾರಿಂದ ಆಮೇಲೆ ನೋಡೋಣ. The terminal benefits of the petitioner which are now withheld. ಯಾವತ್ತು ಕೊಡಬೇಕಾಗಿತ್ತು?
As on 31st July 2000.
The petitioner on retirement became entitled to receive pension and other terminal benefits from August the 30th, 2025, 1 month after his retirement. It has not been paid. Therefore, the pension and other terminal benefits shall be settled to the petitioner within an outer limit of 4 weeks from the date of receipt of the copy of this order. In the event the petitioner's terminal benefits are not settled within 4 weeks, the petitioner becomes entitled to interest at 12% per annum from the date it fell due till the date it is to be paid. Any other baki idea? To be paid, yes.
Highly obliged, my lords.
I may be permitted to file a memo wherein my lords, the corporation have my lords taken my lords initiation, wherein my lords I have written a letter to the my lords government first respondent, so that my lords cost should not be my lords on my part. Then I may be permitted to file it in the registry, my lords. There are 4 correspondence which my lords the corporation had my lords requested the first respondent to my lords conclude the my lords inquiry, and my lords since my lords I was the presenting officer, so my lords I have written a letter to please. I'll file it.
Petition, not some allegations are made against Lokaयुcta that it is won by, on our instigation, this inquiry has taken up. No, that is not so.
ಅಲ್ಲ ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಇರುತ್ತೆ ಬಟ್
ನಮ್ದು ಯಾವ ರಿಪೋರ್ಟ್ ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
ಅವೆಲ್ಲ ಅದು ಬಂದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು ಅದಕ್ಕೆ.
Everybody is submitting not their shoulder, your lordship, about the
ಎಲ್ಲ
cost.
ತಪ್ಪು government ದೇ
But your
madam.
lordship, we have also done our work and appointed the inquiry
ಒಂದ್
officer,
ಕೆಲ್ಸ
your
ಮಾಡಿ,
lordship.
ಕಾಸ್ಟ್
And
ಒಂದ್ 2 ಲಕ್ಷ ಮಾಡ್ಬಿಟ್ಟು ಡಿವೈಡ್ ಮಾಡಿ.
because we have, even we have written a letter to the inquiry
This should
officers
be, this
also, your
should be a
lordship.
lesson to the state. You can't treat the employees as your chattels. Time has come where cost impose ಮಾಡಿದ್ರೆ ಆಗದೇ ಇಲ್ಲ ಅಷ್ಟೇ, ಹಂಗಾಗ್ಬಿಟ್ಟಿದೆ.
No, your lordship. Earlier we have written a letters
Enquiry
also to
ಮುಗ್ಸೋದು
the.
ಕಷ್ಟ. ಅದು ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದೆ ತಪ್ಪು.
That can be, your lordship, but we have appointed the officers and written a letters consistently and asked them to finish also, your lordship, but they have not submitted.
Yes.
Cost.
ಇರ್ಲಿ.
Release.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ವಾ? ಕೊಡಿ ಫಸ್ಟ್ ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂತ ಮಾಡಿ. ಎಸ್.
I will also file, your lordship, maybe.
ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ.
ಎಲ್ಲಿದೆ?
It is ready, your lordship.
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮತ್ತೆ.
Please, your lordship.
I'll also file it in the registry.
ಎಲ್ಲ ಇಲ್ಲೇ ಕೊಟ್ಬಿಡಿ ಸರ್. ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್ ಎವ್ರಿಥಿಂಗ್.
22, 23, 24, 25 year before my lord's matter is listed before this court.
Memo take ಮಾಡಿ.
Yes. Next.
Number 28, ಏನ್ ಮಾಡಿದ್ರಿ?
Yes. Lord, this petitioner is a cooperative society. Respond number 4 borrowed loan from petitioner society. Became defaulter. And petitioner society had to file arbitration suit against him. Suit came to be decreed and award was passed by respond number 3. Lord, the respond number 4 challenges the award before Karnataka appellate tribunal. Now, my lord, appellate tribunal has set aside the order of the assistant registrar. Now, that is under challenge before this honorable court. My lord, appellate tribunal has proceeded to allow the appeal and dismiss our suit mainly on 2 grounds. That petitioner society has not produced any document to establish that respond number 4 is a member of the society. My lord, this was not in dispute at all. I have produced the written statement.
That's all right. What is the justification for 6 years delay?
My lord,
In filing the proceedings before the tribunal?
my lord, he was not aware of the proceedings.
Who was not aware,
Allah.
sir?
One sufficient, one
Who was not, who went before the tribunal?
tribunal, respond number 4 here in, my lord.
ನೀವ್ ಯಾರಿಗೆ?
Respond number.
6 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
That is, my lord, one.
You're having a siesta?
Huh?
Everybody. What were you doing for 6 years?
It is for, he was not provided opportunity when the execution has been filed, then only he came to know that the award wasn't passed, my lord.
Oh, before the registrar did, JRCS or DRCS?
ARCS.
Yes.
ARCS did not provide any opportunity.
That is been observed in the order, my lord.
Order of the tribunal. ಈಗ ರಿಮೈಂಡ್ ಮಾಡಿದಾರ?
60 adjournments. 60
ರಿಮೈಂಡ್ ಮಾಡಿದಾರ?
Remand.
ARCS ಮುಂದೆ 60 adjournment.
60 adjournment. Kindly go to page 11, my lord. Annexure A. 60 adjournment ಆಗಿದೆ. And execution file ಮಾಡಿದ್ದು 2018 ಅಲ್ಲಿ. 3 years after filing execution, he has preferred appeal. ಅಷ್ಟು ಡೇಟ್ಸ್ ಹಾಕಿದ.
ಏನಿದು ಡೇಟ್ಸ್ ಇಷ್ಟೊಂದು?
ಅಷ್ಟು ಡೇಟ್ಸ್ 60 ಹಿಯರಿಂಗ್ಸ್.
ಓಹೋ.
Now he says opportunity is not given. And my lord, execution was filed. 3 years after filing execution, he prefers appeal.
What execution?
For recovering that amount, award amount. After ARCS passes an award.
What was the allegation?
Please, may.
ಇವ್ರ ಮೇಲೆ ಏನು?
ಅಲ್ಲ, ಸಾಲ ತಗೊಂಡಿದ್ರು. ಲೋನ್.
ಸಾಲ ತಗೊಂಡಿದ್ರು.
ಲೋನ್ ರಿಕವರಿ.
Yes, sir.
My lord, admittedly, the cooperative is providing loan for the members of the society. And we are neither the member nor a surety to the loan, my lord.
Where did you take the loan?
Allah, we are not taken the loan. That is observed in the KAT order, my lord, at page 29.
29?
May I, my lord?
One
While
moment.
on, please.
Where is the loan document?
They have not produced.
ಅಲ್ಲ,
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇಲ್ಲಿಲ್ಲ, ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ.
ಅಲ್ಲ, ಇಲ್ಲೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಆಯ್ತು.
ಲೋನ್ ತಗೊಂಡಿದ್ದ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ.
ಇಲ್ಲ. My lord, he is disputing that he is a member. In the written statement, I produced annexure D. He never takes up such defense.
ಯಾಕೆ ಸರ್? ಇವ್ರ ಮೆಂಬರ್ಶಿಪ್ ಆಗಿರೋದು ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ. ಲೋನ್ ತಗೊಂಡ್ರೋದು ಕೊಡಿ. ಕ್ಲೋಸ್ ಮಾಡೋಣ ಇಲ್ಲೇ.
Yes.
And one more, my lord.
My lord, another aspect, my lord. Another reason to dismiss the suit by the KAT is that the land is not, any land is not mortgaged. I have produced annexure E. In their
To
2006 only.
produce two documents of his membership and loan availing.
Yes,
We will close it. then.
yes.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
My lord,
Yeah.
one second.
Any,
In another observation in para 3.
Observation ಬೇಡ. Let me see
ಅಲ್ಲ.
the document.
ಹಾ.
Yes. List the matter on 26th
list,
in fresh matters list.
Please.
Yes.
interim order.
Interim order subsisting will continue to the next date of it. Yes.
Please.
Next.
Number 30, Chaitanya S. Viraj, Jagdish Patil.
You have safe passage da.
Yes, your lordship.
Ah.
Yesterday's matter, your lordship, that where we have made an application for appointment of commissioner
For
for
what?
cross examination of PW2.
PW2 in other,
PW2
other
is-
that is challenged here. Is
Yes,
it?
your lordship. It has been challenged by them. That video conference has been allowed, your lordship, permission.
Oh, ಅದೆಲ್ಲಿ ಯಾವತ್ತದು?
They have to keep him present, your lordship, for the cross-examination.
Allah, he's at Goa, your lordship. It can, he can.
ಗೋವಾದಿಂದ ಬರಕ್ಕೆ
Barakin, but
Goa
safe
ಅಲ್ಲಿ
passage ಬೇಕಾಗಿದೆ ಅವ್ನಿಗೆ.
atmosphere and
No,
weather
he
will be
requires
good in
some
Goa.
police
Let
protection.
him come here.
ಅಲ್ಲ police protection ಕೊಟ್ಟು ಒಂದು ಆ ದಿವಸ
ಯಾಕೆ
ಒಂದೇ
police
ದಿವಸ
protection?
let them give your lordship on the
police, ಏನೇ police protection?
ಅಲ್ಲ ಅವನಿಗೆ ಲೈಫ್ ಥ್ರೆಟ್ ಇದೆ ಅಂತ ಮೆಸೇಜಸ್ ಬರ್ತಾ ಇದೆ ಅಂತ ಅದರ್ವೈಸ್ ಐ ವುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ದಟ್ಸ್ ದ ಪ್ರಾಬ್ಲಮ್
ಯಾರು
ಅದರ್ವೈಸ್
ಇವ್ರಿಂದ-
ಡೇಟ್
ಇವರಿಂದನಾ?
what day they he is receiving a messages
He has not filed any
otherwise any
evidence
date
in
may
the
be fixed
set to
on
his
that
name.
day only. Let them cross examine on the same day. Entire thing can be concluded on the same day. Let them take an undertaking on 25, 26 or 27.
Of Belgaum.
Belgaum.
Matter is pending before Belgaum Family Court. And, Lord, it is, Lord, and the affidavit is
He will
filed.
come.
Filed
He is there only, Lord.
He will
There in
come.
Belgaum.
ಅಲ್ಲ ನಾನು ಬರ್ತೀನಂತೆ 25, 26, 27. Let them cross examine him on the same day. Let them conclude it, your lordship. It can be done. Yes, sir.
ಏನಿಲ್ಲ ಅಂದ್ರೆ 27th ಬರ್ತಾರೆ ಅನ್ಸುತ್ತೆ.
ಅಲ್ಲ ನಾ next week date fix ಮಾಡಿದ್ರೆ same day it can be done. And one thing your lordship, till he reaches the Goa border, somebody has to be accompanied.
ಮನಿಯ
ಅಲ್ಲ somebody has to be accompanied because of this.
wife will accompany. Don't
ಇಲ್ಲ ಇವ್ರು ಬೇಡ wife because he is giving the evidence against his mother, your lords. That's the
Lord, the respondent
that's
was in
because
the-
he is living in adulterous life.
was in the
That
side
was
of,
this.
Lord, the mother only. Now he has gone on the side of.
In fact, your
Lord,
lordship, there are other.
ಅಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ ಗಾನು ಹಂಗಂದ್ರೆ ಅವ್ರ ಸೈಡ್ ಹೋಗಿದ್ದಾರೆ ಇವ್ರ ಸೈಡ್ ಹೋಗಿದ್ದಾರೆ ಅಂತ.
He has promised him to pay share, give share in the profit, that's the reason.
ಈಗ ಇಟ್ಸ್ a decree.
We are not on that.
And
Let
he's
the
a
evidence
major.
go on. The both the petitions they will dispose this.
Same order has been questioned, your lords.
The petitioners in hang on. In the batch of these petitions, the order that is called in question is common. One is by the respondents before the defendant. In suit.
Defendants, your lords.
One by the defendants and the other by the plaintiff. The issue revolves around the family. The petitioner, who is the plaintiff here? I am holding.
Who is the defendant number one, your lords?
Yeah, the defendant plaintiff ಅಂತ
Point number
ಹಾಕಿ
one.
ಯಾರು
The
ಎಲ್ಲ
first
respondent
petition,
petitioner.
the first petition is preferred by the respondent number 1.
ರತ್ನ ಬಿರಾಜ್ ಕೊಡಿ first.
ಯಾವ ಫೈಲ್ ತಗೊಂಡ್ರ ಅದ್ರ ಮೇಲೆ ಹೇಳ್ಬೇಕಿತ್ತು ಪೇಜಿನೇಷನ್.
ಹಾ, ಇದೆ. Yes.
Respondent number 2.
In writ petition 102,774 of 2025, the challenge is 102,555 of 2025 is preferred by the defendant or plaintiff.
Respondent number 2, your lordship.
ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಇದು?
Page number 9, your lordship. The petition is at page number 9.
In the first petition ನಲ್ಲಿ
MC na?
MC
please.
petition.
Sorry. The petitioner in writ petition 102,774 of 2025 is the second respondent. In MC 195 of 2020. In the companion petition,
It is by respondent number 1, your lordship.
the companion petition is preferred by respondent number 1. Therefore, both the petitions are preferred by the respondents before in the aforesaid matrimonial case. The issue that has driven the petitioners to this court is permitting the husband ಯಾರಿದು?
PW2, son of the
Permitting PW2, the son of
Petitioner and respondent number 1.
the petitioner and the first respondent to appear through video conference to tender his evidence.
for cross examination.
For cross-examination. The learned counsel for the petitioner submits that petitioners in unison would submit that the PW2,
Yes, Your Lordship.
PW2 is a resident of Belgaum. There are cases that he is attending in Belgaum, but is presently residing in
At
Goa.
Goa.
So therefore, he present residing in Goa and can always travel to Belgaum. Video conference should not have been permitted. The submission of the counsels appearing for the petitioners would merit acceptance, as the petitioner is only 100 kilometers away from Belgaum and not anywhere else for him to appear through video conference. The learned counsel for the respondent Jagdish Patil submits that there is threat through his life or limb because as he has been receiving threatening messages from all and sundry, and therefore is wanting video conferencing. If that be so, the submission though would be partially acceptable. It is not acceptable that the PW2 would appear for cross-examination through video conference. He shall be present before the court on next day
26, Your Lordship.
on 26/11/2025 and conclude his cross-examination or re-examination as the case would be on the same day itself. The petitioner, in the event if in the event there is any threat that is meted out by these petitioners to PW2 as is contended, the concerned court is at liberty to pass necessary orders against the petitioners who are allegedly threatening PW2, which is denied by the petitioners. However, it is for the petitioners to encourage restraint and not generate messages of threat through to PW2. Yes, with the aforesaid observation, directing PW2 to appear before the concerned court on 26/11/2025, the petitions stand disposed.
Their
One more
matter
submission,
can be
Your Lordship.
disposed of because
Yeah.
from the 2010 it is pending. Within 6 months it can be disposed. Already
The
PW2
threat,
exam.
they say that they have received it from third party,
all
Lordship,
and sundry ಅಂತ ಹೇಳಿದ್ದೀನಿ ಅದಕ್ಕೆ.
who is no way connected.
Within 6 months, Your Lordship.
ಅದನ್ನ conclude ಮಾಡೋಣ.
Yes, Your Lordship.
Both the learned counsel appearing for the petitioners and the respondent in unison would again submit that the proceedings are pending before the concerned court for the last 15 years.
No, 5 years, Your Lordship.
2020 na?
2020.
2020
6 months ಅಂತ ಅಷ್ಟೇ. ಅಲ್ಲ ಡಿಕ್ರಿ ಆಫ್ ಡೈವೋರ್ಸ್
The last 5 years. Therefore, the concerned court shall endeavor to conclude the proceedings with an outer limit of 6 months, if not earlier, from the date on which the cross-examination would get complete.
Yes.
All right. Yes, next.
31, HN 31, PN50, Harsh Desai.
Lord, on the last occasion, my Lord, your Lordship said directed the university to ensure that the salary is paid. My Lord, I'm filing a memo that all the papers have been processed.
Processed,
And
when would it be paid?
Lord, it is now to the
Salary from?
Lord, from May of this year, my Lord, to October.
ಯಾರು ಪೇ ಮಾಡ್ಬೇಕೀಗ?
University ಅವರೇ ಮಾಡಬೇಕು, but it is, my Lord, to be routed through HRMS, that new software.
HRMS is human resource management system software.
ಅದಕ್ಕೆ
Again, it's only click of
Your
buttons.
Lordships may kindly see the second page. my
That's
Lord.
only click of buttons, sir.
ಹೌದು,
ಅಲ್ಲೇ
ಅದು
delay
ಇವತ್ತು
ಆಗಲ್ಲ.
ನಾಳೆ ಆಗ್ಬಿಡುತ್ತೆ, because this is dated 5th of November. My Lord, I am told within this week, my Lord, his salary will be
We'll post
credited.
it on 25th.
ಅಲ್ಲ, 1st of December, my Lord.
ಬೇಡ, ಯಾಕೆ?
1st or 2nd.
List ನೀವಿರಲ್ವಾ?
Next week ಸ್ವಲ್ಪ.
List the matter on 1st December. The learned counsel, Harsh Desai, places a memo along with documents seeking to demonstrate that the payment of salary of the petitioner is now processed and would be paid by the next date of hearing. In the light of the said submission, list on 1st December. In the event salary is not dispersed by the said date, appropriate orders would be passed, mulcting the respondent. Yes.
Interim order may be extended.
Interim order subject to the aforesaid shall continue till the next date of hearing.
In both cases.
Both cases.
32, V Vidya, PV Kunja.
I appear for the petition. This is a matter which was listed on 5th.
Your lordship sir directed me to.
The petitioner, my lord, joined the services of Miller's Hospet Cooperative City Bank, was in the year 1973. Plus, he retired on 30/6/2008. Plus, he sought for commutation of pension. Plus, in view of insertion of Miller's paragraph 12B, plus wherein they said, plus if they have completed 15 years, plus their full pension plus has to be restored to them. Accordingly, plus in the year 2023, I gave a representation plus to the authorities to restore my pension plus pursuant to that notification. Plus, they did not respond. I gave one more representation.
Heard on the last occasion.
Oh.
It was heard. In fact, I was relying upon a judgment of the Honorable Supreme Court, which your lordship said. There are a number of issues decided. ಅದಕ್ಕೆ ನಾನು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ. The last paragraph number C ಅಲ್ಲಿ, the issue involved is that at paragraph number 44 of the said judgment, it has been said that in which cases, in which situation is the pension to be given on the actual wages anta. Paragraph number 44 at page 46.
We'll see. We'll go through it. We'll post it tomorrow and dictate. Nale no argument, only dictation. Yes. Tomorrow. Yes.
33 Ashok R. Kalyan Shetty.
Your lordship seeks one more week time, your lordship, for filing objections, your lordship.
Learned HCGP seeks in pension.
Pension.
ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು
Pension.
ನೆಕ್ಸ್ಟ್ ಜಿ ಅಂಡ್ ಎಚ್ ಮೇಲೆ ಆಲ್ರೆಡಿ 85 ವರ್ಷ ಆಗಿದೆ ಸರ್.
85 ವರ್ಷ ಆಗಿದೆಯಾ?
80 ವರ್ಷದ ಮೇಲೆ ಆಗಿದೆ ಎಲ್ಲ.
ಪೆನ್ಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದೆ ಸಮಯ ಜಾಸ್ತಿ 50% ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ.
ಕಾರಣ? Yes, madam. Why?
Kindly
I think list at the request of the learned HCGP list the matter on 3rd December.
Please, your lordship.
It's made clear further adjournment would not be granted. Yes.
Please.
Next.
34 HR Kambiyavar.
Not same 107 na?
ಇಲ್ಲ madam. 119 subsection 2 and B.
Learned
Income tax.
Tirmalesha, yaar?
Yes, Tirmalesh.
Learned Counsel M. Tirmalesh is directed to accept notice for Tirmalesh and Rupa are directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid counsel. We'll close it next time. List the matter on 4th December. Yes, next.
35 Sanjay Skitagiri.
Lordships are directed to take hand summons to the respondents against the Lok Adalat award in the civil suit for partition and separate. Lordship, the 1 and 4, one has in fact is the plaintiff has refused, my lord, did not accept. So we have sent through postal, my lord. 2356, my lord, I undertake to file wakalat.
Yarige, sir?
On behalf of respondent number 2, 3, 5 and 6.
Learned Counsel undertakes to enter appearance for respondents 2, 3, 5 and 6. Register. Ellargu idiyalla?
No, my lord.
Inyarige?
1 and 4, my lord. I will take out through court notice, my lord.
The 1 and 4 emergent notice. Registry to print the name of so and so is appearing for respondents 2, 3, 5 and 6. Emergent notice returnable by the 10th of December. List on 10th.
Please.
Next.
36 Karabasappa Kori Shettar.
Your lordship, the respondent.
Where is Kannur?
Kannur.
Prashant Osman.
My lord, Prashant Osman is ತಗೊಂಡಿದ್ದಾರೆ already files.
ಹೌದಾ?
Name may be deleted. MM Kannur.
Okay, to delete the name of MM Kannur. Prashant Osmani alle? ಆಯ್ತು. Misconduct.
Your lordship.
What penalty? Penalty ಏನು?
Penalty ಇಲ್ಲ. Say suspended from the.
Suspended.
Suspension
is not penalty. What penalty?
No, see revoked once again. Revoked after 3 months. As per their procedure, she revoked, your lordship.
All right.
But one thing is that charge sheet is issued against 7 members. Only this petitioner suspension order passed against this petitioner. That is a selective suspension. After this suspension, already 3 months are over. As per their procedure, they have revoked. But your lordship, those other recipient of the charge sheet, other 6 members, they were enjoying this their service. They are doing their service, even though they are recipient of the charge sheet. But arbitrary action taken by the respondent number 1, this petitioner is only suspended. Your lordship. Now, by order dated 3/10/2025, they once again, they have given chance to her and she attend regularly doing job on 4/10/2000.
ಏನ್ ಕೇಳಿದ್ದೀರಾ ಸರ್?
Your lordship.
What is your prayer?
Your lordship, to quash the suspension order.
Revoke ಮಾಡಿದಾರಲ್ಲ.
Revoke ಮಾಡಿದ್ದಾರೆ. But act of the respondent ab initio illegal, because that is a selective suspension. The other recipient of the charge sheet are enjoying.
We'll decide it. Learned counsel for the petitioner submits that the petition is filed on the premise that the suspension order passed by the respondents was selective. As seven people were sought to be proceeded departmentally, suspension was only against the petitioner. The matter would require consideration in the light of revocation of suspension of the petitioner, whether the suspension of the petition for 3 months' time was appropriate or otherwise would be decided at a later point in time. Objections, if any, in the next 2 weeks.
Please.
37 Jagdish Patil, Pawan Dodati.
For the petitioner. Petitioner filed an application for issuance of no objection certificate from the KIADB. They issued a certificate, endorsement that 2011 there was a preliminary notification, this land was included. Last date of hearing, your lordships, and the earlier order directed them to file an affidavit, secretary.
ಯಾರು KDB ga?
Howದು KIADB?
Respond number 1, lords.
Who has to file affidavit?
Respond number 1.
R1 na?
Please.
R1 ಯಾರು?
Principal Secretary. Government.
Where is the order directing affidavit to be filed?
Earlier order.
8/9/25, lords.
Which qualifies indicating inclusion proceedings have been pending since 2012. Clarifying the stand. Affidavit ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, affidavit.
You ಯಾರಿಗೆ ಹೇಳಿದ್ದು sir? First respondent.
First respondent, your lord. There is a direction.
1 minute, sir. Principal Secretary na?
Yes.
Ask him to be present. Huh? What day after tomorrow?
Now the 2 and 3, if they issue an NOC, your lordships, I can withdraw it, your lordships. That is the.
3 is only, I represent 3, my lords. 3 is only the allotting authority, my lords.
No, there is an order directing to file affidavit. You can't take the orders lightly like this.
My lords, I represent only the
Nimala,
respondent number
madam.
3, my lords.
Nivala. Yes. The coordinate bench of this court on 8/9/2025 had passed the following order. The matter was directed to be listed on 19/9/2025 and an affidavit, as was indicated in the order quoted supra, had been directed to be filed by the first respondent. First respondent is the Principal Secretary, Department of Urban Development. Though 75 days have passed by, though 3 months have passed by, 2 months, 60 days have passed by pursuant to the expiry of the date 19/9/2025, there is no affidavit filed by the first respondent. It appears the first respondent has, there is no adherence to the order that is passed by the coordinate bench by the first respondent, which cannot be countenanced. The learned AGA submits that if learned AGA seeks time to day after tomorrow for the compliance of the order dated 8/9/2025. In the event the affidavit as directed on 8/9/2025 is not filed by the Principal Secretary, the Principal Secretary shall be present before the court at 2:30 p.m. List the matter on Friday at 2:30 p.m. Yes. Huh? Sorry? ಅದೇ ಗೊತ್ತಿಲ್ಲ. There is an order. You can't take the orders of this court lightly, be it the principal secretary or chief secretary, whoever it is. Yes.
38, Sadiq Goodwala.
Here for petitioner. In page 52, my lord, annexure C, as per respond number 3, Tahsildar. My lord, it is a dispute between four families. My lord, the local MLA, my lord, instigates this impleading applicants to give an, my lord, representation. My lord, based on their representation, annexure C is for shifting of, my lord, ideal from one place to another place, deity. He has no business
ಯಾವ business?
to do all these things.
Who is no business to do all this?
Yes. Because it is a dispute between private parties.
I'm appearing for impleading applicant, my lord.
ಯಾರು ಈ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಿರೋದು ಯಾರು?
ನಾವೇ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಅಲ್ಲ ಈ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಿರೋದು ಯಾರು?
Impleading applicant to a local MLA.
ಲೋಕಲ್ MLA.
Yes.
ಲೋಕಲ್ MLA ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
Party ಮಾಡಿಲ್ಲ. Because of their instigation, that the impleading applicants gave a representation to Tahsildar.
ಏನ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Now kindly see in page 53.
What is the business, sir?
Not business, my lord. There is my lord, a family deity in one place. He has directed to shift it to another place.
Kindly see in page 52 annexure C. In page 52 annexure C.
Who has directed?
The Tahsildar has directed.
Why, sir?
For a moment, may I read, my lords?
Yes.
In page 52, last para, my lords. ಈ ಕುರಿತು ಸದರಿ ವಿಷಯದಲ್ಲಿ 30-40 ವರ್ಷಗಳ ಹಿಂದೆ ಗುರುವಿನ ಸಿದ್ಧಲಿಂಗಪ್ಪ ಮನೆ ಎದುರಿಗೆ ಇರುವ ದೇವಸ್ಥಾನಕ್ಕೆ ಮೂಲ ಕುದುರೆ ದೇವರ ಮೂರ್ತಿಯನ್ನು ಬೀರಲಿಂಗೇಶ್ವರ ದೇವಸ್ಥಾನದ ವಾಪಸ್ ತಂದು ಇಡುವುದರಿಂದ ಯಥಾಸ್ಥಿತಿಯನ್ನು ಕಾಪಾಡಲು ಮತ್ತು ಗ್ರಾಮದಲ್ಲಿ ಶಾಂತತೆಯನ್ನು ನೆಲೆಸಲು ಸಹಕಾರಿಯಾಗುತ್ತದೆ. ಈ ಎಲ್ಲ ಕಾರಣಗಳಿಂದ ಯಾವುದೇ ವ್ಯಕ್ತಿಗೆ ಆಗುವ ಅಡಚಣೆ, ಕಿರುಕುಳ ಅಥವಾ ಹಾನಿಯನ್ನು ಅಥವಾ ಮನುಷ್ಯನ ಜೀವಕ್ಕೆ, ಆರೋಗ್ಯಕ್ಕೆ ಅಥವಾ ಸಂರಕ್ಷಣೆಗೆ ಉಂಟಾಗುವ ಅಥವಾ ಸಾರ್ವಜನಿಕ ಸ್ಥಳದ ಹೊಡೆದಾಟವನ್ನು ನಿರ್ಬಂಧಿಸಬೇಕೆಂದು ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಫ್ ದಿ ಪೊಲೀಸ್ ಸಿರಿಗೇರಿ ಪೊಲೀಸ್ ಠಾಣೆ ಸಿರುಗುಪ್ಪೆ ಅವರು ಉಲ್ಲೇಖ 2ರ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖಿತ 1ರಲ್ಲಿ ಅರ್ಜಿದಾರರು ಕೋರುವಂತೆ ಹಾಗೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಫ್ ಪೊಲೀಸ್ ಸಿರಿಗೇರಿ ಪೊಲೀಸ್ ಠಾಣೆ ಸಿರುಗುಪ್ಪೆ ಅವರ ವರದಿಯಂತೆ ಈ ಕುರಿತು ಸದರಿ ವಿಷಯದಲ್ಲಿ ಹೀಗೆ 30-40 ವರ್ಷ ಹಿಂದೆ ಗುರುವಿನ ಸಿದ್ಧಲಿಂಗಪ್ಪನ ಮನೆ ಎದುರಿಗೆ ಇರುವ ದೇವಸ್ಥಾನಕ್ಕೆ ಮೂಲ ಕುದುರೆ ದೇವರ ಮೂರ್ತಿಯನ್ನು ಬೀರಲಿಂಗೇಶ್ವರ ದೇವಸ್ಥಾನದ ವಾಪಸ್ ಇಡುವ ಕುರಿತು ಸೂಕ್ತ ಪೊಲೀಸ್ ರಕ್ಷಣೆಯೊಂದಿಗೆ ಈ ಕೂಡಲೇ ಕ್ರಮ ವಹಿಸಿದ ಬಗ್ಗೆ ಕಚೇರಿಗೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲು.
ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ?
Problem is, my lords, in order to, my lords, maintain the, my lords, there is a dispute with respect of, my lords, the deity.
In order to maintain the peace,
Yes, peace and tranquility.
ಡೇಟಿನೇ ತಗೊಂಡೋಗಿ ಬೇರೆ ಕಡೆ ಇಟ್ಟು.
Deity ಅಲ್ಲ.
ನೀವ್ ಯಾರು ಸರ್?
I am for impleading applicant.
ಅದು who is impleading applicant?
My lord, one of the, my lord, family member in 3, my lord, Métis families, my lord.
My lord,
There is.
Kindly see, ಇಲ್ಲ ಒಂದೇ ಒಂದು ನಿಮಿಷ. Kindly see in the impleading applicant, para 3, he says he is a permanent resident of that village, not the family member.
ನೀವ್ ಯಾರು?
My lord, we are the family members. My lord, there was a dispute in 1954. My lord, there was a civil court order that who should, my lord, perform the puja. These are the, my lord, residents of that village. They gave a representation.
Submit, my lord. In respect of this, my lord, in Murti.
ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ದೇವ್ರನ್ನ ಅಲ್ಲಿ ಇಲ್ಲಿ ತಗೊಂಡೋಗ್ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ಲಿ ಎಲ್ಲಿ ಇಟ್ಟಿದ್ದೀರಾ ಈಗ?
ಅಲ್ಲೇ ಇದೆ, ಎಲ್ಲಿತ್ತು ಅಲ್ಲೇ ಇದೆ.
Because of entry model, it is there. God is, my lord, shifted to the another temple, my lord. My lord, since from 50 years, my lord, the God is, my lord, in one place, my lord. Due to, my lord, structure is become old, my lord. For my lord, renovation, my lord, it is shifted to the, my lord,
Temporarily it is shifted elsewhere.
Please, my lord. It is temporarily shifted, my lord. Thereafter, my lord, this petitioner family started, my lord, obstruction for construction of a new, my lord, temple, my lord. That is the reason, my lord, we given representation to the Tahsildar, my lord. For that, my lord, they inquired, my lord, and my lord passed the order, my lord. Now, my lord, the elders of the, my lord, villagers, my lord, decided that, my lord, they will not construct a new temple, my lord.
ಯಾಕೆ ಇದು ಡೆವಲಪ್ಡ್ ಕಂಡೀಷನ್ ಇದೆ ಹಂಗೆ ಇರ್ಲಿ ಅಂತನಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, due to this havoc, my lord, they want to shift the God to old temple only, my lord. That is the reason, my lord, we submitted the same before the Tahsildar, and my lord, Tahsildar passed the impugned order, my lord.
ಸರಿ, ಈಗ ಎಲ್ಲಿದೆ ದೇವರಿಗೆ ಯಾರು ಪೂಜೆ?
ದೇವಸ್ಥಾನದಲ್ಲೇ ಇದೆ ಅದು.
ಪೂಜೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಮಾಡ್ತಾ ಇದೀವಿ.
What happens, my lord? Petitioners, my lord, high-handedly, my lord, taken into the, my lord, ಮೂರ್ತಿನ ತಗೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ. That is
ಎಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ?
my lord, ದೇವಸ್ಥಾನದಲ್ಲಿ, my lord, which
ಅಲ್ಲ ಹಳೆ ಟೆಂಪಲ್ ಅಲ್ಲ,
shifted to new temple, my lord.
ನೀವು ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಈಗ?
ಅಲ್ಲಿ ಇದೆ, my lord, there was a defect. Now I have started construction to shift it to the old place where it was.
ನಿಮಗೂ ಓಲ್ಡ್ ಅಲ್ಲೇ ಬೇಕಾ?
ಸ್ವಾಮಿ ಏನ್ 40-50 ವರ್ಷದಿಂದ ಪೂಜೆ ಮಾಡ್ತಿದ್ವಿ ಅಲ್ಲಿ ಇಟ್ರೆ ಸಾಕು ಸ್ವಾಮಿ, ಆಸ್ ಪರ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ಪಾರ್ಸಲ್
ಈಗ ವಾಪಸ್ ಯಾವಾಗ ಇಡ್ತೀರಾ ಅಲ್ಲಿ?
ಇಲ್ಲ, ಇದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆದ್ಮೇಲೆ ಇಡ್ತೀನಿ. ಇಲ್ಲಿ my lord, ಆಲ್ರೆಡಿ
Construction ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು.
My lord, they are
My lord, where it was,
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅವರು started to, my lord, then I will shift it there.
ಅವ್ರು ಬೇರೆ ಗುಡಿನೇ ಕಟ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. That is my lord objected, my lord.
My lord, there is a dispute between, my lord, family members. My lord, 1954 suit.
ಭಕ್ತಿಯಲ್ಲೂ ರಾಜಕಾರಣ.
These are, my lord, at the instigation, my lord, impleading applicants gave an complaint. ಏನು ಆಗಿರ್ಲಿಲ್ಲ, ಇವ್ರು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಇಷ್ಟು ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, 40-50 years ದಿಂದ my lord, it is there only my lord. 3 families my lord.
Well decided, yes. ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ?
ಇದೆ.
In view of entry matter my lord, ಅಲ್ಲಿ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ನಮಗೆ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗ್ಲಿಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ. That is the reason my lord.
ನಿಮ್ಗೆ ಯಾಕೆ ಹೋಗ್ಬಿಡ್ತಾ
My lord, because the family of petitioners my lord.
ಅವರೇ ಪೂಜೆ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಹೌದು ಸ್ವಾಮಿ, that is the reason.
ಯಾರನ್ನೂ ಬಿಡ್ತಾ ಇಲ್ವಾ?
ಬಿಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, that is the reason.
ಪೂಜೆ ಮಾಡಕ್ ಬಿಟ್ರೆ ನಾ ಪ್ರಾಫಿಟ್ ಅಲ್ಲಿ ಇರ್ತೀನಿ.
Lastly my lord.
ಕೊನೆಗೆ ಅಲ್ಲಿಗೆ ಬರ್ತೀರಾ?
Due to profit only my lord, they have challenged the.
ಇಲ್ಲ, ಇವ್ರಿಗೆ ಅವ್ರನ್ನ ಬೀಳಿಲ್ಲ ಅಂದ್ರೆ I will be under loss.
That is the reason my lord, I am praying this honorable court my lord, inquiry.
So both of you want profit.
Profit ಬೇಡ.
We'll see.
ದೇವಸ್ಥಾನದಲ್ಲಿ ವಾಪಸ್ ಹೋಗಿ ಕೂತ್ರೆ ಸಾಕು. That is the reason.
ಅದು ನೋಡುವ. Yes. List the matter on 26th in fresh matters list.
Please.
Yes, next. Why is Gurudas Kanur sir waiting? ಎಷ್ಟು?
51 ಆಮೇಲೆ ಇನ್ನೊಂದು 82 which I was mentioning yesterday.
ಆಯ್ತು, we'll take it. What time is your flight?
ಇಲ್ಲ ಇದೆ, tomorrow also I am before your lordship. ಅದಕ್ಕೆ
You are here today. Haga we'll take it at 5:30. Yes.
Serial number 212.
Wait sir, adjournment ಬೇಕಾ?
No, I'm ready for the matter. The petitioner is retiring in 8 months. He's seeking absorption services. So
wait, we'll continue at 2:30.
My lord, serial number 120, it is a tax matter covered by the decisions. Your lordship.
ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ.
But if your lordship places by 2:30.
ಮಧ್ಯಾಹ್ನ will take.
Please, oblige.
102 my lords may be referred to mediation.
102.
Please, I'm for the.
Matrimonial.
Of you.
Please.
102 ಅಲ್ಲಿ, both the learned counsel appearing for the petitioner and the respondent in unison seek reference of this matter to mediation for exploring the chances of settlement between the parties. In the light of this submission, the parties to appear before
3rd December.
Appear before the mediation on 3rd December. List the matter on 10th December.
Serial number 184, my lord.
Yes,
My lords, one matter that was disposed on 1710, my lords, it's not been released.
ಹೌದಾ? 1710.
Please, my lords.
Let me see.
My lord.
Check ಮಾಡಿ.
My lord, serial number 111, my lord. Last occasion, this honorable court has directed to file a synopsis with event dates, my lord. My lord, 2 days accommodation, my lord.
Wait, ಅದು ನೋಡೋಣ ಆಮೇಲೆ.
Serial number 41 my lord.
Madam, adjournment ಯಾರು ಬೇಕಾದ್ರೆ ಕೊಟ್ಟಿರಿ.
My lordship, serial number 65.
Serial number 184, my lord.
Yes, Vijay Kumar ಏನು?
My lord, serial number 184 relates to withholding of pension, my lord. He retired in 2014. There's some urgency, my lord. He is bedridden. Let it be taken up, my lord.
I'll take it up at 2:30.
Please.
Mention at 2:30. Who respondent ಯಾರು?
Respondent government, my lord.
Madam, be ready in that. Yes.
184.
41 next week. I inform Mr. Sadi Goodwal.
Yeah.
Please.
179. Education Department. In form of five instruction that in 1991, he passed MA in mathematics, scoring 51.6% pass. In 93, he was appointed as a part-time lecturer in sanctioned post and sanctioned workload in SD College, where he worked till 2004. In 2004, the position which he was holding was classified for reservation. So he had to come out because he belonged to the general category. He was asked to go out. Till 2004, he worked there. Then 2010, he is working as part-time lecturer with the fifth respondent against sanctioned position and sanctioned workload. Even now, he is working as part-time lecturer. In 2000, he, along with 110 part-time lecturers, they had filed a writ petition in the High Court uh, regarding the implementation of the High Power Committee recommendation for absorption of part-time employees. Annex K.
ಆಯ್ತು ಹೇಳಿ, ಫಿನಿಶ್ ನರೇಶನ್, ಫಿನಿಶ್ ಯುವರ್ ನರೇಶನ್.
Annexure.
ಅಲ್ಲ ಅಲ್ಲ, ಏನ್ ಹೇಳಿ, ಏನಾಯ್ತು?
Yeah, I'll just read it. This Annexure H, this is a writ disposed of by Justice Dattu in the year 2000. Petitioner is number 70 in that writ petition. He, along with 110%. The submission was made in the court that a similar matter was pending in the Supreme Court. Therefore, it was suggested that whatever order is passed by Supreme Court in that matter be binding. This is the summary. I'll just read out only two paragraphs.
You have told me, ಆಮೇಲೆ ಏನಾಯ್ತು?
Shall I read that part?
Not necessary.
Okay. In that case, thereafter, the matter was agitated before the Supreme Court. That is Annexure J. That is the order passed by the Supreme Court.
ಆಮೇಲೆ
This order was passed in 2001. This is an outcome of the two civil appeals filed by the part-time lecturers as also by the state government. The writ came to be, the civil appeals came to be disposed of against the order passed by the Karnataka High Court, wherein it was held that the civil rules of 1996 are held as unconstitutional. The High Court took the view that this is discriminatory and it is nothing but backstage entry. So Supreme Court overruled that this is not a backstage entry and this is the proper because due process of law was. I may just read out page number 71, para 3. These cases involve not only a question of law but also a human problem in as much as these part-time lecturers have served in different colleges for varying period of 10 to 20 years, and if they are not regularized and treated as regular servants, then they will not be able to get themselves engaged anywhere else, and at the same time, their experience in teaching will be a great loss to the student community. This is what
10/2025. Action is there, Your Lordship, to secure instructions and make a submission.
Constitutional validity of
Objections ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಅದಕ್ಕೆ I will.
2019, madam.
Please, your lordship.
ಹ್ಮ್.
First week of December, your
Rule issue
lordship.
ಆಗಿದೆಯಾ?
My lord, my submission is that he's hardly left with 7-8 months service. And he has been fighting for last 2010. 2019 writ is filed. And writ will become infructuous if it is not disposed of. It is not for the case.
Infructuous, sir.
It will
Nothing will become
if it is not,
infructuous.
if it is not,
If you have filed
should
something
not be,
if you have filed something before your retirement, nothing will become infructuous except orders of suspension.
First week of December, your lordship. I will file and get the instructions also, your lordship.
Madam, these absorption rules,
Please,
what
your
is
lordship.
challenged?
Please,
The
your lordship.
subject matter before this.
Please,
I am telling you what you should look at it.
please, your lordship.
Between 1991 to 1993, who were all working as part-time lecturers, were directed to be absorbed by the apex court in first judgment. Later, offshoot is the second judgment, which is now relying on. So you should just see the dates and events that he was a lecturer. He says 2004 only he was removed for the purpose that it was declared to be a post for SC or ST. And again, he continues as a part-time lecturer now, since from 2010 till here. What is that gap and everything you should know. You should look into that, either file objections or make your submissions.
I will file objections along with
Because he's left
submissions.
with 8 months.
Please, your
service.
lordship.
We will give you, since it is 8 months, we'll give you 8 days.
Please, your lordship. 8 days.
I'll post it on 9th December.
Please, your lordship.
Avattu list the matter on 9th December at 2:30 p.m. Objections, if any, by the state by then.
can it be posted to 8th or 6th?
ಯಾಕೆ 9th ಚೆನ್ನಾಗಿಲ್ವಾ?
6th December or 8th December?
9th is not a good day?
No, not that way.
All right. 8th December.
Please, your lordship.
ಇನ್ಯಾವುದು 2:30? 184? ಹಾಂ, ಕೊಡಿ. ಏನು ವಿಜಯ್? Caste certificate matter?
Lord, yes, my lord.
Ah.
Lord, the petitioner was appointed as a assistant teacher, my lord, in Ramnagar district, in an aided institution. Lord, he obtained a caste certificate from his original district, that is Haveri district, my lord, from Badgi Taluk, stating that he belongs to Bovi caste. Lord, based on that, he was promoted as headmaster. Lord, on 16/7/2007, my lord, a complaint is made to CRE cell. Lord, suo motu CRE cell proceeds with the investigation and my lord submits a report to District Caste Verification Committee at Ramnagara, which invalidates the caste certificate. And he retired on my lord 31/3/2014. Lord,
Retired already.
On 9/7/2014, FIR is registered, my lord, for offence under section 3. Thereafter, my lord, he was acquitted on 6/2/24. Lord, now because of the invalidation of the caste certificate and the appeal filed by him before the appellate authority, my lord, having been rejected, Lord, his pensionary benefits have been withheld, my lord.
Yes, Jagdish, sir.
Kindly turn to page number 51, my lord. They claim that as per as the my lord, merit is concerned, my lord, I have got a strong objection. As per the technical ground, my lord, I sail with my friend. His brother.
Technical ground of what? So moto CRE cell could not have taken up investigation.
And moreover, my lord, caste verification
as
committee of
simple as
Ramnagar
that.
could not have, my lord. Ramnagar could not have.
Oh, no. Virtually it amount to allowing a thief to retain a stolen property. How can a Besta community person can take a certificate? Allah Swami, Pestru ಹೋಗ್ಬಿಟ್ಟು ಗೋವಿ ಅಂದ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
General argument address.
Allowing the thief to retain the stolen property. Yes.
Yes, my lord. Kindly turn to page number, my lord, 51, para 2. I myself has appeared before the appellate authority. As a matter of fact, from the third line, my lord, the appellant sister Kamalava.
Sir, CRE cell could not have taken up so moto
ಅಲ್ಲ
investigation.
ಟೆಕ್ನಿಕಲ್ ಪಾಯಿಂಟ್ ಗೆ ನಾನು ಒಪ್ಕೊಳ್ತೀನಿ ಬಟ್ ಆಸ್ ಪರ್ ಆಸ್ ದಿ ಇಂದು ಗಂಗಾ ಮಕ್ಕಳು ಅಂತ
District Caste Verification Committee, Ramnagar could not have invalidated the caste certificate issued by Haveri district.
Vijay Kumar.
ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ಐ ಆಮ್ ಸೇಲಿಂಗ್ ವಿತ್ ದಿ ವಿಜಯ್ ಕುಮಾರ್ ಐ ಡೋಂಟ್ ನೋ ವೈ ಓನ್ಲಿ ಆನ್ ಎ ಟೆಕ್ನಿಕಲ್ ಪಾಯಿಂಟ್ ಮಿಲೋಡ್ ಐ ಅಗ್ರಿ
If both of you leave me, I will tell something. If
ಲಿಬರ್ಟಿ ಮೇ ಬಿ ರಿಸರ್ವ್ಡ್ ಟು ಮಿಲೋಡ್ ಆರ್ ಎಲ್ಸ್
wait, sir. Yes.
Please,
This
please, my lord. I am sorry, my lord.
CRE
I am sorry.
Complaint is by an RTI activist, my lord. He's not an aggrieved person, my lord.
ಇದೇ VC ಪ್ರಾಬ್ಲಮ್. ಎಸ್.
ನಾನು ಇದರಲ್ಲಿ ಐಪ್ಯಾಡ್ ಅಲ್ಲಿಂದ ಫೋನ್ ಅಲ್ಲಿ ಲಾಗಿನ್ ಆಗಿದ್ದು ಸ್ವಾಮಿ ಈಗ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ. ಐಪ್ಯಾಡ್ ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ.
ಈಗ ಇಬ್ರು ಸುಮ್ಮನೆ ಇರಿ ಒಂದ್ ನಿಮಿಷ. Yes.
Please, my lord. Please, my lord.
If CRE cell did not have jurisdiction to initiate so motu proceedings, and that is the foundation for all the issues, all the things that have happened in the aftermath of the CRE cell's investigation would become null and void. Correct?
Please, my lord.
ಅಷ್ಟೇ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ಲಾ? Yes.
ಅಲ್ಲ, ಲಿಬರ್ಟಿ ಮೇ ಬಿ ರಿಸರ್ವ್ಡ್. ಯಾಕೆ ಅಂದ್ರೆ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ. ಒಂದ್ ನಿಮಿಷ ಆಗ್ಲಿ 2014 ಅಂದ್ರೆ
ರಿಟೈರ್ 11 ವರ್ಷ ಆಗಿದೆ, ಈಗ ಯಾವ ಲಿಬರ್ಟಿ ಸರ್?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಮಕ್ಕಳೆಲ್ಲ ತಗೊಂಡ್ರೆ ಏನಾಗ್ಬೇಕು ಗತಿ? ಇದು ಕೊರೋನಾ ವೈರಸ್ ತರ ಸ್ಪ್ರೆಡ್ ಆಗ್ತಿದೆ ಅಲ್ಲ. ಲೆಟಿಂಗ್ ನಾಟ್ ಯೂಸ್ ದಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ಮಾಡಿದ್ರೆ ಪರವಾಗಿಲ್ಲ.
ಅದು ಮಾಡೋಣ.
ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಮಕ್ಕಳು ತಗೊಂಡ್ಬಿಟ್ರೆ
ಯಾರು ತಗೊಳಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ ತಗೊಳ್ತಾರೆ ಸ್ವಾಮಿ,
ಇಲ್ಲ ಸ್ವಾಮಿ
ತಗೊಳ್ತಾರೆ. ಅದನ್ನ ನೀವು ಯು ಶುಡ್ ನಾಟ್ ಮೇಕ್ ಯೂಸ್ ಆಫ್ ದಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅನ್ಬಿಡ್ರಿ.
I will record it here.
Yes.
The stolen property shall not be used for any other purpose except stealing further.
I bow down my head, my lord. I bow down.
All right. Pension ಬಂದಿಲ್ಲ ಅಂತಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ ತಗೊಂಡೆ ಇದನ್ನ ಔಟ್ ಆಫ್.
Yes, my lord. That is the reason he is in. I heard that, my lord, he is in deathbed. Therefore, there was a necessity of moving the matter.
We'll give it. Now he'll swing back.
I don't know, considering the age, and he is totally blind, I believe, my lord.
Blind?
He has gone blind.
All right.
Sugar ಜಾಸ್ತಿ ಆಗಿರ್ತದೆ ಅದಕ್ಕೆ.
Sugar ಜಾಸ್ತಿ.
Oh. The petitioner is before this court calling in question. ಯಾವ ವರ್ಷದಿದು?
2017.
The petitioner is before this court calling in question the Vijay Kumar sir, ಅದು ಜಡ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ CRE cell does not have jurisdiction ಅಂತ ಕೊಡಿ.
ಒಂದು ಇದು ರಾಜಣ್ಣ ಜಡ್ಮೆಂಟ್ ಸರ್, 3 ಇದೆ ಸರ್.
4 of rule 7 is very clear, my lord.
First justice Raman Reddy
sub rule ಅಲ್ಲ, sub rule 4 of rule 7 statute is clear.
Yes, the petitioner is before this court seeking the following prayer. Heard so and so. Facts adumbrated are as follows. The petitioner is appointed as an assistant teacher in Arohalli Vidya Samsthe, an aided institution against an aided post. The petitioner is said to have submitted a caste certificate. Petitioner is said to have secured the employment on the strength of a caste certificate depicting him to be belonging to Bovi caste.
No, my lord. He used that caste certificate only for promotion as headmaster, my lord.
All right. Sorry. The petitioner is said to have submitted the caste certificate that was in his possession, which depicted him to be belonging to Bovi caste, for securing promotion to further to promotion to the post of headmaster.
Sorry, my lord. Yes. ಒಂದೇ ನಿಮಿಷ ಸ್ವಾಮಿ. ಬೋವಿ which is notified as scheduled caste ಅಂತ ಬರ್ದ್ಬಿಡಿ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಬೋವಿ notified as scheduled caste. So the petitioner was then promoted as headmaster against a post reserved for SC or ST, and the same was approved by the competent authority. When things stood thus, on 16/7/2007, a complaint comes to be filed before the Civil Rights Enforcement Cell, alleging that the petitioner had obtained a false caste certificate that he belongs to scheduled caste Bovi, though the petitioner belonged to what community? Jedara?
Gangamata, Besta.
Gangamata community. On the said complaint, on the said complaint, the Civil Rights Enforcement Cell so motu institutes proceedings on the complaint and directs the matter to be directs investigation into the matter by the hands of at the hands of the Deputy Superintendent of Police of the CRE cell. The CRE cell, an investigation is said to have been conducted without notifying the petitioner even, and the result of the investigation is the direction to the District Caste Verification Committee to initiate proceedings towards cancellation of the caste certificate. The petitioner in all these, in the interregnum, retires on attaining the age of superannuation. The petitioner files an appeal, based upon the said report, the two proceedings spring. One, the one initiated by the District Caste Verification Committee, in which the certificate of the petitioner stood cancelled, and the other, a crime registered in crime number 216 of 2014. Insofar as the criminal case is concerned, it is the learned counsel for the petitioner submits that that he has been acquitted in the said case, and the acquittal has become final. The issue now, the issue that is now to be considered at the hands of this court is whether the civil rights enforcement cell could have entertained the complaint and initiated suo motu investigation without the matter being referred to by the District Caste Verification Committee to the hands of the CRE cell for the purpose of conduct of investigation. The learned investigation. The learned counsel, Vijay Kumar Bhajantri, appearing for the petitioner, would submit that the CRE cell did not have jurisdiction to conduct a suo motu investigation upon the complaint unless the Caste Verification Committee had directed it to do so. The learned counsel submits that since the foundation is the investigation conducted by the CRE cell, all the subsequent proceedings would become a nullity in law. For contra, the learned counsel C. Jagadish would submit that would admit the position of law as it is ingrained in the statute itself, that the CRE cell does not have suo motu powers to begin investigation without the matter being referred to it by the District Caste Verification Committee, and therefore would submit that on technicality, the petitioner may have a case, but not on the merit of the matter. He would further submit that the caste certificate that is now become the bone of contention should not be used by any other family member of the petitioner, as the caste certificate is admittedly false. I've given my source. Therefore, narrated facts are not in dispute. The aforesaid issue needs to be considered, and the consideration of which would be upon the noticing of the statute, the SC Act, madam, blue book is notice. Section 4, Rule 4, yes. Rule of section
Sub Rule 4 of Rule 7, my lord. Sub Rule 4 of Rule 7.
Rule 7 quote madi. Sub Rule 4 of Rule 7 mandates that the CRE cell can spring into action only on a reference being made by the District Caste Verification Committee to conduct an investigation with regard to any caste status of any person. The jurisprudence is replete with the judgments rendered by the coordinate benches of this court or this court even with regard to the power of the CRE cell taking up suo motu investigation. The judgment cell.
I'll submit.
You will submit.
Latest one is WP 46919 of 2014, my lord, decided on 7th July 23.
No.
I'll furnish it along with the memo. I'll furnish it along with the memo.
Then I'll finish the judgment along with the memo.
Please.
After 1 week.
Lord, sorry, my lord.
Art Vijay Kumar sir, ನೀವು ಹಿಂಗೆ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
Illa, I'm sorry, my lord.
Jurisprudence is replete so and so. In the light of the statute being unambiguous with regard to the power of the CRE cell emerging only on a reference being made by the District Caste Verification Committee, the proceedings that have now emerged from the hands of the CRE cell and all its aftermath would become a nullity in law, as the foundation of all the foundation for all the litigation that is now generated before this court is the action of the CRE cell. Therefore, if the foundation is contrary to law, the superstructure built on such foundation would necessarily tumble down. In the light of the judgments rendered by the coordinate benches of this court or this court as the case would be, and the statute, the petition deserves to succeed, albeit in part. The petition stands allowed. The impugned orders, the orders date, the impugned orders 21/6/24, 17/5/24, 28/2/2017, all stand obliterated. The terminal benefits of the petitioner, if have been withheld on the strength of the aforesaid orders, shall all be released without broking any delay. The learned counsel for without broking any delay, it is made clear that the subject caste certificate should not be used by any family members of the petitioner for any benefit to claim that they belong to scheduled caste or scheduled tribe in the peculiar facts of this case.
Not time frame for release of the pensionary benefit.
The benefit shall be released within 12 weeks from the date of receipt of the copy of this order. 12 weeks,
But I read along with the memo judgment.
4 weeks, sir. Yes.
Serial number 113.
I'll give it just an immediate, today itself I'll file it now.
Yes, sir.
Please.
I'm sorry, my lord. Serial number 113, 165. This will be taken on the first week of December. Beda Jangamada, you caste certificates there.
Beda Jangamada.
130 I appeal.
One Beda Jangama is in the remand.
Beda Jangama.
Covered by judgment to the other objects.
130 pertains to Channadasar community. I challenge the remand order, my lord, of the.
We'll take it on 7th, on 4th December.
Obligation.
Please.
Avat Mukspurna Jagdish, sir.
I've served him a copy.
Please,
There's an interim order operating.
I have received copy.
Interim order. Yes.
Obligation.
Yes, sir.
Srinand Pachapure,
Serial number?
39.
Lordship had directed us to serve the respondent. They have refused, my lords, have filed an affidavit.
Refused?
Yes, my lords. They say,
Interim
my
order
lords,
kelidira?
has to come through court.
Interim order kelidira?
Illa, interim order. It's a direction to send the records, my lords, to the, from the.
Then what's the matter? Pension
In
ಕೊಟ್ಟಿಲ್ವಾ?
pension, your lordship.
Papers
are not sent.
Lordship had, my lords.
Papers ಯಾರು ಕಳಿಸಿಲ್ಲ?
Respond
Department.
number 4.
ನೀವು
The
retire
college.
ರಿಟೈರ್ ಆಗಿದ್ಯಾ ಯಾವಾಗ?
4 and 5.
ರಿಟೈರ್ ಆಗಿದ್ಯಾ ಯಾವಾಗ?
Retire ಆಗಿದ್ದು.
ಎಲ್ಲ ಫಾಸ್ಟ್ ಆಗಿರ್ಬೇಕು. What is this?
31/5/25.
31st.
31/5/25.
5/20/25.
What were you there?
Lords, he was a professor in the Department of Electrical Engineering.
Professor,
College of Respondent number 4.
Which college is this?
Aided college, Lords, Maratha Mandal Polytechnic College.
Maratha Mandal Polytechnic College,
Yeah.
Aided institution,
Please, your lordship.
Aided.
They are supposed to send the papers.
affidavit
to-
ಹಾಕಿದ್ದೀರಾ?
Yes, affidavit, Lords, I filed, Lords.
This court on 27/10/2025 directed the fourth respondent to be served by way of hand summons, owing to the urgency of the situation where a retired teacher is not paid pension on the sole score that the fourth respondent institution has not furnished the papers for processing pension to the state government. The learned HCGP pleads helplessness in grant of pension for the reason that the fourth respondent has not submitted the papers. The affidavit also indicates that the fourth respondent has not received the hand summons that was directed by this court. In that light, the state government shall issue a notice to the fourth respondent as to why its grants should not be stopped if the papers are not sent by the next date of hearing. The notice shall be issued and the issuance of notice shall be placed before this court on the next date. List the matter on 1st December. ಇವಾಗ ಕಳಿಸ್ತಾರೆ ಗ್ರಾಂಟ್ ಸ್ಟಾಪ್ ಮಾಡಿ ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ.
Please.
ರಿಟೈರ್ಡ್ ಟೀಚರ್ಸ್ ಹತ್ರ ತೊಂದರೆ ಕೊಟ್ರೆ ವಿಲ್ ನಾಟ್ ಲೀವ್ ಎನಿಬಡಿ. ಟೀಚರ್ಸ್ ಅಂತಲ್ಲ, ಎನಿ ರಿಟೈರ್ಡ್ ಪರ್ಸನ್. ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಟು ಫಾಲ್ ಬ್ಯಾಕ್ ಅಪಾನ್. ಪೆನ್ಷನ್ ಇರೋದು. Particularly teachers, they're not white collar jobs where other things will be there.
Please.
It's not trouble teachers. Yes.
Please, your lordship.
Number 40 HM Dharigon, Srinand Pachapure.
Petitioner pertaining to my lord the
ಈ ಕಡೆ ಬಂದು.
Rajesh.
Yes, respondent.
40?
40 my lord.
40 minutes.
PDS.
Goodola
Oh, adu.
No, Goodola should come this side, my lords, he's on my side.
Oh. Yes, sir.
My lord, during pendency of the inquiry regarding disability certificate,
The authorization given to the malad the respondent, fifth respondent.
ಇದು ಲಾಸ್ಟ್ ಇಯರ್ ಮಾಡಿದ್ದು.
ಹೌದು. ಅದು ರಿವ್ಯೂ ಹಾಕಿ ಅದು ಸ್ಟೇ ಕೊಟ್ಟು ತಾವು.
Writ appeal, my lords, even my lords, Goodall's client also filed writ appeal that my lords, your lordship's order confirmed. Dharwad's my lords client also filed writ appeal. They withdrew it, saying that subsequently we have filed a writ.
The order is confirmed by division.
Yes, it is confirmed.
ಈಗ ಏನು?
ಅಲ್ಲ ಅವ್ರು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ನಾವು ವಿತ್ಡ್ರಾ ಮಾಡಿ ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ನಾವು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
ಆಯ್ತು.
My submission is my lord the annexure F for a moment kindly say annexure E. Page 36 my lord. Operative portion C my lord.
Page
36.
ಅದಕ್ಕೆ ಮುಂಚೆ ದರಿಗೊಂಡ್ರೆ ಒಂದು
Please,
ನಿಮಿಷ.
please.
I'll just go through my order, annexure E.
Please.
Annexure E is the first order.
Please. ಅದೇ annexure ಇದೆ.
ಅಲ್ಲ ಒಂದೇ ಆರ್ಡರ್.
ಅದೇ ಒಂದೇ.
ಗೊತ್ತು.
ಅದೇ
ಅದರಲ್ಲಿ
order ಅಲ್ಲಿ.
you are not a party there.
Please. ನಾನು not a party.
Correct. You are not a party.
ಇದು one of the candidate ಮೇಲೆ applied that post.
ಒಂದು ನಿಮಿಷ.
That writ petition was allowed on 2 grounds.
ಇಲ್ಲ ಇದು ನೋಡ್ತಾ ನಾನು ಅದನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ ತಾಳಿ.
Your lordship will get it at
ಪೇಜ್ 36 ಅಲ್ಲಿ ಇದೆ.
Page 36.
34 ಅಲ್ಲಿ ಸಿಗುತ್ತೆ.
ಏನು ಗ್ರೌಂಡಾ?
ಇಲ್ಲ, ಅದು ತಾವು ಅಲೋ ಮಾಡಿದ ರೀಸನ್.
ಅದು 36 ಅಲ್ಲಿ ಇದೆ.
55 ಅಲ್ಲೂ ಇದೆ. 2 ಗ್ರೌಂಡ್ ಬಿಟ್ಟದೆ.
Allowed impugned orders are quashed.
Please.
The official to allot the fair price shop in favor of the petitioner if he fulfills all other conditions except the two considered in the course of the, which are those two?
One is, my lord, I was not a resident of village. And another, my lord, is rejected on the ground, he is doing a business in residential house.
Correct, alva?
2 ground ಮೇಲೆ.
2 ground ಮೇಲೆ
ಚಟಾಚಟಾಗಿ
if he fulfills the conditions other than these.
Other than.
Now the said process allotment in favor of shall be done in 30 days from the date of receipt. ಆಯ್ತು. ಇದ್ರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರಾ?
Yes.
Next
ಹಾಕಿದ್ದು
Next to the repetition.
ಅದಕ್ಕೆ ನೀವು ಹಾಕಿದ್ರಿ. ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನ್ ಕನ್ಫರ್ಮ್ ಆಯ್ತು?
Confirm.
So this was taken forward and ಏನ್ ಮಾಡಿದ್ರ ಆಮೇಲೆ?
Thereafter my lord the issue authorization within 28 days.
ಮಾಡಬಾರ್ದು ಅಂತಿತ್ತ?
ಅಲ್ಲ ಮಾಡಬಾರ್ದು ಅಂತಲ್ಲ. But the other condition not at all my lord the
ಒಂದು ನಿಮಿಷ. If he fulfills all other conditions. ಈಗ all other conditions fulfill ಆಗಿಲ್ಲ.
ಇಲ್ಲ. But the enquiry is pending before the authority regarding disability certificate. Authorization given to the my lord the fifth respondent.
Disability certificate ತೊಂದರೆ ಇದೆಯಾ?
ಹೌದು.
My request, my submission, my lord, I am out of my lord this thing. Other, my lord, there are other disabled persons. They should have been given opportunity. But so that it can be redone, to giving all the opportunity to all the persons.
ಅದೇ, if all other conditions except the two considered in the course of the order.
So my only submission is this. It's when my lords, Dharwad's client wake up, my lords, is after his application being rejected, after 1 year, lords, they have produced the order copy, lordship may see the order.
What is the order under challenge now?
Yes, no, your lordship may see annexure C, my lords. The Dharwad's client is at page, lords, 22, serial number 3. His application came to be rejected on 27/10/2023. From then, he is sleeping till the writ appeal order is not confirmed, your lordship order is confirmed. He wakes up, it is only after the dismissal of this writ appeal, lords, Goodall's client's writ appeal, but he wakes up.
He is also a disabled candidate.
He is also disabled, he is not eligible, his rejection is on the ground that he does not fulfill 50%, there is no balance in the account as per the rules.
Disability.
He doesn't challenge this. This is
50% disability.
Yes. This was taken by my client, lords, respond number 6 herein, to the appellate authority. There also it got confirmed. Then your lordship, lords, quashed both the orders. That is being confirmed. After 1 year, almost 2 years, lords, 2 years, he comes with this complaint.
That's all right. But what is the proceeding pending against you? Disability proceeding?
No, that is what he files a complaint. After all these things.
What date of the complaint?
7/3/2025.
Lords, he files a complaint. That complaint itself is not maintainable as per the yes, 7/3/25 he files the complaint.
7/3/2025 is the complaint.
Yes, madam.
So that is what ಅದೇ ಪೆಂಡಿಂಗ್ ಇರೋದು ಅಂತ ಹೇಳ್ತೀರಾ?
Annexure J notice issued by
ಅದೇ ಪೆಂಡಿಂಗ್ ಇರೋದು ಅಂತ ಹೇಳಿ.
Then my lord notice issued on 5/4/2025. Annexure J.
ಈ ಪೆಟಿಷನ್ ಹಾಕಿರೋದು ಯಾವತ್ತು ಸರ್?
Writ petition.
There are 2 petitions my lord.
ರಿವ್ಯೂ ಹಾಕಿದ್ದು ಯಾವತ್ತು ನೀವು?
Review
review order, my lords.
ಅಲ್ಲ ರಿವ್ಯೂ
You filed in the year 2025.
ರಿವ್ಯೂ ಪೆಟಿಷನ್ ಹಾಕಿದ್ಯಾ ಅವತ್ತು?
Annexure M maladi 25 maladi. Page 60 maladi.
ಅಲ್ಲ ಅದಾಯ್ತು.
ಅಲ್ಲ ಆರ್ಡರ್ ಅಲ್ಲ ಸಾಹೇಬ್
ಪೆಟಿಷನ್ ಹಾಕಿದ್ದೆ.
Petition ಆಗಿದೆ in the year 2025.
ಇಯರ್ ಗೊತ್ತು ಸರ್, ಡೇಟ್.
Date 10/3
ಅದ್ರೊಳಗೆ ಐತಿ
17/3/25 maladi.
17/3.
25.
10/3/25 minutes.
So complaint is 7/3/25.
Please.
Review is 10/3/25. Yes, sir.
Notice issued by the authority on 5/4/2025. Direct the fifth respondent to appear before the the Beams Hospital for regarding disability certificate. Annexure J page 57.
ಈಗ ಮುಂಚೆ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು? ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದು?
ಇವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ,
ಅವ್ರು ಕೊಟ್ಟರು.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು. ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು ಕ್ವಾಶ್ ಆಯ್ತು.
That was Millards, given Millards, without he being a resident Millards, he.
ಅದಾಯ್ತು. Whatever, that is, he is out of the race because it's confirmed.
My submission is,
Millards, your lordship would
let them,
consider the request
let
of
them
this
issue the notification. Till then continue the fifth respondent. Other candidates are there, Maladi. Without consider the other candidate.
ನಿಮಗೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ, ನೀವ್ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ?
ಅಲ್ಲ Maladi, there is a writ petition pending before the honorable court. He challenge the Maladi.
ನಿಮ್ದು ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೋದಾಯ್ತಲ್ಲ, ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
That is challenged by the fifth respondent.
ನೀವು
before the honorable
ಹಾಕ್ಬೋದಾಯ್ತಲ್ಲ,
court.
ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ? ನಿಮ್ದು ರಿಜೆಕ್ಟ್ ಆಯ್ತಲ್ವಾ?
But after came to know that Maladi.
ಆಯ್ತು, ರಿಜೆಕ್ಟ್ ಆಯ್ತಲ್ಲ, ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
ಅಲ್ಲ ರಿಜೆಕ್ಟ್ ಆದ Maladi, he came to know that Maladi disability certificate produced by the Maladi fifth respondent is fake.
ಓ, ಅಲ್ಲಿವರೆಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ.
Therefore Maladi filed a complaint before the Maladi respondent. There was Maladi stay granted by this honorable court. Maladi matters are pending before this honorable court. My submission is, let them read issued Maladi notification. Till then continue the fifth respondent. Till
This is nothing.
Other candidates are there.
My great submission Millards. This is, yes.
Yes, government. ಲಾಸ್ಟ್ ಒಕೇಶನ್ ಈಗೇನ್ ಹೇಳಿ? ಯಾರ್ದು? ನಿಮ್ದಾ?
Same 75% ಇತ್ತು. This was 10 years back Millards. It was registered under UID also Millards. If that was their grievance, they could have challenged it earlier only Millards.
ಅಲ್ಲ ರೀನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರೆ ಏನು ತೊಂದ್ರೆ? ಅವ್ರು ಎಲಿಜಿಬಲ್ ಇದ್ರೆ ಅವ್ರು ತಗೊಳ್ತಾರೆ. Re-notification ಮಾಡಿದ್ರೆ ಅವ್ರು ಎಲಿಜಿಬಲ್ ಇದ್ರೆ ಅವ್ರಿಗೆ
75%. ಅಲ್ಲ, but here what happened Millards, ಇವ್ರು ಬೇಕಂತ ಹೋಗಿ ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ಬೆಳಗಾಮಲ್ಲಿ ಕೊಟ್ಟು notices were issued. He was threatened, saying, Millards, I put it on the other side Millards, saying that once you come and re-examine yourself at medical, no, I put it in record Millards. Statement ಅಲ್ಲಿ ಇದೆ 45% in disability ಕೊಡ್ತೀವಿ ನಾವು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Then we requested this honorable court at the earlier occasion Millards, when the court directed for medical board, we requested Dharwad Caste. Other than Belgaum, elladru Millards, we are ready to go to Gulbarga also. Court said you go to Dharwad, then the government advocate was directed. 75% anta ide. Despite all this,
ಟೆಂಪರರಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. 75% ಟೆಂಪರರಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಟೆಂಪರರಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕ್ಯಾಟ್ರಾಕ್ಟ್.
Subsequently Millards, he has developed cataract. Other than ಹೇಳ್ತಾರೆ 55%.
What disability do you have?
No,
ಅಲ್ಲ ಏನ್ ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಏನು?
ಅಲ್ಲ ಎರಡು ಕಣ್ಣೇ ಹೋಗುತ್ತೆ.
ಡಿಸಬಿಲಿಟಿ ಏನು?
ಅಲ್ಲ ಕಣ್ಣು Millards 75% ವಿಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಮತ್ತೆ ಕ್ಯಾಟ್ರಾಕ್ಟ್ ಸರ್ಜರಿ ಮಾಡಿಸು.
No, now they are saying not. Now this report, what it says, is given provisionally because he has developed cataract. But this Millards, 10 years back, he had showed it Millards before Joshi Hospital Millards. He was advised cataract ಅಂತ ಇವರು Millards ಹೇಳಿದ್ದಾರೆ. ತೆಗೆದ್ರನು Millards 75% ಬರುತ್ತೆ. But not at this stage. What I am saying is Millards, 10 years before the certificate was issued, it was entered in UID. They never challenged it Millards. They come Millards only after Millards seeing the results of the court. They are watching it.
ಅಷ್ಟೇನಾ?
ಅಲ್ಲ ರೀನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿ ಅವ್ರು ಎಲಿಜಿಬಲ್ ಇದ್ರೆ ಅವರೇ ಅಲ್ಲಿ
ನಾನು ಡಿಸೈಡ್ ಮಾಡ್ತೀನಿ.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
This court directed my lord medical board to examine 75% temporary disabled.
ಅಂದ್ರೆ ಕ್ಯಾಟ್ರಾಕ್ಟ್ ತೆಗೆದ್ಬಿಟ್ರೆ ಹೋಗ್ಬಿಡುತ್ತೆ.
Provisionally ಅಂತ ಹೇಳ್ತಾರೆ. It's not cataract or Millards will produce documents if they feel that again this is because they did not get it done in Belgaum Medical Board. Here it is being done. 75% they have given. That 75% was a disability which was given.
ಈಗ ಮುಗಿಸೋಣ. The petitioner is before this court calling in question an order dated 11/8/2025 by which the third respondent grants the license to run the fair price shop in favor of, which respondent are you?
Respondent for 5 minutes.
In favor of the fifth respondent. Heard so and so. Facts in brief, Germain, are as follows. The petitioner is a disabled person who has disability to the tune of 45%, huh?
55.
50%, to the tune of 50%. So is the fifth respondent. The two were participants in a process for allotment of a fair price shop when it was notified on 15/9/2023.
There are 6 candidates applied.
Out of the candidates that were chosen, the sixth respondent, yaar niಮಗೆ ಕೊಟ್ಟಿದ್ದಲ್ಲ first?
Please.
The sixth respondent was selected as the candidate eligible under the said notification, and the fair price shop was awarded in favor of the sixth respondent. The fifth respondent challenges the said allotment before this court in writ petition.
First before the appellate authority, then
Before the appellate authority.
Annexure
And
D.
the appellate authority confirms the allotment in favor of the sixth respondent. This is challenged by the fifth respondent before this court in writ petition 106605 of 2024, which comes to be disposed by an order dated 12th February 2025, directing the respondent state to consider the cases of consider allotment of the fair price shop in favor of the petitioner if on certain terms and conditions. This is challenged by the sixth respondent before the division bench in writ appeal 100131 of 2025. The writ appeal comes to be rejected without interfering with the order passed by this court. This court. The result of the rejection of the writ appeal on 4th March 2025 is the allotment of the fair price license, issuance of license to run the fair price shop in favor of the fifth respondent herein. In all these proceedings, the present petitioner was nowhere in the picture. After the allotment, after the rejection of the writ appeal and the allotment of the fair price shop in favor of the fifth respondent, a review petition comes to be filed seeking review of the order. Writ appeal ಹಾಕಿದ್ರಲ್ಲ?
Subsequently, madam.
First writ appeal ಹಾಕಿದ್ರು.
ಇಲ್ಲ,
ಆಮೇಲೆ
subsequent,
ಹಾಕಿದ್ರು.
ಆಮೇಲೆ.
A review petition comes to be filed in RP 1001027 of 2025, which comes to be rejected, reserving liberty to the petitioner to avail of such remedy as available in law. The petitioner then files a writ appeal and the subject writ petition. In the light of the subject writ petition pending, withdraws the writ appeal. Withdraws the writ appeal, and therefore the present proceedings call in question
One
an order.
submission, madam. Subsequently, one more order passed by the authority, therefore withdraw the writ appeal.
All right, withdraws the writ petition on the score that the subject petition is filed challenging the subsequent order passed by the authority. Therefore, the order, it is the order dated 11/8/2025 which has driven the present the petitioner to this court in the subject petition. The learned counsel Dharwad appearing for the HM Dharwad appearing for the petitioner would vehemently contend that the petitioner's disability certificate itself is doubtful. A complaint is registered, complaint is pending. Therefore, the order of this court, therefore the allotment of fair price shop to the petitioner is in violation of the order of this court. This court was clear in saying that if all other conditions are fulfilled, only then the allotment should be made. According to the learned counsel, The other conditions that are not fulfilled is the disability certificate. Disability certificate. Therefore, he would submit that in the light of the jugglery, the notification be reissued and all of them be permitted to participate in the freshly notified allotment process. Per contra, the learned counsel for the fifth respondent would submit that the complaint is registered on 7/3/2020 on 7/3/2025 and the review petition is preferred on 10/3/2025. The rejection of the application of the petitioner happens on 7/8/2023. The said rejection is not challenged. Having accepted the rejection cannot now question the allotment made in favor of the petitioner. The learned counsel would further submit that the complaint so registered by the petitioner could not have been entertained even and under the scheme of the in terms of law, and therefore submits that there is no warrant of interference at the hands of this court at this juncture. The learned AGA would submit that a medical board was constituted to assess the disability of the petitioner on the complaint so registered. The medical board has rendered a certificate reiterating the disability of the petitioner at 75%, which was
Respondent, fifth respondent.
Fifth respondent at 75%, which was rendered 10 year, the same which was rendered 10 years ago. Therefore, the learned AGA submits that there is no warrant of interference with the challenge to the said petition. I have given my anxious consideration, so on and so on. The afore narrated facts, link in the chain of events and dates are all a matter of record, but would require a slight elaboration. On 15/9/2023 comes the notification calling for applications from eligible persons for allotment of a fair price shop. The petitioner, fifth respondent and sixth respondent, all of them, all three along with others apply. The applications are scrutinized, few are rejected, and one is chosen. The chosen one is the sixth respondent. The rejection of others is as follows. Page 22. 22-23 mark portion. The application of the petitioner also comes to be rejected on a twin score. One, that he did not have 50% of disability, and the other, he did not have the necessary balance in his account. The said rejection of the petitioner is not challenged by him, but has tacitly accepted the rejection. The fifth respondent challenges the allotment in favor of the fifth respondent in writ petition 106605 of 2024. This court, considering the cases of both the petitioners, holds as follows, page 33 to 36(7). The sixth respondent, who suffered an order at the hands of this court, challenges the same before the division bench in writ appeal 100131 of 2025. The division bench, by an order dated 4th March 2025, rejects the writ appeal. The rejection of the writ appeal happens, as observed, happens on 4th March 2025. Till the rejection of the writ appeal, the petitioner was in deep slumber, wakes up and initiates two proceedings. One, registers a complaint before the authorities on 7/3/2025. The other prefers a review petition seeking review of the order dated 12th February 2025 passed by this court by filing a review petition on 10/3/2025. The review petition comes to be rejected on 11th July 2025 by the following order. The review petition inter alia, following order, page 62 to 64. The review petition inter alia is rejected on the score that the petitioner also had preferred, ಅವಾಗ ಹಾಕಿರ್ಲಿಲ್ವಾ?
Please.
ಅಷ್ಟೊತ್ತಿಗೆ ಹಾಕಿದ್ರಲ್ಲ?
ಅಲ್ಲ ಅದ್ರ ಮೇಲೆ ಹಾಕಿ.
Sorry, were rejected on the score that there was no error apparent to recall the order. The petitioner then prefers a writ appeal against the said order. During the pendency of the writ appeal, it transpires that an order is passed by the respondent state on 11/8/2025 allotting the fair price shop in favor of the fifth respondent. It is then the petitioner files the subject petition challenging the said order and at the same time withdraws the writ appeal that was filed in the teeth of the subsisting challenge in the subject petition. The learned counsel for the submission of the learned counsel for the petitioner that the inquiry against the caste certificate, against the disability certificate is pending consideration. Therefore, the conditions are not fulfilled is unacceptable. The inquiry that is now said to be pending is a circumstance created by the petitioner himself. As the petitioner registers a complaint on 7/3/2025 holding, alleging that the disability certificate of the petitioner, of the fifth respondent is fake. Is fake, and the disability certificate has stood the test of time since 2015, and the disability has not changed at the tune of 75% then and now. The petitioner, having generated the complaint and several other proceedings, has blissfully forgotten that he has not raised a challenge to the rejection, to his rejection, which happened 3 years ago. Therefore, the action of the petitioner in initiating all these proceedings cannot but be observed to be in absence of bona fides. In that light, there cannot be a circumstance where the notification should be reissued and all of them should be permitted to participate. The order of this court was unequivocal. The order of this court has been affirmed by the division bench, and the affirmation of the division bench has become final. In the light of the order becoming final, as also the fact that the petitioner not raising a finger at his rejection for all these years, or for two long years, cannot now be seen to raise a challenge to the allotment made in favor of the fifth respondent, strictly in consonance with the order passed by this court. The petition, lacking in merit, stands rejected.
In lieu of dismissal, subsequent writ petition also in practice.
ಯಾವ್ದು subsequent ಹಾಕಿದ್ದೀರಾ?
ಇನ್ನೊಂದು writ petition ಇದೆ. In earlier allotment ಮತ್ತೆ challenge ಮಾಡಿ. There are two allotment.
In the light, 40.1 ಅಲ್ಲಿ, in the light of the reasons so rendered in the companion petition, the subject petition also stands dismissed.
May I please, Your Lordship, my Lord?
Almost.
Till number 5, my Lord, is passed on.
Wait, only that.
Please, Mr.
Lords, he's not in a position, Lords, he.
ಹೌದು, bonafides ಇಲ್ವಲ್ಲ, ಕಾಸ್ಟ್ ಹಾಕ್ಲಾ? ಒಂದು 50,000 ಹಾಕಿದ್ರೆ.
ಅಲ್ಲ, caste, question of caste does not, because authorization given 28/2/2025. Immediately filed a complaint.
ಇರ್ಲಿ ಬಿಡಿ, ಆ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗ್ಬಿಡುತ್ತೆ.
Number 42, Sirajuddin Ahmad.
Not appear for the petitioner, my lords.
Bharola.
Yes, my lords.
ಏನಿದು?
3 years almost she has undergone.
ನಿಮಿಷ
302 my lords.
ಎಷ್ಟು ವರ್ಷ?
2 years 9 months.
2 years 9 months. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ದಿನ ಇರ್ಲಿ.
Yes, my lord. No, my lords. In the last date of hearing, a lordship it's said, my lords.
ಇರ್ಲಿ.
Next date ಗೆ ಮಾಡೋಣ ಅಂತ.
302 ಅಲ್ವಾ, ಸ್ವಲ್ಪ ಇರ್ಲಿ.
Yes, my lord. 302 my lords.
Jurisdictional police station is a part.
Medical. No, my lords.
ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ತರಿಸಬೇಕು ಅಂದ್ರೆ jurisdiction police station ಅಂತ ಮಾಡಿ ಪಾರ್ಟಿನ. ಇನ್ಮೇಲೆ ಎಲ್ಲ ಪೆರೋಲ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಮಾಡಿ.
Next.
ನೀವು ಪ್ರೊಸೀಜರ್ ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಸರಿ ಇರುತ್ತೆ.
Jurisdictional police station as well as my lords where he is residing, that two police station they have.
How jurisdictional police sir, ನಾನು ಹೇಳಿದ್ದು ಮತ್ತೆ ಅದನ್ನೇ where he resides ಇನ್ಯಾವುದು? ಜೈಲಲ್ಲಿ ಇದೆ ಆ police station. ನೀವು ಎಲ್ಲಿ ರಿಸೈಡ್ ಆಗ್ತೀರಾ ಆ police station. Police station party. List the matter. 10th December.
Annexure B police in the report bandit, my lord.
ಏನಂತ ಬಂದಿದೆ?
Annexure
ಕೊಡಬಾರ್ದು
B
ಅಂತ
have
ಬಂದಿಲ್ಲ.
submitted police report is.
ಇಲ್ಲ ಕೊಡಬಾರ್ದು ಅಂತ ಬಂದಿದೆ.
Yes, my lord. Normally they'll reject.
Obviously
Usually
ಕೊಡಬಾರ್ದು
they
ಅಂತಾನೆ
reject, my
ಬರೋದು.
lord, sir. ಕೊಡಬಾರ್ದು.
ಆಯ್ತು, ಲಿಸ್ಟ್
ರಜೆ ಮೇಲೆ ಬಿಡಬಾರ್ದು ಅಂತ ಬರ್ತಾರೆ ನಮಗೆ.
10th ಕೊಡುವ ಸಿರಾಜುದ್ದೀನ್.
Yes, my lord. 2:30, my lord.
ಇವತ್ತಾ? 10th?
No, my lord. On 10th at 2:30, my lord.
Yes, ಬನ್ನಿ.
Oblige.
43 KS Patil.
ಕಾಡಗೌಡ ಪಾಟೀಲ್ ರೀ.
Guest lecture.
Guest lecture.
This.
Suraj Saib order.
Suraj Sahib's order, Your Lordship, that is there. Yesterday I have submitted.
ನಟರಾಜ್ ಸಾಹೇಬ್ order ಇತ್ತಲ್ಲ ಇಲ್ಲಿ. ಈಗ
ಅದು
ಯಾವ್ದು follow ಮಾಡೋಣ?
actually-
This would be, my lords,
Could be helpful to you.
ಯಾಕಂದ್ರೆ both those two judgments, they are in respect of UGC qualification. It is junior college.
ಇದು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಅಲ್ಲ ಇದು.
ಇಲ್ಲ, ನಾವು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕೇಳ್ತಾ ಇಲ್ಲ. ಅದು ಪ್ರೇಯರ್ ನಮ್ದಿಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ತಪ್ಪಾಗಿ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Insofar as this year is concerned, ಅಷ್ಟೇ ಅಂತ.
ಅಷ್ಟೇ.
And now, Your Lordship, what happens? UGC ಅಂತ guidelines follow ಮಾಡಿ ಅಂತ it is notification is there, Your Lordship.
You have to follow. ಏನ್ choice ಇದೆ?
But in this, he is not qualified, Your Lordship.
UGC guideline.
ಅಲ್ಲ, ಈ ವರ್ಷಕ್ಕೆ ಮಾಡಿ ಆಮೇಲಿಂದ ಕ್ವಾಲಿಫಿಕೇಶನ್ ವಿತೌಟ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ nobody should made to work.
Qualification means, Your Lordship, only
Consider
MCom
the case of regularization ಅಲ್ಲ IC. ಅದು ಒಂದು ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಯಾವ್ದ್ರಲ್ಲ. ಕಂಟಿನ್ಯೂಷನ್ ಅಲ್ಲ?
Continuation.
ಇದು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಬದಲು ಕಂಟಿನ್ಯೂಷನ್ ಅಂತ ಬರಬೇಕು. ಮಿಕ್ಕಿದ ಇನ್ನೇನ್ ಬೇಕು?
ಅಷ್ಟೇ.
Insofar as
ಅಲ್ಲ
this
sir,
year is
ಅವಸ್ಥೆ.
concerned, this year is concerned and 25.
ಇಲ್ಲ, and prior to initiating fresh recruitment process ಅಂತ ಇದೆ.
But hung.
ಆಯ್ತು, ಫಾರ್ ದಿ ಕರೆಂಟ್ ಇಯರ್ ಅಷ್ಟೇ.
Current
ಪ್ರತಿ
year,
ವರ್ಷ ಚೇಂಜ್
please, Your
ಆಗುತ್ತೆ.
Lordship, that is.
ಕಂಟಿನ್ಯೂ ದಿ ಸರ್ವಿಸ್ ವಿತ್ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಡ್ಯೂಲಿ ಇನ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ಇಲ್ಲಿ ಅಷ್ಟೇ.
Please, Your Lordship.
Please.
ಯಾರಿಗೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಯಾರಿಗೆ ಹಾಕಿದ್ದೀರಾ?
I don't press it, my lords.
The relevant counsel of the petitioner seeks withdrawal of the impleading application. Does not want to pursue the impleading application. Therefore, the impleading application stands disposed as not pressed.
Please.
44 Shivraj Balloli.
Tender matter. During the currency of my lords, the tender allotted in my favor. Second tender is, my lords, floated for the same work.
Government ಬಂದಿದ್ಯಾ?
It may be allowed, my lords, because of the same work they have given. ಮಾಡ್ಬೋದು.
ಅದ ಮತ್ತೆ ಸುಮ್ನೆ ಹೆಂಗ್ ಅಲೋ ಮಾಡೋದು? ಅದಷ್ಟು ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಹೆಂಗ್ ಕೊಟ್ಟು
ಅಷ್ಟು ಬೇಡ.
ಏನ್ ಆಟ ಆಡ್ತಿದ್ದಾರೆ?
I have verified the documents.
ವರ್ಕ್ ಅಲಾಟ್ ಮಾಡ್ಬಿಟ್ಟು ವರ್ಕ್ ಶುರು ಮಾಡಿದ್ಮೇಲೆ ಅದೇ ವರ್ಕ್ ಇನ್ನೊಬ್ರು ಕೊಟ್ಟದ್ದು ಎಕ್ಸ್ಟೇನಿಯಸ್ ಕನ್ಸಿಡರೇಷನ್ ತಾನೇ ಕೊಟ್ಟಿರೋದು ಇದು. ಸುಮ್ನೆ ಯಾರು ಕೊಡ್ತಾರೆ? ಯಾರು? ಹೂ ಹ್ಯಾಸ್ ಅಲಾಟೆಡ್?
Now, my lords, the respondent number 5, my lords.
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್.
Please, my lords, rural development, Panchayat Raj. For me, my lords, work is.
ಈಗ ವರ್ಕ್ ನಿಮಗ್ ವರ್ಕ್ ಅಲಾಟ್ ಮಾಡಿದ್ ಯಾರು?
Respondent number 4.
4. ಯಾರದು? ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಸೇಮ್
ಅಲ್ಲ, sanitation department has allotted the work to me. Now, rural development department has again floated the same tender.
Floated the same
Floated the tender for the same work.
How has it done this? Who is the tender inviting authority of the fifth respondent?
Fifth respondent himself.
Sorry, rural development tender inviting authority yaru?
Executive engineer himself, my lords. Annexure A, my lords, is the tender.
50,000 costs to be paid by that executive engineer from his pocket to the petitioner. So that his pocket alli bandidiyalla adu hogutte.
I will caution him, my lords.
What caution?
Yes.
And I'm not.
ಯಾಕೆ ಮಾಡಿರೋದು ಗೊತ್ತಾಗಲ್ವಾ ನಮ್ಗೆ?
Definitely, I will send a word, my lords.
ಯಾವ ಸೆಂಡ್ ಅಲ್ಲ, ಮೆಸೇಜ್ ಶುಡ್ ಗೋ ಸರ್.
Yes, I will convey, my lordships.
ಅಷ್ಟೇ.
And I'm not allowed to carry out the, execute the work, my lords, as per the old.
There is a loss cost. Who is not allowed to execute the work?
The respondents, they are saying, my lords, since work is now subsequently allotted to someone else, they're not disclosing whom the work is allotted to. and neither permitting me to carry out the work, my lords.
What is? ಏನ್ ಹಿಂಗ್ ಮಾಡೋದು? ಬರ್ಕೊಳ್ಳಿ. The petitioner is before this court calling in question a notice inviting tender within bracket NIT dated 9/9/2025 issued by the fifth respondent and seeks a consequential mandamus directing the respondents to permit the petitioner to execute the work in terms of the work order dated 27/5/2025 heard so and so. A notice inviting tender is facts adumbrated are as follows. A notice inviting tender is issued by the fourth respondent. Where is the tender?
My lords, the work order is at annexure C, my lords.
Tender ಎಲ್ಲಿದೆ ಸರ್?
ಅದು earlier tender, my lords.
ಇದರಲ್ಲೂ ಶಾರ್ಟ್ ಸಪ್ಲೈ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಶಾರ್ಟ್ ಸಪ್ಲೈ.
It's after, my lords, tender is allotted, they did not have
ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ?
work order
We
ಆದ್ಮೇಲೆ.
are going to gather the facts properly. Yes. Where is the, for what purpose was the tender?
My lords, for construction of
Where do I
3.
get it?
My lords,
Where do I get that?
annexure B, my lords. Annexure B, letter of acceptance,
Page?
page 19, my lords. Construction of 3 KLD facial sludge treatment. Subject, my lords.
Yes. The tender, ಏನಿದೆ, you see? Notice inviting tender is issued by the fourth respondent for the following work. ಇಲ್ಲಿದೆ, mark ಮಾಡಿದ್ದೀನಿ. So the petitioner participates in the said tender, emerges successful, and a work order is issued to the petitioner. A letter of acceptance is notified in favor of the petitioner on 22/5/2025. The said communication of letter of acceptance is as follows. Annexure B, page 19. What follows is a work order on 27/5/2025. After having issued the work order, in agreement ಏನಿದು?
Agreement, my lords.
An agreement is entered into between the parties for execution of the work on certain terms and conditions and the work was to complete within 180 days. The agreement is as follows. After all these events happening, it transpires that the fifth respondent, another executive engineer under the same office in a different department, issues another tender notification for the same work that was already, for the same work and the same place that was already allotted in favor of the petitioner. The said notification LA.
Annexure A, my lords, page 14.
The said, where do I get that?
Annexure A, page 14, my lords.
The said, the scope of the said tender, impugned tender is as follows. Page. Reserved for SC ಅಂತಿದೆ, ಮುಂಚೆನೂ ಅದೇನಾ?
ಇಲ್ಲ, ಮುಂಚೆ it was not reserved for SC. Now they issue the fresh tender reserving it for SC.
The fresh tender is now issued, dubbing it to be reserved for candidates belonging to scheduled caste category. It is this that has driven the petitioner to this court in the subject petition. If the afore narrated events are noticed, all the nuances of a tender being taken to its logical conclusion stood concluded on the agreement being entered into between the fifth respondent with the petitioner for execution of the work. What remained was beginning of the commencement of execution of work. Therefore, all rights stood created in favor of the petitioner as obtaining in law. The fifth respondent could not have sprung into action later, re-notified the tender, dubbing it to be in favor of the scheduled caste, virtually upturning the concluded contract between the petitioner and the fourth respondent. The fifth respondent, fourth respondent, on the strength of the said illegal tender that is now notified, the petitioner is not permitted to execute the work. The learned AGA on instructions and verification of the records would submit that the tender in fact had been awarded in favor of the petitioner, but it is re-notified by the fifth respondent. By the fifth respondent, he would though seek to defend the action of the fifth respondent, but would leave the decision to the hands of the court. In the light of the aforesaid facts, the notification of the new tender on the face of it is illegal, as the new tender, the scope of the new tender is the same with regard to the old tender. The old tender had concluded in entering in the fourth respondent entering into an agreement with the petitioner. Therefore, the fifth respondent could not have notified another tender for the same purpose. The tender that is notified twice over cannot be sustained. The unsustainability of the tender would lead to its obliteration. The obliteration would not be obliteration simpliciter. The fifth respondent, knowing full well that the tender is already notified, re-notifies the tender for the same job. This cannot but be termed to be illegal, high-handed on the face of it. In that light, the fifth respondent who has acted blatantly contrary to law must be mulcted with certain costs to be paid from his pocket to the petitioner. For the aforesaid reasons, the following order. The writ petition is allowed. The tender notification dated 9/9/2025 stands quashed. A consequent mandamus issues to the respondent to permit the petitioner to execute his work in terms of the tender so notified. Cost of litigation at ₹50,000 is to be paid by the executive engineer from out of his funds and not funds of the state, to the petitioner, all within 4 weeks from the date of receipt of the copy of this order.
But one more submission. I was supposed to conclude the work within 180 days.
One paragraph last. In the light of the tender stipulating the period to be 180 days from the date of its commencement of execution of work, and the commencement being stalled by the respondent themselves, the petitioner shall commence the work and conclude it within 180 days from today.
Please. Yes. Highly obliged.
Number 45, Nitin Ramesh.
Lord, am I audible, my lords? I appeal to the petitioner.
I'm led by my lord senior counsel.
I am appealing for the second respondent in this matter, my lords.
Yeah,
second respondent.
40?
45.
45. Tender writing authority. Yes.
My
lord, the objection has been filed by the answering respondent number 2, my lord. The issue pertains to a tender which has been called for across the state in 17 packages by Vishwakarma Development Corporation, my lords, on behalf of 10 other corporations. The lordship may kindly see page 28.
Yes, sir.
It's for all the 11 corporations. It is provision of submersible pump sets across the state, lords. That is what is the subject matter of the tender. Lords, I am challenging the tender in its entirety because of the manner in which it has been brought about, and to use the felicitous expression, my lords, have used in more than one tender matter, which is that this is a clear case where there is palpable and demonstrable arbitrariness.
You did not participate in the tender?
My lords, I only thanks to your lordship, I was allowed to participate in the tender. They ousted me. Initially, my lords, may I just place a few facts on record, my lords? Yes, I am a MSME, my lords, authorized. I have my certification. I am a sole proprietorship firm. The tender document in the initial part says sole proprietors will not be allowed to participate in it. However, the same tender document in a later part, which is there at page 56, says that sole proprietorship firm may also provide, may participate in the bid. When I go to participate, I am told that I am not eligible and that they do not want MSMEs to participate in this. I have been doing this, my lords, from the late 1980s. I have been providing the same service across various corporations, but they don't want any of those prior work experience. They say MSMEs won't be allowed to participate. Then I come before my lord. Through an interim order, this honorable court permits me to participate subject to the outcome of the petition. During the pendency of that, they bring about one clarification saying that sole proprietorship will be allowed to participate. Then what happens, my lord? They come up with certain other clarifications in which the qualification criteria and the packages are changed midway, my lords. I will point out that from the IA for additional documents which I have filed, because this is a development which happened subsequent to the filing of the writ petition. In that IA, they changed it's a very critical submission, my lords, I want to make, because they changed the rules of the game. One. Number two, the favoritism that is evident is also demonstrated. And then one important aspect which comes along with that I have to point out right away, my lords. Would your lordship kindly take the IA for additional documents? It's a small IA with 18 pages, my lords. In this, your lordship could see, it says pre-bid queries, replies of submersible pump set tenders. Would your lordship get that?
Yes, sir.
Indrali, I have one submission to make on serial number 27 at page 17. But before that, I will come to the next page at page 18, because this is the most striking aspect of demonstrable arbitrariness. Your lordship would see page 18. This is subsequent to my filing the writ petition and getting the orders. They come up with this clarification. In this, they would say, would your lordship kindly see, this is an affidavit for not blacklisted debarment pending cases. Para 2, my lords, that Mr. So-and-so has not been blacklisted or debarred by any central government, state government, semi-government, PSU, autonomous body, local authority, and any other public agency in India or abroad. We are all told to file our affidavit as per this, and all tenderers are supposed to do as per this. In the meanwhile, what happens is, they realize that there is somebody there who is a sole proprietor. They want to show favoritism. I cannot make the allegation straight away because the tender has not been awarded yet, but we know who it is. What they do is, they say, come up with a clarification and say, no, now sole proprietors are allowed to come. But they realize that sole proprietor firm has actually been blacklisted outside our state. So what they do, my lords, they come up with one more clarification. I think I've already submitted it to the court, but anyway, by way of abundant caution, my colleague, my lords, would kindly consider that, my lords, is placing it on record. They come up with this clarification much after the interim order has been passed in this honorable court during the pendency. There are two things. Point number one, would your lordship see that, my lords? Belatedly, after the process is set in motion, they come up with a clarification at serial number 2, saying that 1 and 2, both of them, the OEM bidders must be a sole proprietorship firm. This is added. So also in serial number 1, this clarification is brought, this amendment is brought. Along with that, I would say clandestinely or not so clandestinely, they come up with point number 2. In that, your lordship may kindly see paragraph number 3. Paragraph number 2, serial number 2. Again, affidavit, it says the affidavit format issued under addendum dated 1999, which is also anyway subsequent, stands deleted. Bidders are hereby advised to consider the revised affidavit format provided under this addendum 2 and submit their bids accordingly. All other clarifications issued under the addendum dated so and so shall remain valid. What they do in this, kindly see serial number 2, my lords. Your Lordship had earlier seen what they had, who they had blacklisted. Here they say that Messrs. Dash has not been blacklisted or debarred by any government departments in Karnataka as on date of submission of this affidavit. My lords, what it means is those who are debarred or blacklisted even by the central government or by other states are permitted to participate even though they are blacklisted in the Karnataka tender. My lords, this goes against the Karnataka government's own standard format, my lords. This corporation is trying to bring something which is going against the format of all tenders across the state, not only for corporations, but for the government departments as well. This they are doing.
Vishwakarma Corporation. Huh?
Yes.
How the Vishwakarma development. And the tragedy, my lord, is this will not apply only to the Vishwakarma development. This will be across all other 10 corporations and for all work that is done across the state. And this is how they go back and forth on affidavit. My lords, there cannot be a better instance of a demonstrable arbitrariness than this, my lords. But it does not end there. Your Lordship, kindly see. Your Lordship, may kindly see the last nail on the coffin. The objection, statement of objections which have been filed may kindly be taken. Would Your Lordship take, this is the latest one filed on 14/11.
Really, sir.
Idರಲ್ಲಿ, now they take the stand that they don't want MSMEs to participate in it. First they say sole proprietorship not permitted when I go to participate. Then they say sole proprietorship permitted. Then they say blacklisting nowhere in India. Then they say blacklisting elsewhere is okay but not in Karnataka. Fifth, they come and say now in their statement of objection, no, we do not want MSMEs to participate. Would Your Lordship kindly take the rules which have been, the public policy procurement, which is there at document number 3, which is at page, my lords, I have not been provided the pagination notes, but Your Lordship would get that 23rd March 2012. In that they say, my lords, that also is an old order, my lords. There is an amendment which has been brought. My learned friend, my lord, my colleague would kindly provide that, my lords. I realize that this is an old version they have put. Kindly see what the new version with a small amendment says. Does Your Lordship have public procurement policy for micro and small enterprises?
Yes,
Adharalli, clause 3, subclause 3. There is a mandate as per the central government, which has been adopted by the state government also, that after a period of 3 years from 1st April 2015, overall procurement goal of minimum of 25% shall be mandatory, which means not from 2018, any tender which is called has to satisfy the 25% minimum mandate. This has been violated. They are now saying MSMEs are ousted. How they are ousted is also mentioned in the statement of objections. Would Your Lordships now kindly come to, my lords, document number 2 in the statement of objections. In the document, in this document number 2, amendment of Rule 26, Your Lordship sees, in that, my lord, it clearly says to enable wider dispersal of enterprises, particularly in rural areas, the government departments and state-owned PSUs, which is the present case, shall procure 358 items from the micro and small enterprises which have been reserved for exclusive purchase from them, from among them, as per Ministry of MSME.
You are an MSME?
Correct.
All right. So MSMEs are now ousted.
Yes.
And the defense of such ousting is in the statement of objections.
Correct.
The tender does not oust you.
My lord, they are ousting. They are saying they are ousting me. My lord, may I kindly complete? There is one clause which I have to mention, my lord. Otherwise, I would have not done my duty. Kindly come to clause 11, my lords. There is a very ingenious argument defense which has been brought by the corporation. Kindly see clause 11 in this. The same order which I mentioned, my lord, document number 3. Document 3, clause 11. May I read, my lord? Reservation of specific items for procurement to enable wider dispersal of enterprises in the country, particularly in rural areas. The central government ministries or departments or public sector undertakings shall continue to procure 358 items in the appendix from micro and small enterprises which have been reserved for exclusive purchase from them. Kindly underline exclusive. Now the argument which is made by this corporation is that since these submersible pump sets do not come within these 358 items, we have no duty to entertain MSMEs. My lords, this is not the right argument. The argument is the proposition or the policy.
ಅವ್ರು ಮಾಡ್ಲಿ ಬಿಡಿ, ನೀವ್ಯಾಕೆ ಮಾಡ್ತಿದ್ದೀರಾ ಅವ್ರ
ಅಲ್ಲಲ್ಲ ಪಾಲಿಸಿ ಏನು ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾ ಮಾಡ್ತಿಲ್ಲ. The policy position is that so far as 358 items are concerned, that must be.
ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವೇ ಮುಗಿಸ್ಬಿಟ್ರೆ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಮತ್ತೆ?
ಇಲ್ಲ MSME ಇದು ಒಂದೇ ಒಂದು ಸ್ವಲ್ಪ ಇಲ್ಲ, ಮತ್ತೆ ನಾನು ರಿಪ್ಲೈ ಅಲ್ಲಿ ಇನ್ನೊಂದೇನು ಹೇಳೋದು, ಇದೊಂದು ಪಾಯಿಂಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ. 358 ಐಟಮ್ಸ್ ನ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಆಗಿ ಓನ್ಲಿ ಫ್ರಮ್ MSMEs ತಗೋಬೇಕು. In all other matters, 25% procurement should happen from MSMEs. That is the position, lords. Kindly see this also. Thankfully, from the corporation's own record, I am able to demonstrate this. Kindly come to document number 1. Very first document. It clarifies how much should be brought. Document number 1 alli, the second page alli, your lordship would see the clarification. I don't want to read the entire thing. It talks about 80% is the requirement. However, it will be 40% with respect to micro and small enterprises. Adhe riti, estimated cost at the bottom, average annual financial turnover of the tenderer should be dash, usually not less than estimated cost of the quantity in the tender document. It will be 50% of the estimated cost of the quantity with respect to the purchase. Now, when this is the case, what it clearly means is, in all other tenders where 25% minimum mandatory is there, you shall give this extra exemption also for these MSMEs. So this ingenious argument in the the statement of objection that we are completely ousted and only if we come within those items of 358 or so in the appendix, we will be allowed to participate, otherwise we are ousted, is my lords, clear case of favoritism, my lords, a clear case of palpable arbitrariness. This tender is not worth the paper on which it has been printed. Therefore, my lords, this deserves to be set aside, is my humble submission. If there is anything which comes up, in my reply.
Lords, just quickly, I just cover.
I am for the impleading respondent number 3 and 6, my lords.
Impleading, who are they?
Supporting.
Supporting whom?
Supporting me.
Supporting the petitioner, my lord. Can I make the submission for today, my lords? Notwithstanding these objections, if the respondent were to evaluate a tender bids, my lords, along with all others, then, my lords, whether if
evaluation agilva
illa,
it was in the process, my lords, but on last occasion there was an
technical bids have already been evaluated.
Now, my lords,
then you evaluate the whole thing.
There is a 3 process.
We will be ousted, my lords, on the ground of MSME that
whatever,
we don't have a certain
that,
certificate.
let the evaluation
No. My lords,
let the evaluation happen, and then, my lords, if my bid, my lords,
yes, Ravi Shankar sir.
My lords, I just wanted to clarify this, my lords.
Yes.
The opening statement saying that there is an ouster of any bidder is a misstatement. I really do not know from where they are getting the statement from. My lords, this is a tender called in respect of procurement of the submersible pumps of 6 HP motor and 14 stage motors. This essentially, this is what we are procuring. Now, for this, we are saying that what are the requisite qualifications for the purpose of participation. Lords, now the petitioners who has come before the court says that we should give them a special consideration as an MSME. This is essentially what they want to say. Lords, what we are saying is we cannot give you a special concession as an MSME. You can even if you are an MSME, you will have to participate along with the other bidders, and you will be a bidder whose tender will be considered. Lords, may kindly have a look at section 6C of the KTPP Act. What is the limited extent to which the MSMEs are protected, my lords? Section 6, capital C of the Act. There is one small leverage which has been given, that's it. May just read it, my lord. Section 6, capital C.
Yes, sir.
To encourage micro and small enterprises, preferences may be given to them in such manner subject to such conditions as may be prescribed by the government. Lords, as may be prescribed is defined as prescribed in the rules. Now, Lords, may kindly see Rule 26. Rule 25. Rule 25, sub-rule 2. Now, this is the first exemption. The proviso to Rule 25, sub-rule 2. Notes, provided for a period of 5 years from 1/10/2014, goods manufactured by
Rule
micro and
26
small
or 25?
enterprises located in the state.
25.
25, sub-rule 2 proviso.
In a tender, ಯಾವುದು?
Sub-rule 2.
Yes.
Proviso, yes.
In determining the lowest evaluated price, the following factors. In that, there is a proviso after A, B, C, D, E, F.
Yes, sir. Provided that period of 5 years.
Period of 5 years. From 1/10/2014, goods manufactured by the MSME in the state shall be given 15% preference against the large and medium industries of the state and industries of the other states during the government department purchases subject to following conditions, namely, enterprise should have been registered. 2. An enterprise shall produce a certificate obtained from the said authority certifying it's an MSME. Provided further that nothing contained in the first proviso shall apply for procuring of the pump sets under the Ganga Kalyan scheme being implemented by the Social Welfare Department. Now the other exemption, my lords, is under Rule 26. Sub-rule 4 and 5. Sub-rule 5. Micro and small enterprises with NSIC under a single point vendor registration scheme shall be facilitated by providing tender sets free of cost exempting from payment of EMD during the purchases by all government departments and state-owned PSUs. 6. To enable wider dispersal of the enterprises, particularly in rural areas, the government and departments and the state-owned shall procure 358 items. Notice these 358 items, we have already produced a list, that is document number 1, which does not contain the pump sets. Now, the primary contention is that there should be given a special exemption or a special consideration as an MSME. It is not there under the scheme of the Act. We cannot be compelled to give that. But this essentially is what is the scheme of number 1. But then there is a challenge, to the manner in which we have called for this 6 HP motor and 14 stage motor. Explanation is given in para 15 of the statement of objections because this 3-phase power is given for very limited hours. This is to the rural areas. It is given between 3 hours to 6 hours in every rural area. In order to ensure that the efficiency of the pumps and the irrigation is better equipped for the borewells which are operated, these pumps are called upon. This is number 2. Notice 3, exemption from EMD, what they are asking is not applicable because this does not come within the purview of these 358 items. There is no special concession which can be given to them. And to make a statement that there is somebody which is being favored false flag because out of 17 packages, we have made a policy that one bidder is entitled to participate only in 5 packages. Out of 17, he can participate only in 5 packages.
No, I can participate.
He can participate, but he will not be
Participate in
given
all
more than
17.
5.
All 17.
Participate he can in all 17, but he cannot be given more than 5 packages. Now, the tender conditions as such as what is tender by itself can never be called in question. That's too far-fetched an argument to advance. But what I want to submit it, the tender by itself cannot be called in question. If there is any specific clause which they say is offending the manner in which the tender is to be devised, I can understand. These are all the borewells which has already been dug under Ganga Kalyan scheme. Now the borewells will have to be serviced with the pump sets.
Otherwise, half the writ petition that is. Ravi Shankar sir,
The borewells will already be dug under the Ganga Kalyan scheme.
ಯಾರ ಕಲ್ಯಾಣ?
This Ganga Kalyan scheme will be done by the Social Welfare Department. Nothing to do with our department. In respect of those borewells which has been successful as per the reports from the Ganga Kalyan under the Social Welfare Department, then an indent will be sent to us for the purpose of servicing these borewells. So first phase is not within us. Second phase is merely the procurement and servicing of the pump sets. Now we are procuring.
So, is there a problem in assessing these tenders also?
At the lowest cost.
Is there a problem in evaluating these tenders applications also?
I am making a statement. We have never, they wanted a special consideration. We said no special consideration as an MSME. Other than that, Your Lordships may take my statement, every single bid which has been submitted, technical evaluation will be made, inspections will be carried out wherever technical bids has been through, and thereafterwards financial bids will be opened. We will do
Without
that.
disqualifying
Lords,
anybody.
what is, kindly,
Milords,
let me
if-
finish.
we are not disqualifying anybody, Milords, if they are within the eligibility criteria. If you are not in the eligibility criteria, you can't ask us to be qualified.
You have already said we are not qualified in the statement of objections. There is a question of waiting for technical evaluation.
I just want to clarify.
Kindly
We
come
are
to page 10, my lords. Kindly come to page
just one sentence I
10.
state, Milords, and then I leave it to my friend, Mr.
Yes, Ravi Shankar sir, Muksi.
One sentence. Milords, I just want to say this. We have very specifically said that MSMEs as a special category is not something we are considering as an MSME either under 6 capital C, Rule 25 or Rule 26. MSMEs as a bidder will be considered and their technical bids will be evaluated in accordance with all the norms as applicable to every other bidder. We have never prohibited any person, and there is a restriction or a cap that one bidder will not get more than 5 packages. He may get even less.
That is midway changed.
One minute. Nitin sir, 1 minute. Yes.
Please.
The impleading applicants stand on a slightly different footing.
We're supporting the petitioner.
We are supporting the petitioners, but our grievance is slightly different.
Then he has to file a separate writ petition, Milords. It would not be proper to enlarge the scope of the writ petition. The moment he said his contention is something else, then he has to pay separate court fees at least, if not anything else.
I was anticipating this, Milords. There, I have an answer.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ petition?
I'm before your lordships, Milords. My only submission is this, Milords. Insofar as we are concerned, Milords, our tenders, Milords, we have filed all the certificates. Their cases, you have not filed the physical copy of the certificate, you have only filed the approval, Milords. Either way, Milords, without disqualifying us, if they were to evaluate our bid, tomorrow, Milords, in case, Milords, I stand a chance, then I will stand a chance to argue before your lordships. If even after evaluation, if I'm out, Milords, then there is no point in me, Milords, troubling your lordships.
Even the
petitioner,
the petitioner
and the respondents, Milords, without disqualifying them, let them evaluate and place it before your lordships.
No, they're not. We'll answer it because that I think they are not ready to do it.
Milords, they cannot put this is a process. Tender process is Milords, now they cannot.
Ravi Shankar sir, we will answer it. We will answer the challenge, not direct you to evaluate. Anyway,
Milords, technical evaluation we have already completed.
No, that's all right. We will answer the challenge. Yes.
Please.
ಈಗ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ನಾಟ್ ಕ್ವಾಲಿಫೈಡ್ ಅಂತ ಹೇಳಿದೀರಾ?
No.
Para 10, kindly come to para 10, Milords. It is submitted that in reply to para 11. Since MSCs are not allowed in this tender as per document, the tender eligibility conditions are framed with KTPP Act and rules. It's a sham, Milords, that they are going to do a technical evaluation. There is no other reason why I'm saying this entire tender will have to be recalled. First, Milords, only 3 points. Number 1, what is their statement so far as the mandate that 25% procurement has to be done only from MSMEs? How can they now take the stand? We are not going to do as per MSME. 1. Number 2, in blacklisting, they have gone back and forth. They are saying even if somebody is blacklisted from outside the state, they can come and participate in Karnataka. Absolute silence. There is nothing that the learned senior has to say about this. Number 3, they keep introducing new conditions, withdrawal conditions as the process goes on and change the rules of the game. Obviously, my lords, this is a clear case where the tender cannot continue. They have to incorporate the legal mandate which is there of minimum 25%, which the Karnataka government is following for itself and all the state PSUs. There is no way they can continue. There is no question of continuing the technical evaluation bid by any stretch of imagination. This is not at a stage where a clause here or a clause there is what we find fault with or aggrieved by. It is a case where the entirety has got initiated by the manner in which they have conducted themselves. This tender cannot continue.
Can I just
and also kindly see, one more submission. Please.
Yes.
Clause 10, my lords, in document number 3. Document number 3, clause 10. This is also a mandate, my lords, order which is adopted by the state government. Kindly see, now they are saying
we will not consider them as MSMEs. We are not asking only for exemption. We are saying we have to be treated at all times as MSMEs. You don't have a choice there. You will have to recall this and notify bid with 25% minimum mandate from MSMEs. Kindly come to clause 10, my lords. Reduction in transaction cost. Firstly, this very order says 25%, then it says reduction in transaction cost. To reduce transaction cost of doing business, micro and small enterprises shall be facilitated by providing them tender sets free of cost, exempting micro and small enterprises from payment of earnest money. They have already collected this from us. Adopting e-procurement to bring in transparency in tendering process. Nothing of this sort. In fact, from the inception itself, I was not allowed to put my nose in, but for the honorable court's intervention, my lords. So this in the light of their statement of objection at clause 10, in the light of the legal mandate evident which has been adopted for 25% to be given to MSME, the submissions made now orally that we don't consider them as MSMEs itself is enough to show that they cannot continue with this tender. They have to recall and re-notify.
All right, we'll Thursday for dictating orders.
Grateful.
Please, can I just make two submissions?
Thursday, 4 p.m.
I have slightly different submission.
Slightly different petition actually.
I will, but only difficulty would be this, Malad. In that event, Malad, in my impleading, Malad, I had projected, Malad, my grievance. Your lordships permitted me, Malad, and thereafter, Malad, I am on record. Can I just say this, Malad?
Allow agide impleading application.
Impleading applications are allowed. Yes,
respondents.
Malad, as respondents, of course. Malad, can I just say this, Malad?
There are 9 to 11 of my objections, may I use.
No, I'm dictating on Thursday.
Please.
You're present. It's not an absence.
Great.
3 minutes by the clock, Malad, can I just say this?
Eye on the clock. Really.
Yes, Malad. Malad, the tender document, Malad, clause 7 would say, Malad, that those who are blacklisted or debarred in anywhere in India are not permitted to participate.
That is changed later.
By way of an affidavit. In the addendum to the tender document.
After notification of tender.
After notification. But the tender document, the tender condition remains. But in the format of the affidavit, Malads, it is restricted to those who are debarred or blacklisted only in Karnataka, without changing, Malads, the original notification. Malads, insofar as I am concerned, Malads, 6 HP 14-stage motor is called for the first time. 45 days, Malads, is the time limit prescribed for procurement of the certificate, Malads. Now, the time limit, the last date from the date of calling the application, from the date of issuing the notification till the last date is 39 days, Malads. So, Malads, there is no chance that I can procure it. Nevertheless, Malads, I apply. They approve it, Malads, and I receive a notification that it is approved, which I upload. Malads, the next last date, Malads, being a Saturday and Sunday, Malads, second Saturday, Sunday. Physical copy of the certificate, Malads, did not reach us on time by the 29th, which was the last date. Yes, Malads. Malads, along with my application.
Anyway, we'll see. If I consider that, I think you will be covered by that.
Malads, along with my application, I have filed the approval of the authority.
If you have a better right than that of the petitioners,
yes,
then you have to file a separate petition.
Yes,
Malad,
you can't take favorable orders being a respondent.
And also at this stage, Malads, we are sailing differently because what I am seeking for is a complete recall of the tender. And my learned friend is trying to have a midway there. And so I think we're not sailing together, Malads. I would object to this prayer.
Then would your lordships permit me to file a fresh writ petition?
Who stops you, sir?
Malads, I am impleaded and my grievance is before this court.
You withdraw the impleading application.
Malads, I am already allowed, Malad. Only your lordships may reserve liberty, Malads. I'll come back to your lordships, Malads.
You come back. If you're coming back tomorrow, is fine. Thursday.
Malads, tomorrow, Malad, would. Thursday, Malad, I'll be before you.
Thursday, come back.
Yes, I'll be before you.
Thursday, 4 p.m. dictation.
Please.
Grateful, Malads. Grateful. Malads, may kindly permit me to file a short synopsis, Malads, to assist because there is more.
By tomorrow morning.
Sorry, Malad.
By tomorrow morning, if you are filing, fine.
Please, I'll file it. Great.
Synopsis and list of authorities, if you are working overnight and filing it tomorrow, fine.
Please. Malads, tomorrow by the end of the day, Malads. Tomorrow by the end of the day, Malads.
End of the day at least, because when file comes home, if I go through it, I'll finish it off. Yes.
Grateful.
This tender matter should not remain. Yes.
True.
Next.
So grateful.
Lakshman T. Mantagani.
Lordship, in this last date, Lordship of Directorate has to serve the copy to the respondent, Your Lordship, in lower court.
Husband did not receive, huh?
No, Your Lordship, we couldn't reach the council, Your Lordship.
Wife could not reach the husband?
No, Your Lordship, we couldn't reach the
Aదే
council.
problem
Yes,
ಆಗಿರೋದು.
yes.
ಆಯ್ತು, ಸರಿ.
Lordship,
List after 2
meanwhile,
weeks.
Lordship, meanwhile, kindly issue notice to the respondent, Your Lordship.
ಆಯ್ತು
Meanwhile,
ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. The emergent notice to the respondent returnable by the 12th of December. 12th ಅಲ್ಲ, 12th of December. Yes.
please, Your Lordship.
47, Prasad Patil.
Mulad, this matter I'm appearing for the petitioner, Mulad.
Sharp watch.
I am
Please,
for
Mulad.
respondent number 2 and 3.
ಹಾ,
Mulad,
ಅದನ್ನೇ
the
ಹೇಳಿದ್ರಲ್ಲ ಏನೋ.
Mulad, rejection of
ರಕ್ಷಿತಾ
the.
ಮೇಡಮ್, ಒಂದ್ ನಿಮಿಷ. ಹಾ.
I have filed preliminary objection stating that
Ah.
the writ petition is not maintainable as there is a appeal provision, sir.
ಕರೆಕ್ಟ್. ಈಗ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
No, Mulad, work order is not issued.
It is the second writ petition, sir. They have challenged, it is the second writ petition.
ಸೇಮ್ ಟೆಂಡರ್ ಮೊದಲು
ಹೌದು sir.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಇದೆ ಹೇಳ್ತೀನಿ ಸರ್.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿದೆ?
ಒಂದು ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಸರ್. ಪೇಜ್ ನಂಬರ್ 144 ಸರ್.
ಅವರೇ ಹಾಕಿದಾರಾ?
ಅವರೇ ಹಾಕಿದ್ದಾರೆ, ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಸರ್. It was
If I may-
disposed of 23 September 2025, sir.
Sharp watch.
Oh, sir. The order is on 147, sir. Page number 147.
ಏನ್ ಡಿಟರ್ಮಿನ್ ಆಗಿದೆ ಸರ್ ಇದರಲ್ಲಿ?
Sir, determine Allah.
ಏನಿಲ್ಲ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದರೆ ಲಿಬರ್ಟಿ ಇಸ್ ರಿಸರ್ವ್ ಟು ಚಾಲೆಂಜ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ರಿಜೆಕ್ಷನ್.
Oh, they have to, sir, he has to appeal to the appellate authority, sir.
Mulad, if I may
He has again
clarify.
filed the same writ
Submits the
petition, sir.
reason for rejection. ಈಗ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ ರಕ್ಷಿತಾ?
No, Mulad, the work order is not issued. That is why I'm before this honorable court on the, since my technical bid is rejected.
I don't think the council is ignorant of such rudimentary things. Don't worry. Yes.
Mulad, now earlier, Mulad, I approached this honorable court because reasons were not notified, Mulad.
No, that's all right. Sir, the preliminary objection tumbles. Yes.
Also, second is.
ಒಂದ್ ನಿಮಿಷ ತಾಳಿ ಅವ್ರು ಮುಗಿಸ್ಬಿಡೋಣ. Yes,
Please,
madam.
Mulad, my technical bid has been rejected on for the single reason that the PAN and TAN submitted by me are not the same. Mulad, page 22 of the 10.
There is one
Please.
judgment on that. Where is that? PAN and TAN.
Mulad, that I've produced your lordship's decision at annexure M, page 170, Mulad. Before that, if I may just point out what is the criteria, Mulad, page 22, your lordship will get it. Page 22.
Now, who is supplying
The
security?
Mulad,
ನೀವೇ
it
ಮಾಡ್-
is-
You are continuing, is it?
No, my lord, I am not continuing. My technical bid is rejected. And earlier, I was not the successful service provider.
All
Page
right.
22, my lord, at serial number 2, PAN of Income Tax Department and
Will
TAN
be the
shall-
same for the last 5 years.
Please, Mulad, my reason, as your lordship is aware, in a series of decision, the company was constituted in the year 2020. For the financial year 2019 and 20, Mulad, the PAN of the proprietorship, that will be the individual PAN. Mulad, annexure
That
N, if your
judgment
lordship,
also I have written. Where is that, madam?
page 170, Mulad, annexure M.
Yes. Idರಲ್ಲಿ you
Mulad,
were the
your-
respondent. You suffered an order in this, I guess.
No, my lord, in this, your lordship was pleased to dismiss the writ
Dismiss,
petition
all right.
confirming. My lord, para 10, before that para 4, my lord, even there they had questioned on the same grounds. Para 4, page 173. That existence for
5
the
years
period-
prior to the submission
Please,
of the bid.
Please,
Yes.
same, my lord, and then para 10 to 12 would be relevant. Your lordship relying on the coordinate bench decision
ಈಗ
and the,
technical bid is rejected only on this ground.
please, annexure C, my lord, the reason is at page
Page,
140.
page.
My lord, at page 138, my lord. The annexure F, my lord, is the reason notified, page 148. 148 and 149, my
As
lord.
per condition, bidder does not satisfy having same pan
Same
and
pan
tan.
and tan.
ಈಗ ಇವ್ರದ್ದು ಬಿಡ್ evaluate ಮಾಡಿ.
That is all, my lord. My request is to open my.
Technical bid will be evaluated, subject to the outcome of the petition. Right? Interim order ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ
Hello, sir.
ಅದನ್ನ.
Please, madam.
Please.
There is a order.
My lord, but
The-
it was stay of further
Pan
proceedings.
and
Now
tan.
my.
The pan and the condition is that pan and tan should be same for the last 5 years, sir.
Correct.
It is not satisfying, sir.
ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿಲ್ವಾ? Page 188 ಅಲ್ಲಿ.
Yes.
Why it can't be satisfied ಅಂತ. Proprietorship becomes a company in 2020. So pan and tan will be the same from 2020. 2019-20 ಇರಲ್ಲ ಅದು. So 5 years ಬರಲ್ಲ.
It is a preliminary this thing, sir.
ಅದೇ ಅದು ಸರಿ ಇಲ್ಲ ಅಂತಾನೆ ಬರ್ದಿದ್ದೀನಿ. That objection I have not accepted, I guess. Anyway, you evaluate the tender of the petitioner.
Yes.
The petitioner is before this, ಅಷ್ಟೇನ prayer ಬೇರೆ ಏನಿದೆಯಾ?
My lord, only to consider my, open my financial bid and to consider in
The
terms of
petitioner is before this court seeking, will dispose it or subject to result ಅಂತ ಮಾಡೋಣ.
Please, my lord,
Yes,
subject to
the
result.
Petitioner is before the court on the rejection of the technical evaluation by the respondent. The learned counsel for the respondent, ನೀವಲ್ಲ? Respond number?
2 and 3. 2 and 3, sir.
Respondent 2 and 3 would project a preliminary submission that the same petition is filed twice over for the same relief. The learned counsel takes this court through the earlier order that is passed. The said submission is on the face of it untenable, as the earlier order was only permitting the petitioner to raise a challenge to the order of rejection which had not been furnished till then. This would not constitute a second petition on the same cause of action, notwithstanding, however, even otherwise, liberty is granted by the coordinate bench to file the subject petition raising a challenge. The learned counsel for the petitioner submits that the only reason for technical evaluation being rejected is that the tan and pan are not the same for the last 5 years. The identical issue was projected before this court in challenge to a tender which is rejected, contending that the pan and tan for 5 years could not be pan and tan of the present petitioner, who was the third respondent therein, could not be the same for the last 5 years for the reason that it became a company in the year 2020, transformation from proprietorship concern to a company. Therefore, these matters would require consideration. Therefore, the respondent shall now evaluate the financial bid of the petitioner as well, which shall remain subject to the result of the present petition. It's made clear that the petition in the later point in time would go against the petitioner. No equities would be claimed. The work order shall not be issued without the leave of the court. List the matter on 5th December.
Please. Oblige, my lord.
Next.
Grateful.
Number 48. Harishankar Moore.
Yes, ma'am. In this respondent 4, I have refused the notice, my lords. I filed affidavit also.
ಏನು notice?
The court has directed to serve the notice to the respondent 4. The police protection.
Who is respondent 4?
Respondent 4 is the mother-in-law of the petitioner, my lords.
Mother-in-law?
Yes, sir. Already she had filed suit for injection.
ಏನು ಹಾಕಿರೋದು ನೀವೀಗ?
Injection suit came to be dismissed, my lords.
Protection order?
Yes, your honor. Secured by judgment, I am producing.
ಕೊಡಿ. The petitioner has filed an affidavit indicating that the fourth respondent, mother-in-law of the present petitioner, has refused acceptance of notice as was directed by this court, and would submit that the issue in the list stands answered by the judgment rendered by the coordinate bench in identical circumstances. The learned AGA would not dispute the position of law as is laid down by the coordinate bench. In that light, the coordinate bench is held as follows. Same order. Next.
Please.
49, Raj Desai.
I seek 4 weeks time, my lords, to file statement of objection.
Award is passed.
Nine-
Award.
1960 land acquisition award has been called in question now.
Learned Counsel Chetan Manoli seeks, Chetan Manoli,
Yes.
4 weeks time to file statement of objections. Objections, if any, by the next date. Yes.
Please.
List the matter on 16 December.
Please.
Next. Bless.
50. Sanjay Chanal.
Lord, in this case, my lord, last occasion, lordship directed to settle the issues with the respondent bank. I mean, lord, after the DRT order, my lord.
Who appears for DCB?
He
My
appears.
lord, 2022 till date, same submission, all courts and same
No, my lord.
submission.
ಏನು ಕೊಟ್ಟಿಲ್ವಾ?
No,
We have paid 16 lakhs before DRTO, my lord.
One
And we are
ನಿಮಿಷ
ready to settle the matter, my lord.
Yes, one moment, sir. ಎಷ್ಟಿದೆ?
1 lakh, 1 crore 25 lakhs.
ಈಗ ಎಷ್ಟು ಕಟ್ತೀರಾ sir?
My lord,
ಕಟ್ತೀರಾ ಇಲ್ವಾ sir?
we are ready, my lord.
Yeah, how much ready?
My lord, 20 lakhs we are ready to deposit, my lord.
Tomorrow?
2 weeks, my lord.
Why?
My lord, it's required.
Last vacation of lakh.
20 lakhs ready ಇದೆ
20 days
ಹಾ,
already
ಹೇಳಿ,
taken.
ಇರ್ಬೇಕು.
No, my lord. 20 lakhs is ready, my lord.
Pay it tomorrow.
2 weeks, because we visited the bank, my lord, they are not allowing to talk with the manager also, my lord. We are ready to
Why do you want to
deposit.
talk to him?
The single, only person is coming to branch.
You want
No
family-
money.
You want family to come?
No money.
Oh, they are coming without money.
No, my lord,
Bank
with,
ಹೋಗ್ಬೇಕಾದ್ರೆ you should take money, sir. ಸುಮ್ನೆ ಮ್ಯಾನೇಜರ್ ನೋಡಕ್ ಹೋದ್ರೆ ಆಗಲ್ಲ.
no, my lord, with 2 checks we enter the banks, my lord.
ಚೆಕ್ ಇಲ್ಲ, DD.
Please, my lord, DD will pay 2 weeks time, my lord.
DD ತಗೊಳಕ್ 2 weeks ಬೇಕಾ?
No.
ನಾಳೆ ಕಟ್ತೀರಾ ಇಲ್ವಾ ಹೇಳಿ?
No.
Don't sing the same swan
lord.
song.
One submission. This DRT challenge the DRT order.
ಆಯ್ತು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ತಾಳಿ.
Okay.
ನಿಮಗೆ ಬ್ಯಾಂಕ್ ದುಡ್ಡು ತಾನೇ ಬೇಕು?
Yes.
Wait.
Kindly pass over, my lord. I will take instruction. Just,
No singing same swan song.
no, my lord.
ಹಂಸಗೀತೆ ನಡೆಯಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ, ಇಲ್ಲ. I will seek in 2 days, 2 weeks, my lord. Otherwise, I will take instruction. Kindly pass over, my lord.
Pass over. I'll call it back.
Please.
ಇಲ್ದಾರೆ ಈಗಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
No, my lord.
Yes.
51, Raviraj C. Patil.
Appear on behalf of the people. Respondent number 6.
It's IP of the petitioner. The issue relates to 3 delegation that being sent minutes to the.
Oh, ಹಾ.
Now will
ಹೇಳಿ. ಈಗ ಯಾರನ್ನ ಕಳಿಸಿದ್ದಾರೆ?
the respondent number 6 society has sent. Let the fellowship sees the first minutes delegation that was
ಈಗ
sent.
ಡ್ಯೂಯಲ್ ಡೆಲಿಗೇಷನ್ ಆಗಿದೆಯಾ?
Third time.
ಆಗಿದೆಯಾ?
This is the third time. Now according to them, the first delegation which was sent was in a previous term. And the present body had come into minutes.
No, you tell me if the term of the body is over, the delegation also gets over or it
In
adds
fact,
on to the
even
next?
even if that is, let's not taken into consideration, if that is it, he is sent one more time.
Now, there is a body of management.
Yes.
Now, delegation is sent by that body of.
Yes, ma'am.
The term is over, supersedes, any circumstance that is over.
Yes.
Now, the new body comes in.
Yes.
Delegatee is the same, but delegation is sent by the new body of management.
Yes.
All right.
Yes.
If that is the case, then how will the earlier body's delegation stay valid for counting that it is 3?
It is their contention.
I
that
don't know if it's
No,
their
no, no.
contention.
Even if that is
That's
left
a
out.
doubt I have.
No, let's, even if that is left out, it amounts to 3 delegation being sent. Yes.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಷ್ಟೇನಾ?
ಹೌದು ಅಷ್ಟೇನೆ. Because my lord, your
ಆಯ್ತು,
lordship,
ಅವ್ರು
before I could say, your lordship said that because it is the board, I would have shown the definition, but your lordship have gotten it. I don't know. Now it appears what he wants to say is, it is the same, very same board. Now it is the third time that they have given.
ಅಷ್ಟೇ, ಅದು ತೋರಿಸ್ಬಿಡಿ ಸಾಕು.
ಇಲ್ಲ, ಇದಕ್ಕೆ we have a reply for this.
Yes.
I'll get back to you.
Yes. But the first delegation was sent, if your lordship sees, even after their new body has come into place.
ಮಲ್ಲಿಕಾರ್ಜುನ್.
Yes.
ಡೇಟ್ಸ್ ಹೇಳ್ಬಿಡಿ
Yes,
ಸಾಕು.
yes. Second blood, the date is 27/7/2024.
ಫಸ್ಟ್ ಡೆಲಿಗೇಷನ್.
Andre, if according to them, this is first is 27/7/2024, first delegation. Now, the other delegation which I have filed it
No,
along
no,
with.
this is by which?
The new board.
New board.
By the new board.
ಸರಿ.
Now, the second is 38/2025.
38, 2025. ಈಗ
The third one is a impugned one, impugned.
date.
That is dated, let's,
ಇದು 38 ಅವ್ರು ಏನ್ ಹೇಳ್ತಿದಾರಲ್ಲ ಇದು ಅದಲ್ಲ. 38 ಹೌದು ಬಟ್ ಇದು
25/10/2025. To the elections held on 25/10/2025.
ಓದಿಸ್ಬಿಡಿ ಸರ್.
ಈಗ ಎಲೆಕ್ಷನ್ಸ್ ಆಗೋಗಿದೆಯಲ್ಲ.
Election ಆಗಿದೆ, results are, let's,
withheld here.
ಹೌದು.
Lord, let my learned friend, the new
That is
one.
my judgment, delegation,
Yes.
more delegation
That
ಮಾಡಬೇಕು.
was, he had argued.
ನೀವೇ
Argument ಮಾಡಿದ್ದಾರೆ.
ಒಂದು ಹಂಗೆ you
ಇಲ್ಲ,
came-
ಅದಕ್ಕೆ
came here and took a bill.
absolutely no quarrel. I'm not going to go back on that. Though I may take up a defense that I may have grown a little wiser, but no, my lord, there is some distinction
ಅದಕ್ಕೆ
there. My lord, two things there.
ಇದು ರೇಟ್ ಬಿಲ್ ಹಾಕ್ಲಿಲ್ವಾ? ಹಾಕಿರ್ಬೇಕಲ್ಲ ಇದು.
Hakil. This has become final. In fact, there, my lord, one is we had made the delegate a party. Second, elections was not yet held. Your lordships had barred him from voting. That's the second point. Here, the third one, which my lord, he's saying on 38/24, it is with regard to general meeting and not with regard to the voting as mentioned under
21/3.
21/3.
21/3. I'll just show that distinction.
You are covered by your own arguments.
ಇಲ್ಲ. Well, because what your lordship said, extracting the said provisions, then at para
21/3, yes.
Yes.
21/3 bars a member once nominated
By the
to
board
vote
to
in
vote
election
in an
twice
election
over.
twice over. Now, my lord, the distinction here is only this, my lord. Now, what the second one they are showing, 38/2024, that says, ಸಭೆಯ ನೋಟಿಸು ಪರಿಶೀಲಿಸಿ ಸದರಿ ಸಭೆಗೆ ಹಾಜರಾಗಲು ಅವಶ್ಯ ಬಿದ್ದಲ್ಲಿ ಮತ ಚಲಾಯಿಸಲು ಸಂಘದ ವತಿಯಾಗಿ ಅಧ್ಯಕ್ಷ ಶ್ರೀ ಸೊ ಗಣಪತಿ so and so. So now, my lord, if your lordship sees 21/3, my lord. Now first your lordship may kindly see.
ಅವಶ್ಯವಿದ್ದಲ್ಲಿ ಕಳಿಸಿದ್ದೀರಾ.
ಸರ್ವಸಾಧಾರಣ ಸಭೆ.
This is a general meeting, my lord. Why I'm saying that is, if your lordship were to turn to section
21.
21.
ಓದಿ
Yes,
sir.
your lordship may kindly see 20.
You don't worry about ಓದಿ.
Manner of exercising vote. This is section 21. This is
Correct.
prior to 21/3. That's why I want to read this.
Prior to?
21/1.
Oh, 21/1 is prior to.
ಹೌದು, ಅಲ್ಲಲ್ಲ, ಅಂದ್ರೆ ಅದರಲ್ಲಿ ತಾವು ಹೇಳಿದಿರ, ಇದರಲ್ಲಿ I want to show something.
ಇಲ್ಲಿ ಕೊಟೇಶನ್ 21 ಇಂದಾನೆ ಇದೆ. No worries. ಹೇಳಿ.
ಅದಕ್ಕೆ ಇದರಲ್ಲಿ every member, every representative, every delegate and every nominee shall exercise his vote in person and not by proxy at a general meeting.
Yes.
Yes, ma'am.
At a general meeting
or an election by the members of the board of a
cooperative society.
My lord, if it is only to this, then my lord, I have no case.
Don't think you have a case.
Yes, my lord. Now I'll point out what is the case. Then your lordship may kindly see
21/3.
21/3, because then notwithstanding, my lord, 2. Your lordship may kindly see, my lord, 2 is notwithstanding anything contained in subsection 1. Then your lordship may now turn to 21/3. A member once nominated by the board of a cooperative society under clause A of subsection 2 to vote. Now, subsection 2, your lordships, now we'll see A of subsection 2. Subsection 2 is notwithstanding anything contained in subsection 1. A, this is what, my lord, in 21/3 it says. The board of a cooperative society, which is a member of another cooperative society, may appoint one of the members of the board to vote on its behalf in the affairs of that other society. So here it says that a member once nominated by the board of a cooperative society under clause A of subsection 2, not so, my lord, the general meeting will not come here. This is with regard to the election. So, my lord, they have made a very clear distinction, because here, if that's
Between a general meeting and an election.
yes, my lord, because that is the reason why.
The second nomination, according to you, was for general meeting.
Yes, my lord. The third one was for voting. So that will be there. But this one was only for a general meeting, and that, my lord, is different, because here they very specifically say it is under clause A of subsection 2. So subsection 2 is very clear here. And so my lord, a member once nominated by the board of a cooperative society under clause A of subsection 2 to vote on its behalf in any meeting of any other cooperative shall not be changed except by so and so by 2/3 majority of the members present in voting. However, a cooperative society shall not nominate or appoint any member of the board to vote on behalf of it in more than 2 cooperative societies. So my lord, one which
So it is only elections and not general meeting.
Yes, no, because that is the
So
objective.
that's the distinction you're drawing.
Yes, no, because
Yes,
otherwise
Madam.
21.
So subsection 2 is clear, my lord. It doesn't relate or restrict to voting. If you just read the entire
21(2).
21(2). Notwithstanding anything contained in subsection 1, the board of a cooperative society which is a member of another cooperative society may appoint one of its members of the board to vote on its behalf in the affairs of the other society. So it is not restricted to millet's election. Let's adding to this millet. Let qualifying section, if you also see subsection 3, the second part of subsection 3 is a rider to millets to this. However, is a word that commences millets in subsection 3.
Yes.
However, a cooperative society shall not nominate or appoint any member of the board to vote on behalf of it in more than 2 cooperative societies. This is a rider in addition to millets that. Now, millet, if you also read that second resolution also which is passed by them, it is not millets only to participate in the general meeting. If need arises, he is also permitted to vote.
Vote, correct.
So now he cannot distinguish and say that. Avashya Vidyalaya. So he was a delegated to vote also. Now he can't be sent to KDCC Bank, which is a third one.
So in those two nominations, the delegate has voted?
He has participated. Yes, ma'am. He has participated.
Both?
Yes, ma'am.
No, did he vote in the election, the
That
second
is
one?
not forthcoming.
No.
He has not voted, which that 3824, because that thing of voting has not come. My lord, that we can file an affidavit, he has not voted. So the voting has not taken place. Because there was a thing that if avashya iddalli mata chalaisalu.
But that right has spent itself, sir. The right that you get under subsection 2 of section 21 to get nominated for any affairs of the society, then that is over now. Whether you cast your vote or not, you have been appointed as a delegate, that's over.
My lord, this is my lord,
No,
because here what has been stated in 1 is, my lord, in general meeting or an election of the member.
Correct.
But here in 2A, my lord, so this is with regard to, my lord, when the primary member.
General meeting, what is it for?
Beg your pardon?
Why a general meeting is called?
Lord, general meeting could be for any reasons, my lord.
Affairs
They
of
may-
the- affairs of the society.
Affairs of the
Correct,
society.
huh?
So there could be a vote.
One nimisham.
Yes.
Affairs of the society, correct, tane?
Yes.
Anything else?
No.
ನಿಮ್ದೇನಾದ್ರು ಹೇಳಿದ್ಯಾ?
Definition of delegate malad.
Definition of?
Delegate malad. Includes malad everything.
For everything.
Represent
The petitioner is before this court seeking the following prayer. Heard the learned counsel Mallikarjun Swami Remat along with Gayatri Sir appearing for the petitioner and the learned senior counsel Gurdas Kannur along with Saurabh Hegde. ನೀವು ಅವ್ರು ಬೇರೆಗಾ? ನೀವು ಯಾರಿಗೆ?
respondent.
KDCC Bank.
And
Sorry, respondent.
so and so appearing for the respondent. The petitioner, facts in brief, Germain, are as follows. The issue revolves around interpretation of the Cooperative Societies Act Quay, section 21, insofar as it permits voting of a delegate in an election. The petitioner, which respondent are you?
Six. Respondent number
The
6.
respondent number 6 is chosen as a delegate to vote in the election or the general meeting.
No. Respondent.
Society is made as a party.
They have not made delegate the party. It's only the society. Delegate is
Society,
not the
you
party.
nominate the delegate.
Yes.
The 6th respondent society nominates a particular delegate on 27/7/2024 for the first time for the purpose of voting in the ensuing elections therein. Later, on 30th August 2025, it transpires the 6th respondent society again nominates a delegate for the purpose of participation in the general meeting of the society, or if need arises, also to vote in the ensuing elections thereon. For the third time on 25/10/2025, it transpires that the sixth respondent again nominates the delegate for voting in the ensuing elections, and the delegate has now cast his vote. The petition calls in question the action of the society in nominating the delegate thrice over for the conduct of elections or otherwise. The learned counsel appearing for the petitioner, Mallikarjun Swamy Hiremat, taking this court through the mandate of the statute, would seek to contend that the delegate which is now sent by the sixth respondent, whether he votes in the general meeting or the election, is of no consequence as it pertains to the affairs of the society. He would submit that the statutory bar under subsection 2 of section 21 and subsection 3 of section 21 is unambiguous, which prohibits the voting in any election or general meeting more than 2 occasions. The learned senior counsel Gurdas Kannur, appearing for the sixth respondent, would seek to distinguish the said submission or refute the submissions in contending that the delegate now the delegate now who is now the sixth respondent has now delegated for voting only for the second time in an election. On 30th August 2025, the delegate was nominated only for the purpose of general meeting, and if need arises, it was for voting in the election. He would submit that he has not cast his vote in the then election. The learned senior counsel would seek dismissal of the petition on the score that it is not more than twice that the delegation is done by the sixth respondent. The learned counsel Vishwanath Hegde, appearing for this society.
Respondent number 7.
Respondent number
7.
ನೀವೇನ್ ಹೇಳಿದ್ದು?
My lord, the definition of delegate, my lord, includes, my lord, everything. My lord, under section 2 of E1A.
The learned counsel would submit that the definition of delegate would include the action of the delegate, be it in the general meeting or in the election, as the case would be. He would make his submission and leave the decision to the court. The aforenarrated facts are not in dispute. The issue lies in a narrow compass of the interpretation of section 21 of the Cooperative Societies Act. The section 21 reads as follows. Subsection 1 of section 21 permits a delegate, but section 21 deals with manner of exercising a vote. Every delegate and every nominee shall exercise the vote in person at a general meeting or an election of the members of a cooperative society. Therefore, subsection 1 deals with both the general meeting or an election. The subsection 2 would begin with a non-obstante clause, observing that directing that notwithstanding anything contained in subsection 1, the member may of a cooperative society which is a member of another cooperative society may appoint one of its members to vote on its behalf, quote unquote, in the affairs of that other society. Therefore, the distinction of election is not found in subsection 2. It would include other affairs of the society. Subsection 3 would further mandate that a member once nominated by a board of a cooperative society to vote on its behalf in any meeting of any cooperative society shall not
That's however, that's
shall not be permitted to be appointed to vote on its behalf in more than 2 cooperative societies. In the aforesaid, the consideration of the aforesaid mandate of the statute, the unmistakable inference would be that the petitioner, that the delegate, be it for the purpose of a general meeting, which would mean the affairs of the society, or the election as mandated under subsection 1 or subsection 3 cannot be permitted to be a delegate for the purpose of voting more than 2 occasions. If it is permitted, it would be committing violence to the statute, which is unambiguous, that it cannot be, that voting cannot be, nomination cannot be to more than 2 cooperative societies for the purpose of election or for the purpose of general meeting, as the case would be. More so in the light of the fact that the definition of delegatee in the statute would clearly indicate that it would be a delegation for the purpose of election or for any general meeting. In that light, the vote that is cast by the vote that is cast by the 6th respondent, by the delegate of the 6th respondent in the elections of 25/10/2025 is a vote is a vote that is invalid. Therefore, the further action shall be taken by the respondent, excluding the vote cast by the 6th delegate of the 6th respondent. Again, results announced.
Yes.
And announce the results and take the issue to its logical conclusion, bearing in mind the observations made in the course of the order. Ordered accordingly. Yes.
Please.
Yes, sir. You are hit by your own submissions.
I'm aware of that. In fact, that was the earlier board which you said. This one, my lord, now they brought it to our notice about that other 3824, which, my lord, we just in the afternoon came to know, and we were trying to see how we could distinguish, but it was a very difficult task. So that came in our way. Otherwise, their earlier petition, as your lordship said, that earlier board and new
Petition,
board.
you came, you stood, you took the order and went away. 5 minutes.
Alla, Madlin petition prakara.
Petition, it was,
yes,
it was an open and shut case. Yes.
True, my lord. If this 3824 was not there, then as your lordship rightly said, it was the old board and the new board. Then it would have been different. But in the new board itself, 3 times it has happened under the new board itself. So
old board, new board, that's a different interpretation.
yes, that
Now,
we,
more idrale agide. Whether it is general or otherwise,
that was what we were banking on. But this came to our knowledge only some time back about the third one which was done.
Weak wicket. Yes.
The second one, 51, next 52 minutes.
ಅದೇನಾ
ಅದು ಮೂರು ಅದೇ ಇದೆ. ಇದರಲ್ಲಿ the distinction is he was sent
same
ಇಲ್ಲ ಸೇಮ್ ಸ್ವಲ್ಪ ಬೇರೆ ಇದೆ. ಸೌಹಾರ್ದ and cooperative society.
Whether sending a delegate to vote in a Savarda cooperative society would amount
for
to
the cooperative Savarda society.
Sahakari. It's as good as.
I will decide this later then.
Please.
Yes.
Tomorrow day after. ನಾಳೆ ಇದಿರಲ್ಲ.
ನಾಳೆ ಇದೆ.
We'll decide it tomorrow.
No, 1088, my lord, both of us are there. This is what yesterday it was listed before your lordships. I troubled your lordships.
Appointment of administrator is stayed by your
Appointment
lordships.
of an administrator. Now there what has happened is, your lordships has said that if
I'll take it, wait. We'll take it at 5:30.
Could it be taken tomorrow?
Why?
My learned senior is, no, first of all, his application for impleading is to be allowed. I have serious
application.
ಹೌದು.
ಅಲ್ಲ society
Objections ಹಾಕಲ್ವಾ?
Objections ಇವತ್ತು ಅವರು affidavit ಇವತ್ತು
ಅಲ್ಲ
ಬರ್ತಾರೆ.
ಇವತ್ತೇ ಇಟ್ಕೊಂಡು ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನ್ I'll only point out this one, then I leave it to your my lord. Now what they have done, the board, my lord, some of them have won, some of them have lost indisputably. So the old board, now they're taking policy decisions. My lord, when the elections, my lord, the elections are held, the results are not declared. My lord, I can understand if, my lord, only as a caretaker government, my lord, the procurement committee, expenses committee, my lord, they are passing resolutions where some of the quorum members, my lord, 9 have not been declared.
Term ಮುಗ್ದೋಗಿದ್ಯಾ?
Term ಮುಗ್ದಿದೆ. Because of, no, elections are also over. Because of the interim order that are subsisting, results are not declared.
Will direct declaration of results.
That if that is done, my lord, I would.
That, my lord, my only other
Okay, ಬೇಡವಾ?
they should not, ಅಲ್ಲ ಅದ್ ತಾವು ಮಾಡಿ. ಇನ್ನೊಂದು ಏನಂದ್ರೆ
ಲಾಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಅಲ್ಲ ಅವರು they should not give effect, my lord, they are taking decisions with regard to expenditure.
Will direct the results to be declared day after tomorrow.
ಅವೆಲ್ಲ petitions number ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದರಲ್ಲಿ annexure ಮಾಡಿದ್ದೀನಿ. All they can be club bloods if it is disposed of.
ಅಲ್ಲ
number
then all
ಕೊಟ್ಟಿಲ್ಲ.
it is part of the writ petition itself. I made it as ಹೌದು.
ಅಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ತಮ್ಮಿಂದ interim order ತಗೊಂಡು they are functioning like
ಅಲ್ಲ, ಇವ್ರು
proper newly elected boards.
Some come on record,
Some of them have lost the election to the knowledge. They are part of the board.
Sir, 88 ಯಾವ್ದದು?
88, then that
ಒಂದೇ ಇದೆ ಇಲ್ಲಿ.
ಹೌದು. ಅಲ್ಲ ಅದರಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. 17 ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ವರ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್. because of the interim order that was passed.
We'll post everything tomorrow.
I have given that list, it is annexure.
List all of them tomorrow. We'll close all this tomorrow.
Please,
We'll direct results to be declared and taken to its logical conclusion.
please.
Yes. ನಾಳೆ ಯಾಕೆ madam?
Only thing is they should not
ಅಲ್ಲ ಇವರು ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡ್
give effect to all those resolutions.
ಅಲ್ಲ,
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು
ಒಂದ್ minute sir.
17
ಇವತ್ ರಾತ್ರಿ ಮಾಡ್ತಾರ ಅದನ್ನ.
ಅಲ್ಲ ಅವ್ರು ಏನ್
ಆಗಿದೆ
ಮಾಡಿದ್ರು
already.
17th
ಇಲ್ಲ ಇವತ್ ರಾತ್ರಿ ನೀವು ಏನಾದ್ರು ಪ್ರೋಗ್ರಾಮ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ರಾತ್ರಿ ನಾವು ಏನು ಮಾಡ್ತೀವಿ?
14th ಗೆ ಎಮರ್ಜೆನ್ಸಿ ಮೀಟಿಂಗ್ ಕರೆದ್ಬಿಟ್ಟು they passed the resolution with the board members who have lost the election.
No,
It is not.
I'm only asking, do you have any program
No,
tonight?
today absolutely no, there is no.
Tomorrow ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ ಈಗ ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ. Only we have sent the delegation forms to the apex bank. That is their objective.
ಆಯ್ತು, tomorrow will. You are there tomorrow ಅಲ್ಲ?
ನಮ್ದು 230 ತಗೊಂಡ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
230 ಗೆ ಯಾವ್ದು?
ಅದು KDBದು
ಎಲ್ಲಿದೆ 230?
ನಾಳೆ ಇವತ್ತಲ್ಲ, ನಾಳೆಗಿದೆ. ನಾಳೆ
ನಾಳೆ ಇದ್ದೀರಲ್ಲ?
ಎಲ್ಲ ಮ್ಯಾಟರ್ ನಾಳೆ ಬಂದ್ರೆ ನಮ್ದು ಆ ಮ್ಯಾಟರ್ 2012 ಮ್ಯಾಟರ್ ಮತ್ತೆ ತಮ್ಮ ಟೈಮ್ ಇಲ್ಲ.
2012 ಯಾವುದು?
ಅದು KDBದು KDB had said that they don't want the land, my lord, I have that land. So they themselves have gone to the Supreme Court. They have the
We'll see tomorrow.
Yes.
Interim order can be 88 ಅಲ್ಲಿ. There is an interim order.
That will continue. Madam, 88 ಅಲ್ಲಿ interim order continue ಮಾಡಿ. List this petition along with all connected cases tomorrow in fresh matters.
Please.
We'll dispose all the 17 or 18 tomorrow and direct holding results to be declared.
Please.
That is done immediately then.
Milord, serial number that 55 and 105, those are recreational matters.
Recreation. ಆಯ್ತು, urgency.
Next matter only, next.
ಆಯ್ತು, wait. Where are you appearing?
54.
ಇಲ್ಲೇ ಬಂದ್ಬಿಡಿ madam. On the side.
Milord, 54 madam.
So I have to hear you like this.
54 next matter.
ನಾಳೆ ತಾವು ಇನ್ನೊಂದು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಒಂದು ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಎಲ್ಲ ಇರ್ಲಿ ಬಿಡಿ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಭಾಗವತ್ and Mr. Bhajantri.
Don't worry. Yes.
54 and
ಯಾವ್ದು? Appointment by promotion. By transfer.
For diploma ಇಲ್ಲ.
ಅದೇ, that's what ABT.
Yes. That whether
That's appointment by transfer.
Executive engineer post can be given to the diploma holders or only degree holders.
Exactly.
Milord, 52 and 53 has to be called tomorrow.
52 tomorrow.
52 and 53 both are same.
Both tomorrow.
And 54 is Milord
Recreation page.
Milord annexure A.
54 and 55 recreation.
54 and 55 ಅಲ್ಲ.
54 ಮಾತ್ರ.
4 ಅಷ್ಟೇ. ಆಮೇಲೆ 105.
54 and 105 recreation close. Ranjita 55. She is busy.
Ranjita.
ಅದೆಲ್ಲ ಆಚೆ ಕಡೆ ಮಾತಾಡ್ಕೋಬಹುದು.
Your lordship, I have challenged annexure E rowdy sheeter diary, your lordship.
Rowdy sheeter diary ಇದೆಯಾ?
Sorry.
Register.
1059. Only the allegation, your lordship, there is a pendency of one criminal case. Last occasion, your lordship has directed them to take the instruction.
Only one case. Only one case is there.
ಏನು offense ಏನು?
Offense is, my lords.
143, 147, 148.
Unlawful.
506.
BS Prakash.
Yes, Prakash is yes.
The petitioner 230 matters ಬಂದಿದೆ ಮೇಡಮ್?
Yes.
ಒಂದೇ ನಿಮಿಷ 230 ಫಿನಿಶ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ. ಎಸ್ ಕರೀರಿ. ಸಾದಿಕ್ ಗೋಡ್ವಾಲ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ? Being spoken to na. Why Sadiq?
Being spoken ನಾಳೆ ಇರ್ತದೆ, ನಾಳೆ
ಇಲ್ಲ
230 ಗೆ ಯಾಕೆ ಮೂವ್
ಅದೇ that is what I meant. 170 ಇವತ್ತು ಬಂದಿದೆ, ಅದು lordship has disposed it.
170 ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಹೌದು, ಅದು ಆಗಿದೆ.
ಅದು ಮತ್ತೆ ಯಾಕೆ ಬಂದಿದೆ?
ಅವರೇ recall ಮಾಡಿದ್ದು, ಇವರೇ recall ಮಾಡಿದ್ದು. Therefore your lordship 170 and 170
ಇದು ರೀಕಾಲ್ ಮಾಡೋಣ.
170
ಒಟ್ಟಿಗೆ ಹಿಯರ್ ಮಾಡೋಣ.
ಆಯ್ತು, serial number 170 no.
Tag this petition along with serial number 170 in the light of the fact that serial number 170 and the subject petition a number ಹಾಕಬೇಕು, 170 ಅಂತ ಹಾಕ್ಬೇಡ. Subject petition are identical. And the said writ petition is recalled. The subject petition also stands order passed in subject petition also stands recalled. List tomorrow. Fresh matters both. ನೀವೇ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೊಂಡು ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಮಾಡ್ತಾ ಇರೋದು?
ಇಲ್ಲ, I am not aware, my lords.
Not aware.
230 ನನ್ಗೆ ಹೇಳಿದಾರೆ ಅವ್ರು. ಗೊತ್ತಾಗಿಲ್ಲ ನನಗೆ.
ಏನ್
ನಾನು
ಗೊತ್ತಾಗಿಲ್ಲ?
ಕನೆಕ್ಟೆಡ್ ಅದನ್ನ ತಿಳ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ, ಕನೆಕ್ಟ್
ಏನ್
ಆಗಿಲ್ಲ.
ಪ್ರೇಯರ್ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ? ಆಯ್ತು, ನಾಳೆ. ಎಸ್.
Serial number 2, Santosh Mane.
ಸಂತೋಷ್.
Please.
ಸಂತೋಷ್ ಮಾನೆ.
Please.
ಹಾ. ಕೊಡಿ ಆರ್ಡರ್ ಸೇಮ್.
Please. It's covered by
ಪೆಟಿಷನ್.
Same
CP ಹೆಗ್ಡೆ ಅವ್ರು ಯಾವ್ದಕ್ಕೆ ಇದಾರೆ? ಇದಕ್ಕ ಸೇಮ್ ಆರ್ಡರ್.
57 and odd ones, my lord, sir.
Serial number 2.
No, my lord, that is
Mahadev.
same series of
Same
matters where
order.
notice is
KBJN
not
and
given
same
to
order.
the
Heard
beneficiary.
senior counsel ಅಂತ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್.
Serial number 57 mala.
Hmm.
57, 58 all KBJN matters.
ಒಂದು ನಿಮಿಷ ಬರ್ತೀನಿ. ವೇಟ್ ಸರ್, 2:30 ಮುಗಿಸ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಕಮ್ ಬ್ಯಾಕ್. ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು? ಧಾರವಾಡಕ್ಕೆ ತಾನೇ ಹೋಗ್ಬೇಕು. ವೇಟ್. ಎಸ್ ಮಹಾದೇವ್.
Serial number 3, Mahadev Emma.
ಎಲೆಕ್ಷನ್ ಅಂತ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. ವೋಟಿಂಗಾ?
The election, the results have already been announced.
Then Justice Shyam Prasad or order.
My lord, the petitioner has cast his vote. His vote has been placed in a sealed cover.
It will be opened, sir. Opened. The whatever Justice Shyam Prasad has written, same order. Shyam Prasad or order. Next.
Serial number 4, Santosh Mane.
Same 4, 5, 6, 7, 4, 5,
8, 9,
up to 9.
and then 12 to 28, my lord.
9 and 12 to 28, same order.
And 30, 31. 30, 31.
ಅದು ಬರ್ಕೊಟ್ಬಿಡಿ ಅವಿನಾಶ್. ಎಲ್ಲ ಬರ್ಕೊಡಿ. ಸೇಮ್ ಆರ್ಡರ್. ಎಸ್. ನೆಕ್ಸ್ಟ್ ಉಳಿದಿರೋದು ಯಾವಿದೆ?
Serial number 10,
Shivraj.
Shivraj Karlaki.
Serial number 10, I appear for the petitioner. Lord, in this matter, I am a Jaggery unit. I have been producing Jaggery since 2011. Now, Lord, what happens is on 15/11/2025, Lord, Annexure 8, page 13, Deputy Commissioner passes an order directing me to stop my operations on the basis of an order passed by the government on 4th January 2025. May I request the Lordship to take the government order first, Lord?
ಹೇಳಿದಿನಲ್ಲ ಇದು 4th January 2025.
Please. This was the subject matter of challenge. Yeah, your Lordship has passed an order.
Yes. 4th January ಅಂದ ತಕ್ಷಣ I got it. Somewhere.
I'm grateful.
Yes, sir.
Page number 83, my lord, that's the operative portion of the order. In fact, Lord, this was the subject matter of challenge before your lordships.
83, yeah.
83 is 82, my lord, is the operative portion of the
Here is
order.
my order.
Lord,
Prashant,
Lord,
an
the
order.
4th January order, I will just explain the matter, my lord.
They make the same mistake.
The
Now what's the
4th
problem?
January
Tell me,
order.
sir.
My lord, the 4th January order is passed in a larger context of whether, my lord, Askins, a unit that is adjacent to mine, and me, together we constitute a sugar factory, and whether, my lord, certain earlier orders of the cane commissioner should be enforced or not. Now, my lord, there is no restriction in the order. I have gone through the order carefully, my lord. This was also, my lord, argued before your lordships. There is no restriction whatsoever on manufacture of jaggery. This is a restriction on manufacture of sugar and operating together. Now, my lord, what happens? The deputy commissioner relies on this order and says you cannot manufacture jaggery. May I request your lordship to take the operative portion of the order at page 82.
Wait,
Lord,
wait, what is the urgency for moving it at 2:30? I'll take it tomorrow morning.
My lord, today, in fact, my lord, a letter is issued to the Tehsildar to close down my unit today. They are standing there, my lord, today, not waiting to close down my factory. My lord, the letter is produced.
1 minute.
Page number 61.
The order passed by my lordship, my lord.
That is
My lordship, yes, against the my lordship order, they prepared a writ appeal, there is no interim order.
Writable pending ಇದೆಯಾ?
Writ appeal pending, it is been heard and it is reserved, there is no interim order is operating.
Heard and reserved.
Heard, reserved, no interim order. No interim order has been granted, heard for more than 5 to 6 date of hearing, my lord, no interim order has been granted. So this is an order has been passed to implement the order passed by my lordship. My lord, they are manufacturing in the.
Allah, my lords may appreciate that in the earlier rounds of litigation, my lords,
very
Supreme
fact
Court
that,
also
very
permitted
fact
us
that
to
they have not
manufacture
produced the
jaggery.
order passed by my lord.
Where is my order, sir?
Yeah, that is sufficient to show that the conduct of the petitioner, my lord.
Where is my order?
My lord, I will just point out.
Have it tomorrow, my lord, please. Have it tomorrow.
Where is my
I will
order?
point out the urgency. My lord, now what has happened is, my lord, the 4th January
Counsel,
order.
I'm asking a simple question. Where is my order?
Lord, your order, my lord, is not on record in
Why
the
you
petition.
have not produced it?
My lord, the reason is this. My lord, the
No,
4th
if-
January
if
order
the-
does
if
not
the
pertain to me
action-
at all.
1 minute, sir. If the action of the state is in implementation of an order passed by this court, should we not at the outset produce that?
My lord, it does not pertain to Jaggery at all. It does not pertain to me today. It does not form the subject matter of this matter before your lordships today.
Is it not a composite order, 4/1/2025?
Yes.
In a different context. In a different context of.
Sir, see, jaggery and sugar may be different in its sweetness, but the effect is the same.
No, my lord.
So I think it's a composite order.
No, my lord, for the
I
sugar
remember
control
even
order
without
only
looking
applies.
at the order, it was a
Sugarcane control
composite
order only
order for
applies.
both jaggery and sugar. The council is also here who appeared. See,
4/1/25 is the order of the under secretary, my lords.
I think the council, same
Not
council
my
had
lord's
appeared
order.
earlier. Hmm.
Yes.
We'll take it
Tomorrow,
tomorrow.
please.
I may be permitted to.
Lord, in the meantime, Lord, may I only request that the impugned order be stayed?
My lord, let them not take any precipitative
No,
actions or, let
no,
them
one
not take
minute.
action to
You-
shut my unit down.
One moment, sir. Don't precipitate the matter till
My
tomorrow.
lords, may not
If they
pass
are
in.
wanting to close down and other things, don't do that.
My lords, may I only make one submission on this, my lords? My
Gautam,
lords,
I'll take it tomorrow.
illa, my lords,
My lord, there's no business in
order
making
to pass.
submissions, my
My
lord.
only
They know
request
they have no locus. They have no locus. Let the state argue their case, my lords. I mean,
Lord, in fact, I'm grateful
these
that
people
the.
have no business in arguing the state's matter, my lord.
Lord, in the round of litigation before the learned division bench, Lord,
tomorrow,
learned
sir.
addition- please.
Please, tomorrow.
Let-
Yes.
don't
I will
precipitate.
instruct. I will instruct.
ನಾಳೆ
Please.
ತಗೊಳ್ಳೋವರೆಗೂ ಸುಮ್ನೆ ಇರಿ.
Please, ma'am.
I will
Please.
pass appropriate orders tomorrow.
Please, ma'am. I will
My
instruct.
lords, we'll also file our documents, my lords.
Great.
because most
Copy
of the
ಕೊಡಿ. Tomorrow we'll hear you. Yes.
My lords, we'll also produce documents, my lords, because most of the
Who is
documents are.
ಗೌತಮ್ ಯಾರ್ಗ appear ಆಗ್ತಿರಲ್ಲ?
My lords, with
Serial number 11 millets appearing for petitioner in this matter.
ಇದು ಶುಗರ್
No millets, this millets matter is pertaining to the elections of the Hubballi Bar Association. Millets,
ಸೇಮ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರೆ.
yes, millets, the yesterday after order of your lordship, millets, the respondent issued a calendar of events. Virtually, millets, it is nothing but a contempt of court. Kindly see page number 81, millets, your lordship's order, millets, order dated 17th October 25. Relevant at page number 83 and 84, millets.
5925 ಆರ್ಡರ್ ಯಾವುದು?
This is, millets, it is extracted in the page
ಯಾವುದು?
number 8.
ಸೂರತ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್.
Suraj Sahib order, millets. Later, millets, after this order of your lordship, millets, the respondent ought to have issued calendar of events based on annexure C, millets. Instead of issuing the calendar of events on the annexure C, the respondent issued the calendar of events based on, millets, annexure number B. Very, millets, they have shows only 1,117 voter list, millets.
Annexure C ಏನು ಸರ್?
Annexure C, it is updated voter list, millets.
ಎಲ್ಲಿದೆ ಅದು?
Page number 48.
ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಅದರಲ್ಲಿ 1349 millets.
1349.
1349.
ಹ್ಮ್.
And annexure B
B ಅಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
B ನಲ್ಲಿ 1117.
So about 250 votes.
Yes, millets. Kindly see page number 46, millets, the date. The
22/11/2025.
22/11/2026, millets.
26
Sorry, 22/11/2025.
ಹಾ.
No date ಬಂದಿಲ್ಲ, millets. And the very action, millets, the petitioner is a practicing advocate.
Why
He
sir
is
you are
standing
thinking in future?
ಅದು ಏನೋ ತಪ್ಪಾಗಿದೆ.
That's nothing but a contempt, millets, the action of the.
You sir, Shilwal sir, it
I
was your
undertake-
undertaking that you will adhere to the list that was already there.
No, sir. No, I told them, as on last 22 second, calendar of events is final subscription to be paid on 19/11/2025. 19/11/2025. ನಾಳೆಗಿದೆ. ಅಲ್ಲ, subscription ಕೊಡ್ಲಿಕ್ಕೆ. Final voter list would be on 22/11/2025.
ಆಗ್ಲೇ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ಅದನ್ನ?
ಇಲ್ಲ, ಅದನ್ನ ತಪ್ಪ ನಾನು ಹೇಳಿದ್ದೀನಿ. I already told them that they have to hold election as per the new list. 1000 ಅಷ್ಟೇ.
ಇನ್ನೇನ್ ಬೇಕು?
In terms of
second
that,
undertaking.
Second undertaking. My humble submission is, millets,
No,
the
I advise
action of
them
the
not to
respondent. This is not, millets, this is undertaken
Immediately
even before
after-
before the
immediately
constitutional
after
court. This is
disposal.
nothing but nothing but contempt, millets, because millets, the petitioner is practicing.
We'll
standing
refer
in
it to the contempt bench.
There is some
standing
confusion.
33 years of standing in the bar, millets, the petitioner, he is a practicing advocate. He was the president of the bar association.
ಹೆಸರಿಲ್ವಾ?
ಎಲ್ರದ್ದು ಹೆಸರು ತೆಗೆದ್ಬಿಟ್ಟು ಅವ್ರ ಜೂನಿಯರ್ಸ್ ಯಾರು ಇದ್ದಾರೆ, ಅವ್ರ ಕೊಲೀಗ್ಸ್ ಯಾರು ಇದ್ದಾರೆ, ಎಲ್ರದ್ದು ಹೆಸರು ಡಿಲೀಟ್.
You don't like them, is it?
No.
Don't know, my lords, why they are doing
No, sir, earlier what happened, there was some confusion as far as COP is concerned. Person who advocates who are complied with COP, that is to be added, the bar council has instructed.
ಎಷ್ಟು ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದೀರಾ?
33 years of practice in the Hubballi.
ಅವ್ರಿಗೂ ಬೇಕಾ?
I was the president of the Hubballi Bar
Illa,
Association.
bar council has instructed
That's
us,
the COP rules.
who are complied with COP, they should be included as on the date of finalization of list. We have instructed them.
Plus,
Accordingly, they have to do it. There is no doubt about it. They have to include all those things and
Plus
hold elections.
the returning officer, my lords, they have selected the close associates, close juniors of the petitioners.
ಅಲ್ಲಿ ಹೇಳಿಬಿಡ್ರಿ.
Pick and select ಮಾಡಿ ಅವ್ರನ್ನ ಮಾತ್ರ delete.
ಅಲ್ಲ, ಈಗ ಇದ್ರ ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ ಆಗೋಯ್ತು ಅದನ್ನೇ ಮಾಡಿ.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಥ್ರೆಟನಿಂಗ್ ಆಫೀಸರ್.
Now they have constituted ad hoc committee. Because earlier committee.
ಈಗ ಏನ್ ಎಲೆಕ್ಷನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ರೆಫರ್ ಮಾಡ್ಲಾ?
ಇಲ್ಲ, as per the list, Malas will hold election.
Which list?
1349 members, Malas, which is earlier issued. ಅಷ್ಟೇ ಇದೆ, ಮತ್ತೇನಿಲ್ಲ.
In that terms.
They have to hold election as per the.
ನಿಮ್ದೇನಿದೆ ಮೇಡಮ್?
Subsequently, they sought information with regard to the list of members, my lord.
ಈಗ 1349 ಕರೆಕ್ಟ್ ಅದು?
1349 ಅಂತ ಹೇಳಿದೆ, but we are going to issue a fresh list again by tomorrow. Accordingly, it may be considered.
Then ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ತೊಂದರೆ ಮಾಡಬಾರ್ದು.
That is the problem last we are facing. Sometimes bar council issues list who are complied with COP 1,000 and odd. 1,349. That is the difficulty last.
One submission.
ನಾವು ಈಗ 1349 ಹೆಂಗ್ ಒಂದ್ ನಿಮಿಷ ಮಾಡಿ. 1349 ಹೆಂಗ್ ಬಂತು ನಿಮಗೆ?
We have requested the bar council, state bar council through mail.
ಬಾರ್ ಕೌನ್ಸಿಲ್ ಕೊಟ್ಟಿರೋದಲ್ವಾ?
Yes, madam.
ಎಸ್ ಮೇಡಮ್, ನೀವೇ 1349 ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ.
1349 ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಮತ್ತೆ ಅದನ್ನ ರಿವೈಸ್ ಆಗುತ್ತಾ?
ರಿವೈಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Because they have received some more ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ಇನ್ನೂ ಇದೆಯಾ?
ಇಲ್ಲ, 22 ವರೆಗೂ ಯಾವ ಬರ್ತಾ
11 ಇನ್ನೂ ಬಂದೇ ಇಲ್ಲ ಡೇಟ್, ಆಗ್ಲೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
22 ವರೆಗೂ.
By tomorrow it will be released, my lord. Accordingly.
Tomorrow also 22 ಅಲ್ಲ.
Page number 80, my lords, this updated list taken as on the date of 3/10/2025.
ಯಾವುದು 1349?
1349 as on 3/10/2025, page number 80.
ಕ್ಯಾಲೆಂಡರ್ ಪೇಮೆಂಟ್ಸ್ ನೋಟಿಫೈ ಮಾಡಿದ್ಯಾ ಅವಾಗ?
Yesterday, my lord, 17/11/2025.
So as on 17/11/25, what is the list? That will be the list.
Yes, my lord.
Yes, Archana madam.
Yes.
As on the calendar of events is notified on 17/11/25.
Please.
So you will
1911. 1911.
Calendar of
ಅದು
events.
ಬಂದಿಲ್ಲ madam, in ನಾಳೆ 1911. Yes, 17/11/2025. So the list is 1349 in that.
Please.
It shall not vary. This will be the list on which the elections would be held. Yes. The petitioner is before this court calling in question the voters list so notified on 17/11/2025 along with the calendar of events for the conduct of election to the Hubballi Bar Association. The Hubballi Bar Association earlier Suraj Sahib order
At page number 80, my lord, 81. Annex ready.
ನಂದೇ ಇದು.
ನಿಮ್ದೆ
interim order.
Undertaken before this court.
Yes. This court disposed a writ petition filed by one of the members of the Hubballi Bar Association in writ petition 106786 of 2025 by the following order. Page 83 to 85. The learned counsel V.M. Shilwant, appearing for the association, had undertaken that the elections would be held strictly in consonance with the order passed by the coordinate bench on 15/9/2025. The coordinate bench had directed that the voters list as obtaining on the day to be the foundation for the preparation of the voters list and the conduct of elections. The learned counsel, the present petition is now preferred on the score that the respondent association has committed contempt of the undertaking that is submitted undertaking before this court and the order passed by the coordinate bench, for the reason that a list is drawn of certain members which is dated 22/11/2025, a date which is yet to come. As on today even, the learned counsel V.M. Shilwan submits that there is a mistake by the bar council.
Bar council.
There is the mistake in the bar association. Mistake by the returning officer of the bar association in printing a date in futuro. The learned counsel further undertakes, yet again, that the elections would be held in accordance with the voters list that is drawn on 17/11/2025, which includes, which has in it 1349 members. The learned counsel, Srimati Archana Magdum, appearing for first respondent,
Yes, ma'am.
first respondent would confirm that the members, that the list that is notified by the election officer of the Bar Association is in fact 1349. Therefore, the elections now slated to be held shall be held in strict consonance with what is ordered by the coordinate bench and followed by this court, and as undertaken by the respondent, Shilwant Yarige?
Respondent 4.
Respondent number 4.
2 and 4.
The respondent number 4. Any tinkering or tweaking now with the voters list, despite the undertaking or the observation made by this court, would fringe on the borders of contempt. Borders of contempt. This court has no reason to believe that the respondent election officer would be committing contempt of this court by tinkering or tweaking with the list in addition or deletion to 1349, as is indicated here in above. The aforesaid observations, the petition stands disposed.
Yes.
ಯಾರ್ಯಾರಿಗೆ notice? 1,
2 and 4, my lords,
2 and
Bar
4,
Association.
VM Shilwant, 3 are
Officer, sir.
3 returning of.
I am election officer, respond number 3, my lord. That copy of the same served on me, my lord.
ಅವರೇನಾ election officer?
Returning officer.
How, my lord?
Yes, sir. ನೀವು think in future,
It was mistake, my lord.
ಸರಿ. ಅಲ್ಲ ಏನಾರು ಫ್ಯೂಚರ್ದೆಲ್ಲ ಹೇಳ್ತೀರಾ ಅನ್ಕೊಂಡು. Yes.
My lord, of the date of the
All right, yes.
published, my lord.
So may I request one more clarification? Now body is constituted, that may be including returning officer. New body is constituted, my lords, because earlier body has gone now.
Whoever has to conduct elections will conduct elections in accordance with law. ಅಷ್ಟೇ, that's all. ಅಲ್ಲ, the elections ಅದು ಬರ್ದೇನ್ ಬಿಡಿ, ಮತ್ತೆ need not clarify. You are all of your advocates, ಮತ್ತೆ ನಾನು ಅದನ್ನ ಬರಿತಾ ಕೂತ್ಕೊಳ್ಳಿ.
Number 29, Ranjita.
In this case, I am challenging the annexure A, page number 9, order passed by the chairman of Panchayat Raj.
29. ಏನಾಗಿದೆ ಮೇಡಮ್?
ಇದರಲ್ಲಿ under 17A, your lordship, the chairman of a Panchayat Raj Act has passed an order, your lordship, to inquire the further matter under Prevention of Corruption Act, your lordship. The allegations says that the scam included, misappropriation included, conducted in the Narega scheme, your lordship. Kindly see annexure A, your lordship. My simple submission is now there
What
is
is your legal submission?
Please. There is a bar under section 81B of the Karnataka Lokayukta Act, your lordship. If there is alternative remedy, then under prevention
What
of.
is the alternative remedy?
Alternative remedy is ombudsperson, your lordship. I have.
Ombudsman ಗೆಲ್ಲ ಏನ್ ಕೆಲಸ ಇಲ್ಲ.
ಇಲ್ಲ.
Ombudsman is not an alternative remedy.
For Narega, your lordship, specifically ombudsman forum is framed. That rules I have produced.
That is not alternative remedy. Yes.
Please.
Ombudsman will not do anything. Any other ground?
For there is a judgment, your lordship, exactly
On
for.
ombudsman.
Ombudsman igilla. This says that if there is, andre, it is ombudsman is for appropriate forum to conduct an inquiry, your lordship.
What inquiry ombudsman will do?
Till today, if I am not.
Inquiry ಆಗಿರೋದನ್ನ ಸರಿ ಇಲ್ವಾ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
And also, your lordship, the work project is pending. Till today it is pending. Kindly see, your lordship.
ಎಷ್ಟು crores misappropriation?
It is, your lordship, around 8 crores. It is continuation of the project for 6 years.
Misappropriation continuation.
Alla, 6 years project irodu. Hoolatadu. It is a lake stilling, your lordship. That will never ending project. And also, your lordship.
Misappropriation never ending.
And your lordship, one more contention. Under Narega, your lordship, directly amount will go to the laborers. There is no question of misappropriation. This is my first contention.
ಯಾವ ಲೇಬರ್ಗೂ ಹೋಗಿಲ್ಲ ಇಲ್ಲಿವರೆಗೆ. ಪ್ರಾಬ್ಲಮ್ ಏನದು ಅದೇ ಆಗಿರೋದು. Registry is maintained. Names of the laborers are there. They are ಅವ್ರು ಬೆಂಗಳೂರಲ್ಲಿ ಇರ್ತಾರೆ, ಅಲ್ಲೆಲ್ಲೂ ಇರೋದೇ ಇಲ್ಲ.
If that is a contention, your lordship, kindly see annexure C, your lordship. The CEO itself has given the letter, your lordship, stating that submitted the report before the Panchayat Raj, your lordship.
Who is the competent authority to grant sanction, to grant approval under 17A? ಈಗ 19 ಕೊಟ್ಟಿದಾರಾ, 17A ಕೊಟ್ಟಿದಾರಾ?
17A.
Who is the competent authority? That should be your submission.
Please, competent authority, your lordship, under Panchayat Raj Act.
Who is the
It is chairperson.
chairperson? Chairperson, principal secretary na yaar heli madam.
Sorry, your lordship, I have not looked into that
that
point.
you should-
Nanne ನೋಡಿ ನಾಳೆ ಹೇಳ್ತೀನಿ.
ಅದಕ್ಕೆ ಕ್ಲೈಂಟ್ ಹೇಳಿದ್ದನ್ನ ಹೇಳ್ಬಾರ್ದು, ನೀವ್ ಹೇಳ್ಬೇಕು.
ನೋಡಿ. I've
comes.
gone through the rules of Narega Act, your lordship, ಅದ್ರಲ್ಲಿ
ಅದೆಲ್ಲ
specific
ಏನಾಗಲ್ಲ,
ombudsman.
ombudsmanಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ.
Yes.
ಅನಿಲ್ ಕಳೆ ಸರ್, ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್, ಲೋಕಾಯುಕ್ತ ಇದ್ದೀರಲ್ಲ?
Anil Kales
ನಾನು ಅದೇ ತಾನೇ ಹೇಳಿದ್ದು.
was there.
Yes. Counsel Sri Anil Kale is directed to accept notice for respondents 2 and 3. Learned AGA for the first respondent. The learned counsel Ranjita, appearing for the petitioner, submits that the approval to hold investigation, inquiry or inquiry as obtaining under section 17A of the Prevention of Corruption Act is now accorded by an incompetent authority, as it does not bear the signature of the principal secretary, who is the competent authority to the petitioner. In the light of the said submission, there shall be an interim order of stay of further proceedings pursuant to the impugned order till the next date of hearing, lest the matter on 27th.
I apologize.
Yes, next.
Cell number 32, Venkatesham Kharvi.
ಇದು ಅದೇನೆ, ಇದು ಅದೇನಾ? ನಿಮ್ದಲ್ವಾ? ಮೂವ್ ಮಾಡ್ರದ್ ನೀವೇ. ಸರ್, ವೆಂಕಟೇಶ್ ಕಾರ್ವೆ ಅಂತಿದೆ, CH ಮೂಡ್ ಅಂತ ಇದೆ. ನಿಮ್ ಕೊಲಿಗ್ ಮೂವ್ ಮಾಡಿದ್ರ ಕೇಳಿ.
ನಾಳೆ ಕೊಟ್ಟದ್ದು ಕಾಣುತ್ತೆ, ಇವತ್ತು ಬಂದಿದೆ.
ಓ, ನಾಳೆ ಕೊಟ್ಟಿದ್ದು ಇವತ್ತೇ ಬಂದ್ಬಿಟ್ಟಿದ್ಯಾ?
Please sir, tomorrow.
ಆಯ್ತು, tomorrow. Yes.
ಕನೆಕ್ಟ್
ನಾಳೆ. ಎಸ್ ಮೇಡಮ್, ನೀವೇ ಮೆಮೋ ಮಾಡಿದ್ದ? ಟುಮಾರೋ. ಎಸ್. ಮತ್ತೆ 72 matters 230 ga. ಎಸ್. ಎಲ್ಲ ಐಡೆಂಟಿಕಲ್. ಅವಿನಾಶ್, ಎಲ್ಲ ನಿಮ್ದೆ? ಅಪ್ ಟು 15, 1 to 15 ಸೇಮ್ ಅಲ್ಲ? ಟ್ಯಾಗ್ ಅದು ಎಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್? ಯಾವುದು ಒಂದು ಆರ್ಡರ್ ಕೊಡಪ್ಪ, ಎಲ್ಲ ಲಿಸ್ಟ್ ಇದೆಲ್ಲ ಏನು ಒಂದಿನ ಹಾಕಿ ವಿಲ್ ಫಿನಿಶ್. ಎಸ್
My lord, serial number 57 on the first list. All matters are same, my lord, till 80, 87. All these matters to be listed in.
We'll take it on one day and finish it.
These matters, my lord,
ಅದೇನು
arising out of the UKP project, my lord,
ಹೌದು,
where state is intended to acquire more than 1,20,000 acres of land. For 20,000 acres of the lands, my lord, more than 20,000 cases have been filed before the various courts. And these cases, my lord, without making the beneficiary as a party, arbitrary award have been passed to the extent of 3 crores, 4 crore rupees per acre. So therefore, my lord, now the KBGNL.
supporting KBGN.
Now, yes, my lord. Now the KBGNL has filed.
It is clear. How can they make without making a party?
Yes,
party?
The more than two.
We'll set it aside and send it back to here, make them a party and rehear the matter and close it.
Yes, more than 200 cases have been.
Without making them.
Compulsorily beneficiary to be party.
The coordinate bench has heard this matter, my lord. More than 200 cases have been departed, and the matter is posted on 27th. ಅಥವಾ next week ತಾವರ ಹಿಯರ್ ಮಾಡಬಹುದು ಅಲ್ಲ?
ಪ್ಲಾನ್ ಮುಗಿಸ್ಬಿಟ್ಟು
ಪ್ಲೀಸ್.
ಎಸ್,
on first week of December ಮಾಡ will give.
ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು?
Respondent beneficiary
ಪಾರ್ಟಿ ಮಾಡೋದು
ಅಲ್ಲ, ಅವರು ಪಾರ್ಟಿ ಮಾಡಬೇಕು.
Advocates, my lords, who are appearing in the.
ಬೆನಿಫಿಷರೀಸ್ ಪಾರ್ಟಿ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ,
ಬೆನಿಫಿಷರೀಸ್ ಆಫ್ 3 crores 4 crores ಎಲ್ಲ
owners of the land should be made.
ಮತ್ತೆ
Claimants are parties before this court.
notice ಹೋಗಬೇಕು.
ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
Notify ಮಾಡಿ. My lord, in other cases, my lord, in serial number first, all the notices have been served, my lord. This court has ordered for by hand summons, my lord.
ಇದ್ರಲ್ಲೂ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡ್ಬಿಡಿ ಎಲ್ಲ. ಅದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದ ಆರ್ಡರ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ಇದೆಯಾ?
ಇದೆ ಸರ್.
ಎಸ್, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ ಎಲ್ಲ. ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ serial number 57.
My lord, list
ಕೊಡಿ ಎಲ್ಲ. ಏನದು?
Any day in the next week, my lord, may kindly.
We'll post it on
first week of December.
We'll post it on 3rd, 4th December.
Please.
By then you serve everybody by way of hand summons. We'll close it on that day.
Please.
Yes. I'll not wait. We'll close this.
Please.
Impugned order placing the petitioner under suspension solely on the ground of report of the Lokayukta is under challenge, your lordships.
ನಾನು ಜಡ್ಮೆಂಟ್ ಕೊಡಿ.
Please, your lordship. ಎರಡಿದ್ದಾವೆ, your lordships.
ಬಸವರಾಜ್, ಇನ್ನೊಂದು ಯಾವ್ದು?
ಇನ್ನೊಂದು
Earlier judgment first.
ಇದಕ್ಕೆ ಮುಂಚೆ ಬರ್ದಿದ್ನ
23.
Chinchorkar.
ಇದು
ಲಾಸ್ಟ್ ಅಲ್ಲಿ
ಅಲ್ಲ, ಇದು 48 hours ದೇನಾ?
ಅಲ್ಲ, he was not under deemed substantial, solely on the report of Lokayukta. Please.
But this is squarely on 48
Please,
hours.
please.
The petitioner is before this court calling in question an order of suspension which according to the learned counsel by the petitioner is passed on solely on the dictates of the Lokayukta. In that light, the Lokayukta, he would seek to place reliance upon so and so. In that case, the order of suspension will remain stayed. The learned HCGP is directed to accept.
Phone number 123.
All the respondents, for the respondents, list the matter on 3rd December.
Oblige, your lordship.
Madam, close Marbana. Yes.
Number 17, Venkatesh Talwai.
I appear for petitioner. My lord, this is a restraint order passed against a plaintiff, my lords. Initially, order was passed in Vijapura. It was confirmed in SLP, my lords. Annexure B is the order of SLP. My lords, page 29.
Team order the.
Yeah, Allah, where are you?
Mugudum, sir. Copy is not, sir.
Page 29, your lordship would kindly turn to the order of the apex court.
I request it tomorrow, my lord.
In page 29.
We'll take it, we'll take it.
My lord,
ನೋಡಿದ ತಕ್ಷಣ.
My lord, the apex court categorically says that Vijapur order cannot be the made basis. Now please come to the impugned order at page 31, annexure C.
1 minute, sir. It is also clear that the impugned order passed on 15/25, the Deputy Commissioner Vijapur would not form a basis for externment of the petitioner
From any other
district.
Yes.
ಬೇರೆ district ಮಾಡಿದಾರಾ ಈಗ?
My lord, Dharwad, they have done it, and the representation my colleague would hand over. They make a statement based on the High Court order and the Apex Court order. May I request my lords kindly take the representation which is referred in the annexure C.
ಈಗ externment order ಎಲ್ಲಿದೆ?
Annexure C, my lords, page 31.
This is prohibitory order or externment order?
External, not to enter. Not to enter. My lord, the grievance was that till 7th of November, my lord, there are functions I should not participate.
All right.
No, my lord, without recording reasons, I have been prohibited till January, 3rd of January 2026.
All right.
There are no reasons forthcoming, and my lord, so the doctrine of proportionality will have to be applied. If the grievance itself is to end on 7th.
Where is the impugned order now?
My lords, annexure C, my lords, page 32.
31.
31 it starts. Operative portion 32.
ಆದೇಶ ಧಾರವಾಡ ಜಿಲ್ಲೆ ಆದ ಸೋಣಿಸು
ಜಿಲ್ಲೆಗೆ ಪ್ರವೇಶಿಸಿದಂತೆ
ಸಿದ್ದೇಶ್ವರ ಮಠದ ಸ್ವಾಮೀಜಿ ಕಿನ್ನರಿ ಮಠ ಸ್ವಾಮೀಜಿ ಗ್ರಾಮ ಸೋಣಿಸು ಧಾರವಾಡ ಜಿಲ್ಲೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಶಾಂತಿ ಧಕ್ಕೆ ಉಂಟಾಗದ ಮುಂಜಾಗ್ರತಾ prohibitory order.
Prohibitory order till 3rd of January. The request itself is 7th November.
January 2026.
Yes. Now please come to that same page on the above paragraph. The representation is between 511 to 711. One, there is a doctrine of proportionality is violated. Second, the apex court specifically says that don't make it a basis. Now the representation, please see the representation notes my colleague is going to hand over there, which is referred in the impugned order.
ತುರ್ತು ಕ್ರಮಕ್ಕಾಗಿ ಮನವಿ.
ಮನವಿ. My lords, Jagadika Lingayat Mahasabha registered Bangalore, and they quote the previous order of Vijapura and High Court order and the Apex Court order.
This is to stop you from entry, is it?
Yes, and the Apex Court says don't make it a basis for passing the new order in any other district. And their grievance itself is ended on 7th of November. Where is the question of my lords holding me out till January 2026?
Tomorrow. Please. Tomorrow we'll take it at 10:30.
Yes, ma'am. Grateful.
But Dalwai sir.
Yes, ma'am.
There is the order of the coordinate bench.
True, my lord, accepted. Lord, I have produced that annexure A and
Produce it.
annexure B.
I'm not saying you've not produced it. You produced it, but you will have to wriggle out of it. Yes.
Yes, my lord, I bank upon the order of the Honorable Apex Court, which said don't make it a basis. Yes, grateful. Man.
Tomorrow, ಇದು ನಾಳೆ ಹಾಕ್ತೀನಿ. File ಕಳ್ಸಿ. ಹಂಗಾದ್ರೆ ನಾಳೆ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಏನಂತ. ಆಮೇಲೆ ನಾಳೆ ಟೈಮ್ ಕೇಳಬೇಡಿ.
Number 4.
ಅವಿನಾಶ್ ಎಲ್ಲಿ ಸೇಮ್ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅದು. ಎಸ್ ಇನ್ನು ಎಷ್ಟು ಲಿಸ್ಟ್ ಇದೆ? ಎಸ್ 21.
Number 55. Ranjita.
ಇದು ಆಯ್ತಲ್ಲ ಈಗ?
Dictation.
ಇಲ್ಲ ಇಲ್ಲ ಎಸ್
Two judgments, your lordship, wherein your lordship merely pending, based on the one pending case, the rowdy sheet register has been opened.
BS Prakash case it's covers.
ನಾಳೆ ಮಾಡುವ. Day after tomorrow, fresh matters.
Please.
Yes.
56 Girish V. Bhatt.
Regarding appointment Anganwadi helper, some of my lords direct me to serve the hand summons. I had approached. They have rejected it and I have filed the affidavit.
Your lordship, interim order has been granted on 28/10, your lordship. Order was already, final order has been passed on 8/10/25 and appointment letter was also issued before granting interim order, your lordship.
This court on 28.
In fact, my lords.
Madam, this court on 28/10/2025 had passed the following order. The learned HCGP submits on instructions that by the time the interim order could be granted, the fifth respondent was already appointed by way of an appointment order that was issued on 8/10/2025.
17/10/20.
17/10/2025 and she has reported duties on.
She has not reported as per my instruction, my lords. On last
I will
Thursday.
I will verify, lordship, whether she
Agile
has-
ಅದಕ್ಕೆ I have to-
In the event the fifth respondent has reported to duties, the appointment shall be subject to the result of the petition. In the event the fifth respondent has not reported to duties, there shall be an interim order of not permitting her to report to duties till the next date of hearing. List the matter on 1st December.
Lordship, actually, she has not enclosed the documents which are needed, your lordship.
On that day we'll see.
Please, your lordship.
Yes, please. Next. 57 to 87, same.
64 is serial number 64. Santosh Nargun.
Oh, Madam, your lordship. Annexure A is the representation.
Many writ appeals are pending before the principal bench, my lord.
Any writ appeals?
No. Main petition is on 6001 of 2020, my lord.
ಏನು? Serial number 64,
Yes.
You are Gopal Patil.
Respondent.
Yes, sir. What is the issue?
Annexure D is the representation.
Representation la issue ಏನು ಹೇಳಿ sir?
Issue, your lordship, earlier the petitioners have filed writ petition before this honorable court.
That is not the issue.
No,
Issue ಏನು ಹೇಳಿ?
I'm telling the facts, your lordship. Lordship, in view of the judgment of this honorable court, the petitioner has not considered the
ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ.
No, they have not considered the representation of the seniority list. Seniority list, they have not been considered, and the pay scale has not been given. On that basis, that is the issue, your lordship. We have made a representation. Annexure D is the representation.
List the matter on 10 December. Yes. Next.
Serial number 66. Devakem Photo Sheeter.
Oh, ಇದು ಯಾವುದು? That
Wherein, my lord, the co-opting.
Appeared for the
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಿದಿರಲ್ಲ?
Please, my lord. Only thing is, my lord,
they pleaded an urgency saying a delegate is to be sent to KMF Therefore, I had suggested, allow me to, as a president, I am entitled to call the meeting and take up the subject of delegation. Subject to result of the petition, we are ready to do that. If they have objection for that, then matter is requires to be heard.
No, I'll pass an order on merits itself. It's not, let's not,
Only one.
let's
Then,
not
my
do
lord,
this.
your lordship may kindly have it tomorrow or day after
Nale,
tomorrow.
nale.
I require about 10-15 minutes time, my lord.
Tomorrow we'll have it at 2:30.
Secure their presence and
Just
affidavit.
2:30,
Lords,
remind
the
me.
officers were directed to be present, file affidavit that this exercise
No,
was
I've
undertaken.
not directed anything like that. We'll do it tomorrow. Yes,
Very well.
tomorrow at 2:30.
Please, my lords.
ಇರ್ಲಿ, ನಾಳೆ 2:30. Next.
Till the 75. Ganesh Vishwanath.
My lord, this is GST recovery matter. Recovery done during the course of investigation pursuant to inspection and search. This is clearly covered by my lord's judgment, which was passed last week only.
DRC 3.
Yeah, DRC 3 payment. 74, section 74, subsection 5 talks about voluntary payment. This payment
is a voluntary payment in form DRC 03.
Yes,
where you make at the time of search, even if it is voluntary payment, you are entitled for a refund is
Yes,
what
ma'am.
I have held.
That's the issue.
Ade issue na.
Gunnam Infra, that's the.
Notice ಮಾಡುವ. Learned AGA is directed to accept notice 1, 2, 3, ಎಲ್ಲರಿಗೂ. ಎಲ್ಲ ಸ್ಟೇಟಾ?
Yes, ma'am.
Learned is directed to accept notice for all the respondents. Covered ಮದ್ ನೋಡಿ ಅವ್ರ ಕಾಪಿ ಕೊಡಿ.
It's already served to them, soft copy. I will give one more.
Hard copy ಕೊಡಿ sir.
Yes, ma'am.
Yes. List on 2nd December.
There is little urgency, my lords. If it
2nd December ಗಿಂತ ಮುಂಚೆ urgency ಇದೆಯಾ? List on 9th December. Yes.
My lords, 2nd December should be fine.
Yes. Next.
87. Girish Vikat.
Regarding minimum wage difference amount of library supervisor yesterday.
Minimum wages though. ಎಷ್ಟು ಬರ್ಬೇಕಾಗಿರೋದು?
19,400. 19,400.
Per person.
ಇದು ಎಲ್ಲ ನೆನ್ನೆ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದಲ್ಲ. ಓ ಇದು ಎಸ್ಟರ್ಡೇಸ್ ಮ್ಯಾಟರ್.
Please.
ಕಾಸ್ಟ್ ಎಷ್ಟು ಅಂತ ತೀರ್ಮಾನ ಮಾಡಿಲ್ಲ. ಒಂದು ನಿಮಿಷ. 19,000 ಬರ್ಬೇಕಾ?
19,400 rupees.
ಒಂದು 50,000 ಹಾಕೊಟ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ.
ಬರೋ ಅಮೌಂಟ್ ಬಂದು
If not paid. If not paid ಅಂತ ಹೇಳಿದ್ರೆ.
If not paid. No, if not paid. ಎಷ್ಟು ಸರಿ ಎಲ್ಲರನ್ನು ಕೋರ್ಟ್ಗೆ ಬರಂಗ್ ಮಾಡ್ತೀರಾ ನೀವು? ಸುಮ್ನೆ ಬೈ ಸ್ಟ್ರೋಕ್ ಆಫ್ ಪೆನ್ ಯು ಡು ಎವ್ರಿಥಿಂಗ್. ಘನಶ್ಯಾಮ್ ದಾಸ್ ಓ ಬಂತ ಸರಿ ಕೊಡಿ.
ಘನಶ್ಯಾಮ್ ದಾಸ್.
ಎಲ್ಲರನ್ನು ಕೋರ್ಟ್ಗೆ ಬರೋದ್ ಬೇಕಾಗಿಲ್ಲ ಅಂತ. ಬಟ್ ಇದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಇಶ್ಯೂ ಇದೆ. ಫೆನ್ಸ್ ಸಿಟರ್ ಶುಡ್ ನಾಟ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ಅಂತ. ವಿಲ್ ಡಿಸೈಡ್. ಅದನ್ನ ಅವ್ರು ಹೇಳಿಲ್ಲ ನೋಡಿ.
Please.
After tomorrow.
Please, your lordship.
Time will like. Yes.
Fresh matters.
Fresh.
Please.
Yes.
89. Venkatesham Karvi.
Slum. ಯಾಕೆ ಸುಸ್ತಾಗೋಗಿದ್ಯಾ?
No, my lord.
ಮತ್ತೆ
Commissioner 1 and 2.
ಸ್ಲೋ ಮೋಷನ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇದ್ದೀರಾ?
My lord, challenging. Challenging the, my lords. Writ of mandamus, my lords.
Challenging writ of mandamus.
Sorry. Seeking file of writ petition, seeking writ of mandamus. Here, whatever, my lords, the petitioners are directors of the multi-pride cooperative society. Multi-fried.
Multi-fry.
Fried, yes, ma'am. Fried multi-purpose Savarda Sahakari Bank.
ಯಾವ್ದು ಡೀಪ್ ಫ್ರೈಡ್ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಏನ್ ಮಲ್ಟಿ ಫ್ರೈಡ್?
Fried multi. Whatever, my lords, respond number 3 and 4 was the chairman and CEO.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಅದು ಯಾವ್ದು ಫ್ರೈ ನೋಡ್ಬಿಡ್ತೀನಿ.
Annexer, my lords, B, my lord, page number 15.
Federal Cooperative Society.
Federal, but name is Fried, my lords. ಹೌದು, ಫ್ರೈಡ್ ವಿವಿಧೋದ್ದೇಶಗಳ ಸೌಹಾರ್ದ ಸಹಕಾರಿ ಸಂಘ ಉಕ್ಕೇರಿ.
ನೇಮ್ ಎಲ್ಲಿದೆ ಸೊಸೈಟಿ ಇದೆ?
Annexer B, my lords. Page number 15, my lord.
ಫ್ರೈಡ್ ಅಂತಾನೆ ಇದೆ.
Fried.
ಯಾವ ಫ್ರೈಡ್
Pride
ಶಾಲೋನ
ನಿರ್ದೋಷಗಳ ಸಹಕಾರಿ. ERI.
ಏನಾಗ್ಬೇಕು ಈಗ?
So whatever my lords, respond number 3 and 4 are chairman and respond propose the CEO or that. And they are the appropriate, they are involved in the my lord misappropriation fund of the society.
ಓ ನೀವ್ ಯಾರು?
That is, we are also vice chairman, my lords.
You are not involved.
Yes, as per the my lord, no, we are not involved. As per the report given by the my lords, that is respond number 2. That is a director, deputy director of the my lords. They have given inspection report on annex D, my lords. There is a misappropriation fund amount to my lord, that is at found in my lords 1 lakh, 1 crores, my 30 lakhs. My lords.
1 crore, 1 lakh?
Yes, 1 crore 30 lakhs.
1 crore 30 lakhs.
And in page number 18, my lord, annex D, my lords, kindly found the inspection report given by the respond number 2. What happened, my lords, against that, my lords, they have filed, my lords, a consumer complaint against these directors, my lords. And recovery proceeding is, my lords, going on against and the consumer forum is taking a course steps against these petitioners, my lords. Till, my lords, my request, my submission is, my lords, the respond number 1 and 2, my lords.
Consumer forum ಹೆಂಗ್ ಹೋದ್ರು?
For depositors, my lord, they have maturity amount, they are claiming recovery proceedings against these directors.
You take notice.
Yes.
ಯಾರಿಗೆ?
For
Respond number 1, 2 is the
1 AGA.
Yes, my lords.
2 to 5 hand summons serve ಮಾಡ್ತೀರಾ?
Please, my lords.
Be served by way of hand summons and an acknowledgement of such service be filed by the next date of hearing. List the matter on 2nd December.
Annex the F and G, my lords.
1 minute. List the matter on 2nd of December in the fresh matters list. Till such time, the proceedings proceedings of execution before the Consumer Disputes Redressal Forum, Belagavi, shall remain stayed.
Please.
Number 90, Sunil Desai.
Omitted to withdraw, my lord, doesn't.
Thank you, sir. Yes. Learned counsel of the petitioner submits, seeks to withdraw the subject petition.
I may direct take notes 1 to 4.
Withdraw ಆದ್ಮೇಲ?
Government.
ಅಷ್ಟೇ ಬರ್ಕೊಂಬಿಡಿ. Learned AGA is directed to accept notice, he is permitted to withdraw. Yes.
91, Lakshman T. Mantagani.
CH mood. ಏನ್ ಮೇಡಮ್ ಎಲ್ಲ ಪೇಜ್ಗೂ ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀರಾ? Learned AGA is directed to accept notice for all the respondents. List the matter on 3rd. Khata change ಮಾಡಕ್ಕೆ. List the matter on 3rd December in the fresh matters list. Next.
92, Chetan Manoli.
By way of annexure A, page number 20, I have been directed to pay deficit stamp duty and penalty at rupees 16,50,000 on a document at annexure C, memorandum of understanding.
45 proceedings ಮಾಡಿದಾರಾ?
I'm sorry, my lords.
Proceedings under the Stamp Act are initiated?
ಇಲ್ಲ, at the instance of the court.
Instance of the court?
Yes, my lords. At the instance of the court, registrar has.
So what is to be done?
My lords, memorandum of understanding whereby it was agreed that, my lords, property will be purchased in the name of another person.
That would not attract stamp duty.
Yes, my lords. Because pursuant to which property has been purchased at annexure D.
AGA is directed to accept notice for the
Sole
for the respondent. Copy ಇದೆಯಲ್ಲ? List the matter on 26th in fresh matters. Let me see. Yes.
My lords, in the meanwhile, my lords, he is issuing notice for recovery of stamp duty. This as per this, my lords.
They responded, list the matter on 7th, 9th December. The respondent shall not precipitate the matter till the next date. Yes.
In the fresh matters.
Yes.
93, Karthik Ganachari.
Demand notice issued by.
148.
No, madam.
Then, ಇದು GST na?
ಅಲ್ಲ, VAT.
Bank.
Value added tax. The authorities have reassessed the value added tax for the.
AGA is tax ಯಾರ ಪೇರ? ನೀವೇನಾ? Then AGA is directed to accept notice for the respondent. Reassessment.
Reassessment for the year 12-13, my lord. And they have issued demand notice in the year
Further proceedings, yeah, 2018-19, ಇವಾಗ ಎಲ್ಲಿ ಸ್ಟೇಕ್ ಹೇಳ್ತೀರಿ? Yes.
ಅಲ್ಲ, they have filed the criminal miscellaneous petition, my lord, for the recovery, but petitioner doesn't have any legal knowledge.
Legal knowledge?
Legal knowledge ಏನಿಲ್ಲ ಅವ್ರಿಗೆ.
Illegal
He's a
knowledge.
contractor, he was a contractor.
Anyway, look into it. List the matter on 26th in fresh matters list. Yes. Next.
94, Nada.
ಎಲ್ಲಿ honor killing?
Janam se saath.
Janam se pyar.
Yes.
Oh. ಗೊತ್ತಾಯ್ತಲ್ಲ ಇದೇನು ಅಂತ? He says he is in love with the man since birth.
As missing complaint is
Janam
filed.
se pyar.
And in that case only they are, my lords, investigating the case.
ಯಾವುದು?
Missing complaint as filed by the father of first petitioner.
Oh, you already married,
Not yet married.
Not yet married.
About to marry. On
About to
21st.
marry?
21st marriage is intended to be. And in that, let my lords, I had sought for a precipitate, not to precipitate, because
That's the allegations is that police are threatening them. I have taken an instruction, but they are not giving any threat to the, my lords, the petitioners. Moreover, my lords, the father of the first petitioner, girl, has filed a missing complaint. And in that case, they are, my lords, investigating the case. These are the
ಏನ್ girl is a minor, ಇಲ್ಲಲ್ಲ?
no.
major. Major ಇದ್ದಾರೆ.
What's the investigation you have conducted in the missing complaint?
Missing complaint, my lords, whereabouts are not known.
Why? Different religion?
Yes, sir.
ಅದಕ್ಕೆ problem.
And their allegation is police are threatening them. Absolutely, they are not threatening, my lords. They have earlier they filed a writ petition.
How did you know her Janam se?
Neighbors only.
Neighbors.
Studied together, qualified, graduation also together, worked also together.
You want to stay also together now?
Yes, sir.
Yes. Yes, sir.
Yes.
Law does not permit.
Absolutely, my lords, police are not coming in the middle.
Why police will not come?
Yes, sir.
ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು.
ನಾವು ಆರ್ಡರ್ ಕೊಟ್ಟರೆ ನಾವು
ನಾನೇ ಆರ್ಡರ್ ಕೊಡ್ಲಿ?
Because
ಆಮೇಲೆ ಕೋರ್ಟ್ ಹೇಳಿದ್ದಾರೆ ಅನ್ಬಿಟ್ಟು.
the reason I have come before this lordship is they are doing some act. Otherwise, I would have never come here.
Let me see what's the complaint. Tomorrow I'll pass orders.
Please, sir.
ನಾಳೆ 2:30 ಹಾಕಿ. ಅಲ್ಲಿ ಆಗುತ್ತೆ ನೋಡಿ. ಇಲ್ಲ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 21st ಅಲ್ಲ?
21st ಗೆ ಇದೆ ಸರ್.
ಯಾವತ್ತಿರೋದು? 21st ಯಾವತ್ತು?
ಫ್ರೈಡೇ ಇದೆ ಸರ್.
ಫ್ರೈಡೇ. ಸರಿ, ಟುಮಾರೋ ಹಾಕಿ.
ಪ್ಲೀಸ್.
ಎಲ್ಲಿ ಇನ್ವಿಟೇಷನ್ ಎಲ್ಲಿದೆ?
ತಾವು ಆರ್ಡರ್ ಕೊಟ್ಮೇಲೆ ನಾನು ಪ್ರಿಂಟ್ ತಗೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀನಿ ಸರ್.
ಇನ್ನೇನು ಅಲ್ಲ, ಇನ್ನೇನಕ್ಕೂ ಆರ್ಡರ್ ಕೇಳಬೇಡಿ ಸರ್.
ಎಸ್.
Order of a suspension. Lord, he is the assistant executive engineer of environment. The banner has been removed in a Sangam circle, which is, my lord, admittedly.
banner?
ವಾಲ್ಮೀಕಿ ಮಹರ್ಷಿದು ಬ್ಯಾನರ್ ಹಾಕಿದ್ದಾರೆ, ರಿಫ್ಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳಿ. ದಿ ಏರಿಯಾ ಈಸ್ ಪ್ರೊಹಿಬಿಟೆಡ್ ಬೈ ದಿ ಲಾರ್ಡ್ ದಿ ಕಾರ್ಪೊರೇಷನ್ ಇಟ್ ಸೆಲ್ಫ್, ಪೇಜ್ ನಂಬರ್ 29. And the commissioner writes it humiliates the government. The action of the removing is the area which is already banned. In fact, there is no.
Where is the prohibitory?
My lord, page number 29, my lord, the resolution of the corporation. Subject number 323. And the circle serial number 4.
ವಿವರಿಸಿದ ಒಂದು ನಿಮಿಷ. ಕಚೇರಿ ಟಿಪ್ಪಣಿಯಲ್ಲಿ ವಿವರಿಸಿದ ನಗರದ ಪ್ರಮುಖ ವೃತ್ತ ಮತ್ತು ರಸ್ತೆಗಳಲ್ಲಿ ಬ್ಯಾನರ್ ಆಟಿಂಗ್, ಕಟೌಟ್, ಜಾಹೀರಾತುಗಳನ್ನು ಅಳವಡಿಸುವುದಕ್ಕೆ ನಿಷೇಧಿಸಲು ಸಭೆಯ ತೀರ್ಮಾನ.
Yes, 323, my lord, serial number 4, my lord, may kindly see.
ಅದನ್ನೇ ಓದಿದ್ದು.
ಅಲ್ಲ.
serial number 4 ಯಾವುದು?
ಸಂಗಮ್ ಸರ್ಕಲ್.
ಎಲ್ಲಿದೆ ಅದು?
Next page. Lords, 29.
30?
29, Lords.
I am at 29.
ನಿಷೇಧಿಸ ಸ್ಥಳಗಳ ವಿವರ ಅಂತ.
ನಿಷೇಧಿಸ ಸ್ಥಳಗಳ ವಿವರ.
ಸಂಗಮ್ ಸರ್ಕಲ್.
serial number
4. Now the order is removal is in Sangam circle.
ಜಾಹೀರಾತುಗಳನ್ನು ಅಂತೀನಿ.
The banner is of the corporator's husband. That is that.
ಅದಕ್ಕ ಇದು. ಅಲ್ಲ, ನೀವು ಅವ್ರ ಬ್ಯಾನರೇ ತೆಗೆದುಬಿಟ್ರೆ.
ಅಲ್ಲ ನಾನ್ ತೆಗ್ದಿಂತಲ್ಲ, ಸ್ಟಾಫ್ ತೆಗ್ದಿದ್ದಾರೆ. But it is prohibited, my lord, even it can't be done.
Who is complainant yaru, corporator?
No, they have made a hesitation. That is why, my lord,
Who has
the,
made agitation?
the workers of the, my lord, corporator, the followers of the corporator,
Oh, ಏನು ತೆಗಿಬಾರ್ದಾಗಿತ್ತು.
ತೆಗಿಬಾರ್ದಾಗಿತ್ತು.
ಅದಕ್ಕೆ ನೀವೊಂದು ಸಸ್ಪೆನ್ಷನ್.
Suspension.
ಯಾರು ಮೇಡಮ್ ಇಟ್ಟಿರೋದು?
ಜಾಹೀರಾತು. Respond number 3, your lordship.
3
The order ಮಾಡಿದವರು first respondent. Recommendation unfortunately by the commissioner who himself is a party to the resolution.
Your lordship, what resolution says ಜಾಹೀರಾತುಗಳನ್ನು ಅಳವಡಿಸುವುದು ನಿಷೇಧಿಸಲಾಗಿರುತ್ತದೆ. ಇದು ಜಾಹೀರಾತು ಅಲ್ಲ.
ಇದೇನ್ ಮತ್ತೆ?
ವಾಲ್ಮೀಕಿ ಜಯಂತಿ ಆಚರಣೆಯಲ್ಲಿ ಆಚರಣೆ ಪೂರ್ವದಲ್ಲಿ ವಾಲ್ಮೀಕಿ ಅವರದು ಬ್ಯಾನರ್ ಹಾಕಿದ್ದಾರೆ.
All the banners, my lord, all kind of banners. Which falls under Open Place Prevention of Disfigurement Act, my lord. They kindly see the order, government order dated page number 20, my lord, 11/3 to 2016. Even I need not, my lord, seek a permission of the commissioner because I am also one of the authority who has to implement.
Please, your lordship, I'll take notice for respond number 1
Don't threaten officers by suspension for doing their duty just because it is a corporator's image that has come down.
Your lordship.
When will you stop catering to the sentiments of these people by troubling the officers like this?
Because it is a sentiment of society also, your lordship.
Society.
Valmiki Jayanti ಪ್ರಯುಕ್ತ ಅದನ್ನ
Madam, we
ಹಾಕಿದ್ದಾರೆ.
live in a society civilized. There should be law and order. We are accountable and responsible. Where is the accountability or responsibility? ಏನ್ ಬೇಕಾದ್ ಮಾಡ್ಬೋದು. If he has committed any misconduct, you tell me, what's the misconduct? That he has cleansed the area by following the law. That's why you place him under suspension? Yes. The petitioner is before this court calling in question an order of suspension. The petitioner is working as, next transfer ಮಾಡ್ತಾರೆ ನಿಮ್ನ. ಆದ ತಕ್ಷಣ ರೆಡಿ ಆಗಿರಿ. Yes, the petitioner is working as an assistant executive engineer in Ballari City Corporation. He is placed under suspension for the reason that he has removed the banners that were placed in a circle, hyphen, Sangam circle. The banner is said to be that of the corporator of the area.
So the husband of the corporator.
Husband of the corporator of the area. The learned counsel Sunil Desai submits that the resolution of the Ballari Municipal Corporation is that resolution reads as follows.
Page number 28, my lord, 28, 29.
Vishaya Sankhya 323 na?
323.
So and so. The resolution of the corporation is that no banner, cutout or any kind of advertisement or anything must be displayed in Sangam circle, which would be in violation of Karnataka Open Places within bracket Prevention of Disfigurement Act 1981. The petitioner or the officers of the corporation have removed the banners that were on the Sangam circle on the score that it is a prohibited area, merely because it is the banner of the husband of a corporator has led an officer who has performed his duty in accordance with law to be penalized, to be placed under suspension. This cannot but be termed to be gross abuse of the power that is vested in the commissioner to place someone under suspension. The learned counsel for the petitioner would now submit that the commissioner who has now passed an order of suspension.
The secretary has passed an order on the recommendation of the commissioner.
The commissioner who recommended the petitioner to be placed under suspension is a party to the resolution quoted here and above. In that light, holding the suspension to be on the face of it mala fide and abuse of power, there shall be an interim order of stay of the said order of suspension.
Respond number 3, notice, my lord.
Learned AGA 1 and 2, 3.
notice I will take hands.
ಪ್ಯಾನಲ್ ಇಲ್ವಾ? ಬಳ್ಳಾರಿ ಸಿಟಿ ಕಾರ್ಪೊರೇಷನ್ ಇದಾರಲ್ಲ ನೋಡಿ. Yes, so and so accepts notice for the third respondent. Petitioner to serve set of papers upon the aforesaid council. List the matter on 2nd December in fresh matters list. Objections, if any, by the respondents by then. Yes, next.
97, Sunil Desai.
The application for regularization, unauthorized regularization has been filed. Lord, I'm only seeking consideration of that. Lord.
ಏನಿದು ಹೆವಿ ಮ್ಯಾಟ್ರಾ?
Lord,
ಹೆವಿ ಮ್ಯಾಟ್ರಾ?
petitioners ಬಾಳ ಇದ್ದಾರೆ, application ಜಾಸ್ತಿ ಇದೆ ಅದಕ್ಕೆ. Lord, in a similar circumstances, when the applications were pending, this honorable court, my lord, has directed them to consider the applications under 94A. Para number 6, my lord.
ನೋಡಿದೀರಾ?
Tomorrow.
ನಾಡಿದ್ದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ತಗೊಂತೀವಿ ಟಾಪಿಕ್. Current AGA is directed to accept notice for the respondents list day after tomorrow in the fresh matters list.
Please.
Or on Friday, ಇಲ್ಲ day after tomorrow. Yes.
Please.
98, Vishwanath Hegde.
Please, my lord, petitioner is a contractor, my lord, engaged in solid waste management, my lord. Similar.
Paling Bella.
Solid waste management.
Solid.
Similar matter, my lord, stated by this.
Same order. ಯಾರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
98, 99.
98, 99 ಎರಡು ಅದೇನಾ? ಇದ್ಯಾಕೆ ಇಲ್ಲಿ ಬಂದಿದೆ? LB, oh, disabled.
GA for R1, my lord. 2 to 4 ಇರನ್ಗೌಡ ಕಬ್ಬೂರ್.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? ಅದ್ರಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇರನ್ಗೌಡ ಕಬ್ಬೂರಿಗೆ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಆಯ್ತು, ಈಗ ಯಾರ್ಯಾರು ಹೇಳ್ಬಿಡಿ ಈಗ. 98 ಅಲ್ಲಿ ಯಾರಿಗೆ?
R1 GA.
R1 AGA. ಆಮೇಲೆ
ಉಳಿದವರಿಗೆ ಈರನ್ಗೌಡ ಕಬ್ಬೂರ್.
ಹಾ, ಮಿಕ್ಕವ್ರಿಗೆ ಈರನ್ಗೌಡ ಕಬ್ಬೂರ್. 99 ಅಲ್ಲೂ ಸೇಮಾ?
ಹೌದು, ಸೇಮ್.
Yes. Same order, entry order in there. ಸಾಕು ಅನ್ಸುತ್ತೆ. We'll continue. 6 o'clock.
One matter in list number 4.
ಒಂದು ನಿಮಿಷ. DD.
My lords, money has been transferred.
ಯಾರದು?
Anil Kale sir, my lords.
ಮನಿ ಬಂದಿದ್ಯಾ?
My lord, by Friday we'll deposit the amount. Friday, my lord. That is
ನಿಮ್ದಲ್ಲ ಸರ್. ನೀವು petitioner ಯಾರು ನಿಮ್ದ್ರಲ್ಲಿ?
My lords, Anil Kale sir, my lords, appears for the petition.
Where is Anil Kale? ಏನ್ ಬಂದಿದ್ಯಾ ಮನಿ?
ಬಂದೆ.
ಬಂದಿರ್ಬೇಕು ನೋಡ್ರಿ.
Lords, this is, my lords, we have sent it through RTGS. Check is also, my lords, to the account. ಕೊಟ್ಟಿದ್ದೀವಿ, we have already served. ಅಲ್ಲ, ನೋಡಿ, ಈಗ ಕಳಿಸಿದ್ದು.
ಬಂದೈತಿಲ್ರಿ?
I received WhatsApp message of his account status. He has been to bank, waiting there. 3,700.
RTGS. Yes.
RTGS, but late agate 1 hour. Morning he came to the bank, my lords, gave details of his bank account, my lord. To that we have already done the RTGS. We have, lords, it may take some time for transfer, but
RTGS ಬಂದಿರುತ್ತೆ.
Lords, now, my lords,
We'll take it on Monday.
Lords, the problem is this, lords, by 20th of November, lords, the 1 year period of suspension that we had extended, my lords, will expire. After that, my lords, there is no provision in the bylaws, my lords, to extend that. Now, my lords, by way of right, my lords, he'll come and sit as a CEO. He has misappropriated more than 6.5 crores, my lords.
Pass necessary orders. List on Friday in fresh matters list. ಅಥವಾ ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ, Thursday. Yes. List on Thursday. Excellence ಬಂದಿದ್ಯಾ? That you will see.
List number 4.
He may have misappropriated hundreds, but subsistence allowance you can't.
That, my lords, I assure, my lords, that we have paid.
ಒಂದು ನಿಮಿಷ, ಈಗ 1 minute. I'll just call the cases page wise. ಚಾಕ್ಲಬ್ಬಿ
Please.
ಇದೇನ್ ಸೇಮ್ ಅಲ್ವಾ?
No, my lord, it is different one.
The impugned order in page number, my lord, SLO has directed to pass the order on section 28A, my lord. Directed to release the amount, my lord.
Reduce the amount.
Release the amount.
Release the.
Section 20, under section 28A is not permissible, my lord. So civil suit is pending. We have filed the application before the same SLO, my lord, to transfer the amount to the civil court, my lord. So even he has passed the disbursed amount. Tomorrow is fixed for disbursement.
ನಾಳೆವರೆಗೆ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್? SLO Seabird Naval Base.
Please, madam. Karwar.
Yeah, Government of India na idu.
Government of India.
Government of India.
Please,
yeah, who appears?
Venkatesh Karvi.
Karvi, idara. Learned Counsel Venkatesh Karvi is directed to accept notice for the second respondent, one AGA. The remaining, ನಾಳೆ ಬೇರೆಯವ್ರಿಗೆ ಆಮೇಲೆ ನೋಡೋಣ. List the matter day after tomorrow in the fresh matters list. The amount shall not be dispersed till the next date.
By hand, my lord, tomorrow is fixed for.
ಯಾವ ಹ್ಯಾಂಡ್ ಇಷ್ಟೊತ್ತಲ್ಲ?
Morning ಕೊಟ್ರು ಸರ್. Morning ಕೊಟ್ರು ಸರ್.
ಮಾರ್ನಿಂಗ್
Please. Upload ಮಾಡಿದ ಸರ್.
ಅದು ಈಗ
My lord, tomorrow 10:30 he is.
ನೀವು 6 ಗಂಟೆವರೆಗೆ ಇದ್ಬಿಟ್ಟು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕು ಸಿಗ್ನೇಚರ್ ಅಂದ್ರೆ ಹಿಂಗೆ. ಏನ್ ಮಾಡ್ಬಿದ್ದು ಮತ್ತೆ? ಯಾಕೆ 72 ಮ್ಯಾಟರ್ಸ್ ತಗೊಂಡು ಮೆಮೋ ಸರಿ ಸೇವ್ ಮಾಡಿ ನೋಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್. Passed over.
My lord, since serial number 10.
Hi, my lord.
VC, please wait.
Please.
ಆಫೀಸ್ಲಿ ಇದ್ದೀರಾ ನೀವಿರಿ. ನಾವು 100 ಇಂದ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಸಿ ಪೇಜ್ ವೈಸ್ ಕರೀರಿ.
Page number 21, serial number 100. 101 to 111.
Serial number 101.
Serial number 50.
Have it tomorrow, my lord.
Why?
It's a simple mandamus, my lord.
ಎಲ್ಲ ಗಾಯತ್ರಿ ಮೇಡಮ್
Pass over matter.
ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ ಅದು.
In the serial number.
ಒಂದು ನಿಮಿಷ 101 ಎಲ್ಲ ವಿಲ್ ಅಸೈನ್ ಡೇಟ್ ಅದು ಬಂದು ತಗೊಳ್ಳಿ. ಯಾವ್ದು ಕಮ್ಮಿ ಇದೆ?
Sir, ಒಬ್ಬಂಗ ಕುಡಿಯಾಗ
27th, 28th. 27th and 28th 2 ದಿನಾನು all the matters that have not reached will come on 27th and 28th unless there is grave urgency. Please tell grave urgency.
This matter was yesterday allowed, one it faceless
allowed.
ಅದು ತಿರುಮಲೇಶ್ ಬಂದು he clarified something. Faceless suspend income tax.
ಅದು ಫೇಸ್ಲೆಸ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ನಿನ್ನೆ.
ಫೇಸ್ಲೆಸ್ ಅಲ್ವಾ ಅದು?
ಅಲ್ಲ ಅದು ಯಾಕೆಂದ್ರೆ 148 ನೋಟಿಸ್ ವಾಸ್ ಇಶ್ಯೂಡ್ ಬಿಫೋರ್ 29
ದಟ್ ಅದನ್ನ ರಿಮಾಂಡ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. ಅದು 27th ಬರ್ಲಿ ಅವತ್ತು ಮಾಡೋಣ. ಈಗ ಒಂದೊಂದೇ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ತೊಂದರೆ ಆಗಲ್ಲ. All matters will come on 27th and 28th.
One request for 120. Let it be in fresh matters, my lord, because
27th and 28th.
Covered by division
disqualification matter.
Finally ಅಂತ ಬಂದಿತ್ತು. Short issue is
9 ಗಂಟೆ ಕೂತ್ಕೋಬೇಕಷ್ಟೇ.
I'm only requesting for fresh matters ಅವತ್ತು any date.
Fresh matters ಜಾಸ್ತಿ ಆಗೇನೆ ಬೇರೆ
197 20
be there. I'll take up
27th ಗೆ
26th ಇಲ್ಲ 27, 28.
Lord,
26th again.
Serial number 166.
Only 26, 27, 28 ಕಮ್ಮಿ ಇದೆ. I will post.
27 Lord 197 matter pertaining to disqualification. May I request it in the fresh matter 27th Lord.
Disqualification.
There is
Serial number 27.
197. Disqualification Lord, this is.
ಅಲ್ಲೇ ಇರ್ಲಿ ಅವತ್ತು ಮೆನ್ಷನ್ ಮಾಡಿ.
ಅಲ್ಲ 27th.
Take it at 2:30 on that day.
Please.
Serial number 166.
ಅದು ಅಷ್ಟೇ. What ಅಭಿನಯ್ ಮೇಡಮ್ ಏನಿದು?
I filed an application for vacating of stay. It's a matter of arbitration, your lordship. Arbitration proceedings have been stayed since January of this year.
27th and 28th will post all vacating stay in the beginning.
Your lordship.
Serial number
207.
Matter ಆದ ತಕ್ಷಣ vacating stay ಹಾಕಿ ಆಮೇಲೆ plenary.
Serial 10 pass over ಆಗಿತ್ತು.
207 it has come in B group, my lords. Mandamus, one request, my lord, for respondents. Name of HR Gundappa is shown for R2 and R3. Sharmila Patil madam's name may kindly be shown because I am told she is instructed. 207, my lords.
Lord, serial
207. 207.
207. HR Gundappa ilva?
Illante. I have served copy on madam only.
To print the name of Sharmila Patil, Srimati Sharmila Patil in place of HR Gundappa. This damage award
This is my lord. 207 is mandamus. If it could be in preliminary hearing, my lord. Please.
Let be there. Please.
Principal bench, my lordship.
14 is damage award. Yes. Sunil Desai. ಇದು ಬ್ಯಾಂಗ್ಳೂರ್ ಸ್ವಲ್ಪ ಇದೆ ಇಲ್ಲಿ.
Yes, my lord.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದ್ವಲ್ಲ, ಅದರ್ ಮ್ಯಾಟರ್
213.
213.
13.
ಅದು ಇವತ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಡ್ಯಾಮೇಜ್ ಅವಾರ್ಡ್ ಯಾವ್ಯಾವ್ದು ಇದೆ ಅದೆಲ್ಲ ಲಿಸ್ಟ್ ಕೊಡಿ ಇಲ್ಲಿ.
This is connected
Madam,
with
ಅದೆಲ್ಲ
these
separate
matters.
ಹಾಕಿ ಲಿಸ್ಟ್ on Thursday.
So the petitioners may not in this.
Matters will be connected.
Respondent, my lordship.
213.
Principal bench matter, my lordship.
ಅದು ಗೊತ್ತು, ವೆಯ್ಟ್, ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಅವೇರ್ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅಲ್ಲಿ ಹಿಯರ್.
Serial number 184, my lord.
Item number 103.
184, my lord.
Item number 103. Item number 103, it was to 5th December.
Item number?
It causes one. Item number 103.
See, 27th, 28th, I will post everything. If you want any other date beyond that, you ask the court office.
My lord, serial number 50,
184,
my lord,
my
I'm
lord.
ready to deposit that 20 lakhs, my lord. That is,
Yes, sir.
yeah.
What happened?
Friday, my lord, I will deposit the amount. This Friday.
Respondent ಯಾರು ಇದ್ರಲ್ಲ?
Serial number 50.
Friday,
Yes, my lord.
list the matter on Friday in the fresh matters list. In the learned counsel for the petitioner submits 20 lakhs would be deposited on or before Friday. In the event it is not deposited, the petition would be dismissed without any indulgence.
Please.
20 ಬರುತ್ತೆ ತಗೊಳ್ಳಿ ಸದ್ಯಕ್ಕೆ.
Not to precipitate the.
ಮಾಡಲ್ಲ ಬಿಡಿ. What precipitation?
The house property is there, my lord. They will, house property is there. That's why, my lord.
ಏನ್ ಮಾಡ್ಬಿಡ್ತಾರೆ 3 ದಿವಸದಲ್ಲಿ?
They will come and.
Come and what?
Seize the, my lord. That's why.
Seize ಹೌಸಾ?
Yes, but the two house properties
ಏನ್
there.
ಮಾಡಬೇಡಿ Friday ವರೆಗೆ.
Not to precipitate.
Serial number 208.
Passed over serial 10.
10 ಪಾಸ್ ಓವರ್.
10 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ನೀವು ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲ ನಾವೇ ಕೇಳಿದ್ ಪಾಸ್ ಓವರ್ ಸೀನಿಯರ್.
ಅದಕ್ಕೆ ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂತಾನೆ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ದು.
Election matter, cooperative election matter.
ಇದು 27th ಇದು
184, my lord.
ಮಂಡೇ ಹಾಕೋಣ.
184, my lord. And submitting
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ಮಂಡೇ.
serial number 204.
ಪಾಸ್ ಓವರ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಮೇಡಮ್ ಪೋಸ್ಟ್ ನೇಮ್ ಆನ್ ಮಂಡೇ.
184, my lord.
ಅಲ್ಲ
my lord. 184 and submitting judgments, my lord, is allowed on that. That's caste verification matter, my lord.
ಕೊಡಿ ಕೊಡಿ.
Serial number 208, my lords.
206 by note.
ಇಲ್ಲ ಬೇರೆ ಎಲ್ಲ 27, 28.
ಇಲ್ಲ 208 may seek in a fresh matter list.
ಯಾವುದು? 27, 28 ಎಲ್ಲ both on. ನಿಮ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್ ಸರ್? ಗವರ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ಮಾ? 208.
208 for it is dictating orders, my lords. This is the matter pertains to without acquisition of a lands, my lord, the order to construct a government buildings including a court.
ಓ ಇದ ಕೋರ್ಟ್ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ.
Serial number 195.
ಲಕ್ಷ್ಮೀನಾರಾಯಣ್ ಸರ್ ಇನ್ನು ಬರ್ತಾ ಇದ್ದಾರಾ? ನಾಳೆನೂ ಬರ್ತಾ ಇರ್ತಾರಾ?
Serial number 195, my lords, there is some urgency, my lords. It may be listed in preliminary hearing.
Urgency.
My lords, that this is a part heard matter, my lords. Gayatri madam's matter.
ಯಾವ್ದು
It's a part heard matter,
21?
service matter. 195. It may be listed in preliminary hearing, my lords.
ಮೇಡಮ್ ಒಂದು ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ. You make a mention on that day. Lords.
It's listed on 27 or 28. That's fine.
ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ಗೊತ್ತಿಲ್ಲಲ್ಲ. Where is Gayatri? Is left you and left, is it? All right.
Lords,
Number 168, my lords, mayor.
There is some confusion, your lordship, when we had Mullimani's case, your lordship, extension of lecturers, your lordship. ಒಬ್ಬರಿಗೆ extension ತಗೊಂಡಿದ್ದಾರೆ. Another person has also came and taken the extension. There is
ಅಂದ್ರೆ ಇಬ್ಬಿಬ್ರು ಒಂದು ಅದು ಇವತ್ತಿದ್ಯಾ?
203 may be taken on fresh. 203, your lordship.
203 ಮಾತ್ರ ಥರ್ಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಇಲ್ಲ. ಇಬ್ಬಿಬ್ರು ಒಂದೇ ಪೋಸ್ಟ್ ತಗೊಂಡಿದ್ರೆ
My lords. 168, my lords, sorry. 168. 168, my lords. From month of January 24, salary has not been released by the response. I have filed an application, my lords.
20 interlocutory application ಇದೆಯಾ?
Please.
ಬರ್ಲಿ ಅದ್ ಮೇಲ್ ಬರುತ್ತೆ.
my lord.
208, my lord. May I seek in a fresh matter list? Sorry.
Yes.
Madam, 208.
Madam, serial number 5, Monday, ma. Pass over matters.
Past over matters, Monday, sir.
Please, my lord. ಆಯ್ತು madam. much obliged. recharge ಇರೋದಿಲ್ಲ 27, 28.